Well, we're about par for the course here. Our 10 o'clock meeting finds itself at 10:15 with three more. We need two more for a quorum, right? We have 8 members present. Mrs. Chick, Mr. Holden, Mr. Pacheco, Mr. Thomas, Mr. Savornich, Mr. Wax. Everybody here? Ms. Chick, Mr. Holden, Mr. Wax. right, members of the council, it's 10:20, and I think we are ready to begin. So let's begin by calling the roll.
Ferguson, Chick, Fuhrer, Galanter, Goldberg, Hernandez, Holden, Miskowski, Pacheco, Padilla, Ridley Thomas, Orange, Wax, Walters, Ferraro, 11 members present, and a quorum, Madam President.
Thank you. This is a special meeting of the Los Angeles City Council on Monday, September 18th, 2000. We have what looks like multiple items on the agenda, but they're all basically the same item. And so I think what we need to do is go through, and Mr. Deaton, you might start by explaining how you want to go through this book. Let me point out to you that we have 182 paragraphs in this book, but there are only 42 of them we really, truly have to discuss. And I will be keeping you updated on the score as we go through this. Okay, Mr. Deaton.
Madam President, members of the council, notwithstanding the number of them, I think that it would be appropriate to go paragraph by paragraph. Some paragraphs are common, and I will be recommending that you consider them at the same time. Even those issues that are not open, in some cases, are significant that they're changing the way we're doing business. They have cost implications, et cetera, and I think we at least should discuss them for a bit. Okay?
You have a number of cards from members of the public. I have 4 people who've asked to be heard on, well, it just says item 1. Then I have a card from the Police Protective League wanting to be heard on 4 different items. I assume those are items and not paragraph numbers. Yes, they are. And so the question I have for you is, in terms of, we have a challenge in front of us to try to keep track of where we are as we go through this document. And
I would, if I might, I would suggest that you have a public hearing at this point, and keep the public hearing open. Maybe, depending on how long this goes, it might be appropriate at some point midstream to have another public hearing, but at least have the initial public hearing right now.
I'm sorry, what was the last thing you said? I had 3
Just have the initial public hearing right now.
All right, and all right, item number 1, hold on. All right, now what's that one? Okay, so let's start off. This is, Ron, do you think we ought to have what we have on the agenda is item number 1 is the basic package that we're here to deal with, and items 2, 3, 4, and 5 are motions related to this. I have cards on each of those
I think in one way or another, all this is related to the same
So we might as
basic
well have a
issue.
single public hearing that
Right.
covers any or all of the items, so is
Absolutely.
everybody with us? And I'm going to go through all the cards I've got and acknowledge that some of you may wish to be heard later on with respect to specific points, and somehow you'll find a way to let me know that. So we're going to open the public hearing on all the items on today's agenda, and hear first from Commissioner Ozzie Gonzalez, then Don White, and Captain Richard Bonneau. Commissioner Gonzalez?
Good morning, Madam Chair, members of the council. I would just like to have a few comments about number 1, the number 1 item. I really wanted to be here to speak on this because I'm very, very frustrated and, in a sense, troubled on this issue that is before you. I'm concerned because I wonder if we really have looked at the message that is being sent. I'm concerned because to me it says, with our council, the police commission, the mayor, the chief of police. It's really, to me, sending a vote of no confidence. And I wonder if really this has been really thought through. We elect people to represent us. And when something like this happens, it's almost like pulling the rug out from under the leaders that we have chosen to represent us. And I'm sure all of you are much wiser, much more experienced than I am. But from what I see, I'm concerned about the message that is sending not only throughout the country, but the message it's sending to our citizens. It's almost saying to our citizens that the people that we have elected to represent us are incompetent. They're not capable of representing us. And that bothers me, because I'm concerned that the message that's being sent to, as I said, to the citizens, says that we have to look to someone else as soon as there's a problem. And as a citizen, I'm the first one to say, I admit we have a problem. LAPD has a problem. But is it fair, as soon as we have a problem, to feel that we have to bring someone else to handle the problem?
Okay, thank you.
Thank you.
I don't think we brought them. I think they came. Don White, followed by Captain Richard Bonneau, and then Ted Hunt or Hank Hernandez or whomever. Go ahead.
Thank you very much, members of the council. My name is Don White. I'm a 34-year veteran teacher with the Los Angeles Unified School District, now retired, and I too am concerned about the message that is sent. I'm concerned about the message that is sent to the youth of this community when evidence planting, perjury, violence against handcuffed detained people goes with impunity for several years in our community. I am here to speak for item number 4. It's the motion by Wax, Goldberg, and Chick. I believe that this is a legitimate time for the city to have independent, fully authorized, independent review and approval of the specific policies, procedures, and the sections needed to implement real reform. I won't go through item 4, but I fully support it. It seems to me that the community now is calling for this kind of independent review. We've had community meetings in which a litany of recommendations, and actually a litany of horror stories in the ramparts and other divisions, a litany of recommendations from the community that a completely independent and fully authorized independent source come into the community and help us at this critical time. I might say also that the procedures of LAPD during the Democratic National Committee Convention need to be reviewed, where civilians protesting, invoking First Amendment rights were shot between the eyes with rubber bullets. We have a young man who is not here today, Rich, who was shot twice, bleeding wounds at chest and abdomen, fully caught off guard without warning that he was going to be
All right,
shot.
Mr. White,
Yes.
we're trying to focus on
Focus.
the items that are before us today.
Okay, even though I believe that is a germane comment, I will move ahead to my final comments
Please.
around this. Right. The recommendations contained in Professor Erwin Chemerinsky's analysis need to be addressed. There needs to be a complete and independent review of this total situation that affects not only Ramparts, but the entire department. Only with that kind of very credible, independent overview, I think embodied in the motion by Wax, Goldberg, and Chick, only with that can we return the kind of confidence to the community, particularly among young people with whom I'm in close contact. Only with this kind of independent review can we return the credibility that our police department really needs in the city. Thank
Okay,
you.
thank you. Captain Bonneau. Just in case anybody excuse me one second, in case people have filled out cards for different items, what I've done is to put all of the cards together. Please feel free to speak on any of the 5 items. This is the public hearing, plus whatever we have to do later for all of those items. Go ahead.
Good morning, Madam President. I'm here representing the Los Angeles Police Command Officers Association, and I'm here to voice opposition to any agreement that we may reach with the federal government which would take control of the management of the police department out of the hands of local officials. Police power is delegated to the states. The men and women that are in this room and the men and women who I represent on the Los Angeles Police Command Officers are chartered with the responsibility of managing the police department. We can bring about any reform that's needed. We're perfectly capable of doing that. And to relinquish that kind of authority to an outside agency, I don't believe would be in the best interests of the people that live and do business in the city of Los Angeles. One particular item that I'd like to voice opposition to specifically is the issue of having police officers collect data to prove or disprove a practice of racial profiling. Based on my experience of almost 30 years, I believe that what this will do, if we ask officers to do this, is put police officers in positions where they are at odds with people over ethnic issues, and it will cause exactly the opposite result that we're trying to accomplish by collecting this data in the first place. Thank you for your time.
Thank you. Mr. Hunt or Mr. Hernandez from the Police Protective League, followed by Cynthia Anderson Barker, James Lafferty, both representing the same organization, Candido Morez, Kay Brown, and some more. Go ahead, Mr. Hunt.
This is perhaps the most significant issue that will be decided in the early part of this century. From the Police Protective League's point of view, we want reform. We understand the need for it. However, we must understand that this is a major commitment. We need to have a consensus of all of the stakeholders before we enter into a consent decree. I got some real problems with the documents that I've received, and that is, for example, 4 pages were missing. Items number 148 through 161, we don't even know what's there. We have not been met with, nor have we been bargained with, on issues that directly affect rank-and-file police officers. The way we see this situation right now, there is going to be a dramatic effect on the ability of rank-and-file police officers, the cops in the blue suit, the people that answer radio calls, the people that go out and deliver that service that taxpayers are paying for. There's going to be some significant inhibitors on their ability to provide services. We are not against reform. We just believe that the public and the Police Protective League that represents the officers, the 2 most affected people, should be heard on this, and we should have been heard a long time ago. And as I said last time I was here, we're going to need more than 1 session and 1 public hearing. Thank you very much.
Thank you.
Mr. Holden, we are for what is best for the people of Los Angeles and what's best for the rank-and-file police officers.
All right, Mr. Holden, don't get in an argument
That's
with him.
why
This
we've
is
gotta
his
discuss it.
time. All right, Cynthia Anderson Barker, followed by James Lafferty.
Good morning. My name is Cynthia Anderson Barker, and I work with the National Lawyers Guild and the Coalition for Police Accountability. I'm here to speak in support of item 4, the Wax, Goldberg, and Chick motion, and particularly under item 4, section D, which would endorse the creation of a special prosecutor in the State Attorney General's office by formal request to the State Attorney General's office. I'll talk a little bit about why we need a special prosecutor in the AG's office. I do police misconduct litigation day in and day out. I see the cases where the police have abused people's civil and human rights, and judgments are often awarded, or we enter into settlement. We need a special prosecutor in the State Attorney General's office because there's currently a conflict of interest with the district attorney. The district attorney uses police officers as witnesses to prosecute criminal cases. As a result, there is no incentive, and there is a clear conflict of interest. Why would the DA then turn around and go after police officers for misconduct?
Excuse me for interrupting you, but the
Yes.
problem is, we on the city council have no jurisdiction
No, I
over what the
understand
state
that.
attorney general's office
You know, I know
does.
that, but...
I know you do.
Certainly, Ms. Goldberg and Mr. Wax and Ms. Chick have in their motion that request that the council endorse
Okay.
a resolution.
Fair enough.
Let me just talk about why there's such a need. During the Democratic Convention, we trained 200 legal observers and 60 lawyers. They were out on the street every day observing the police and documenting instances of misconduct. We have over 100 pieces of evidence on file. We're currently formulating a large class action civil lawsuit on the abuse of people's rights. People were shot with rubber bullets, they were clubbed. I clearly know in the press there's been a big PR campaign about how wonderful the police were during the convention, but there were serious problems and they're going to have to be addressed. If we have a special prosecutor and the council goes on record supporting the creation of such an office, there will be less incentive for the police to act in this way. We won't have to be suing the police civilly for damages. We'll actually have an office of the state that prosecutes police when they abuse civil and human rights. So this is why I'm supporting this motion. Thank you.
Thank you. Mr. Lafferty, followed by Candido Mares, and then Kay Brown and Michael Benefield. And then we'll go to Mr. Chemerinsky.
Yes. I think, I'm Jim Lafferty, the Executive Director of the National Lawyers Guild in Los Angeles. I think I can be brief. Cynthia Anderson said much of what I wanted to say. The Lawyers Guild does indeed endorse item 4, the motion of Councilwoman Goldberg and others. And of course, as Cynthia Anderson has just pointed out, there is a particular need for a special prosecutor, quite apart from any consent decree that the city may enter into, because as we did just see during the Democratic Party convention, the LAPD ran roughshod over the rights of protesters. Indeed, 2 federal courts, 2 independent judges on 2 federal courts have already ruled against the behavior of the LAPD during the Democratic National Convention. The lawsuit that Cynthia Anderson Barker refers to will indeed result in more liability to the city of Los Angeles. It's a class action lawsuit on behalf of those shot with rubber bullets, on behalf of those who were prevented from attending a demonstration contrary to the law, and so forth. So please go beyond the consent decree, understand the merits of having a special prosecutor so that finally, after years and years, the LAPD can be reined in and this city council can stop spending millions of taxpayer dollars in order to correct the misdeeds of its own police department.
Mr. Holden, this is the public hearing. He's entitled to say whatever he wants. What's your point of
Take their
order?
lawsuits in the courtroom, not at this forum.
Mr. Holden, that's out of order.
We like what the
Mr.
police did during the
Please sit down,
convention.
Mr. Holden. Mr. Moraes.
I like it. You were
Please sit
protesting.
down.
Thank you, Madam President. I thank you for giving... Thank you, Madam President, council members. I want to thank you for giving me this opportunity, and I promise this will be the last time you hear from me. But I want to address something this young lady said behind me, that you had 100 observers out there? 200. 200. Can I get those same 200 to come to the areas where the gang members are taking over the city? Can we get those 200? Can you give me your commitment right now that those same 200 will go out and help us turn these communities around?
Many of them are already
Wonderful.
Wait
Wait a
Wait a minute. You guys are not, will you, just stop,
I
please.
promise to stay with my last comments, and then I will sit down. Thank you. But I'm still against this consent decree because I believe the leadership is here within the city. But I want to remind each and every one of you that each one of you took when you took this office. And it says, I do solemnly swear that I will support the Constitution of the United States and the Constitution of the State of California and the Charter of the City of Los Angeles, and that I will faithfully discharge the duties of the office of councilperson according to the best of my abilities. And if you feel that this is what you're going to be doing by turning over your abilities to the federal government, then I have nothing else to say. Thank you.
Thank you. Kay Brown, followed by Michael Benefield.
Good morning, and thank you for the opportunity to speak.
Pull the mic down, you'll be much more comfortable.
Actually, if I could do something like Barbara Boxer and carry one of
We don't have one handy, but
Okay. I'm here to speak on my behalf, although I am a member of a number of organizations. I was trained at the Loyola Law School for observing, and I must say it was a very interesting training. Told me a lot about what my civil rights are and what others' civil rights are. But during the time that we had, and I was there to observe, not confront the LAPD, I was confronted. I was denied any of the training questions that I had to answer, to ask, that the police were asked to answer. I was stonewalled, I was pushed aside, and at the end, the last of the observation marches that I was in, they actually pushed me out of their way because I wasn't going fast enough. And I was at the end observing. I think that we don't have citizen participation in a citizens organization like the LAPD. And we have to have, through our elected officials, some responsible action. I want to encourage the City Council to please support 4, but maybe go beyond. Maybe like the last gentleman said, he doesn't want a consent decree. Well, maybe we should go to court. I think sometimes the public is kept from knowing what actually happens when we have settlements out of court and consent decrees. The LAPD is already under a consent decree. They've been under one for many years on their hiring practices. So I don't see what people are so afraid of. What I'm afraid of is that it's going to get swept under the rug again, and we're going to have more disruption. And I hope that each of you will vigorously support 4. Thank you.
Thank you. Mr. Benefield.
My name is Michael Benefield. I'm a registered mechanical engineer in the state of California. I was one of the 71 bicyclists who were arrested at the Democratic National Convention. We broke no laws. In fact, we had an LAPD escort that was with us during the entire ride until the end, when the nature of the escort changed to a very predatory thing and threw us all in jail. We spent 2 days and 2 nights in the LA County Jail. And at the end of our ordeal, the city attorney dropped all charges against all of us because there was no evidence. I believe that we were held for those 2 days during the remainder of the Democratic National Convention to prevent us from exercising our First Amendment rights to free speech and assembly. The LAPD is out of control. Now, about the consent decree. I'm torn on this issue, actually. There are 2 ways to look at it, I see. One, accepting the consent decree will bring the possibility of real reform at a minimal cost, and is probably the fiscally responsible thing to do. However, on the other hand, a lawsuit by the Justice Department would please me in that it would be more likely to uncover the true and real depth of misconduct and corruption that is in the LAPD. I'd like to call for an immediate investigation into the misconduct and abuses of the LAPD during the Democratic National Convention. Thank you.
Thank you. That's all, all the cards I have at the moment. So we're going to turn now to our resident commentator who is out there, Professor Erwin Chemerinsky. We got one more card. Go ahead, Erwin. We'll come back to the rest of the public hearing later.
Thank you. Good morning. It's always a pleasure to appear before you. I came this morning to urge you to approve the consent decree with relatively few modifications. Overall, the consent decree is an excellent document. It will bring about many long-needed reforms of the police department. Now, I don't believe that the consent decree goes far enough. There's many things that I wish had been included that are not there. There's not nearly enough with regard to protection of whistleblowers. There's nothing with regard to creating civilian oversight of internal affairs. There's not enough about restoring community policing. There's not enough about aggressive recruitment of women and minorities and gays and lesbians. But I fear if you were to open up the consent decree for these and other items, a very fragile consensus is likely to collapse. Moreover, I don't think it's necessary that you put these items in the consent decree to make them come about. All of these items that I just mentioned are within the power of the council and the police commission to do, even without putting them in the consent decree. So I would urge you to take 4 steps with regard to police reform. First, resolve the open issues and approve the consent decree. I don't think the issue of the monitor should be a difficult one. As in other cities, simply specify that the monitor makes regular reports to the Justice Department, to the City Council, to the Police Commission, and to the Mayor. And of course, it would be the monitor who would then inform the Justice Department, which would be responsible for going back into court. The monitor wouldn't have the authority to go to court. This is not an external takeover of the Police Department. The Police Commission would still be managing the department, but you have to manage it in accord with the dictates of the consent decree and the monitor to see whether that's happening. Likewise, I think the Justice Department's recommendations with regard to standards for the police department's interaction with the mentally ill, with regard to collecting information with regard to racial profiling, are necessary and should not be difficult to approve. The second step, I believe, is once you've approved the consent decree, you need then to pursue other reforms of the police department, such as the ones I mentioned, such as many that I presented in the report last week, more protection for whistleblowers, more civilian oversight for internal affairs, and so on. You can do these on your own. The Police Commission can do them without putting them in the consent decree, and you shouldn't regard the consent decree as the end of police reform, just the beginning. Third, I think you're going to need to consider charter changes with regard to aspects of things that are not in the consent decree. The Justice Department, as you know, takes the position that they cannot modify the charter with regard to a consent decree, nor can the consent decree override the charter. Now, I feel a bit sheepish coming before you and arguing that there's a need for charter changes, but we've learned a lot since charter reform. And I think some things like creating a full-time paid police commission, strengthening the inspector general, and others, including changing the police disciplinary system, will require charter changes, and so I urge you to do that. The fourth and final step is I think you, the City Council, on behalf of the City of Los Angeles, need to work with other agencies in Los Angeles County to study the entire criminal justice system. We do need to look at the courts, we do need to look at the prosecutors, we need to look at the defense attorneys. This is beyond your direct jurisdiction, but you must do it with the other agencies, it's the County Board of Supervisors, Los Angeles Superior Court, the District Attorney's Office, and the Public Defender's Office. So I'm here to urge you to take the necessary first step, but please, after you've done this, don't declare victory over problems in the police department. The consent decree is just the beginning.
Thank you. Are you going to stick around for a while in case we have questions?
I teach class at 11:30, so
All
I
right.
have to leave at 11.
I think that's what they pay you for. You probably need to go do that.
It is. Thank you.
Thank you for coming. All right, we do have one more card, and so this is going to be the last card before we start in on the blow by blow, paragraph by paragraph. Elizabeth McClellan from the Empowerment Congress. And Ms. McClellan, let me ask you please to be brief if you can so that we can get started on our full day's work. Thank you. Good morning.
Thank you, Ms. Chicks. Good morning to every one of you, the City Council. I'm here today, and I'm looking at this group that's representing and pro and con on this issue, and I don't see the real people being represented. So I represent the real people, the people who are going to be the most impacted by this decision. First of all, I do agree that there should be the consent decree. I'm for it. But the second of all, it must be, the spirit of it must be there. And it is a fundamental issue. It's nothing that we need to have great legal contact on. It's a fundamental issue of a problem that has been going on for many years. And the African American community has been trying to tell you that we have some deep problem with LAPD. And for all this time, it's been ignored or already pushed under the rug. Now, let me tell you what I know, because I keep up with things. I try as best as I can with my little finite knowledge. You told us that we had a new reform city council, city charter, because the one that we had was 72 years old or something. and you sold that to the people on the ballot as a way of reforming city government that was going to be more responsive, more accountable to its constituency. And so the poor folk who didn't understand a word it said voted yes, and now it's on there. You told us that we would have a new Department of Empowerment of neighborhood councils to oversee the neighborhoods so that citizens would have more participation in their government, and especially in the future of Los Angeles. So here we are in the present with a big, huge problem that the people who promised us better reform government don't know what to do with. And that is a sad state of affairs. Fundamentally, we have a problem. In your heart of hearts, this is the time for you to search it. It's not the time for us to debate. This is the time for the city council, for the mayor, for all the governors of Los Angeles to take a serious look at yourself and your jobs and what you promised us and work for the people. And that's all I have to say. Thank you.
Thank you, Ms. McClellan. Okay. We are now going to return to Mr. Deaton and try to begin working our way through this document.
Stated before, we'll talk about by paragraphs and Roman numeral 1, the paragraphs 1 through 8 and 10 through 11 and 13 through 14 have to do with a consent decree, and I would suggest we hold that to the end of the discussion.
Okay.
And we'll handle that with the discussion on the independent monitor and the overall 1 through 8, 10 through 11, and 13 through 14.
All right, so that means we start with 9?
Right.
Okay.
9 is a provision for, it states that nothing in this agreement is intended to alter the existing collective bargaining agreements, and I think that there's should be a discussion about, just a general discussion at least, about meet and confer, and I think I'll let Mr. Hahn.
Without getting into all the details, and I know this council has been through many meet and confer issues with bargaining units, there are a number of items that are in this proposed agreement before you that will necessitate a discussion with the bargaining unit for LAPD employees in the city of Los Angeles. Obviously, nothing in here is meant to impair those agreements or impair rights under state law. We will, hopefully, if we do get direction from the council at the end of this session, begin to give those documents to the bargaining units for LAPD so that they can have a chance to look at them, and then as we go further, we will enter into a formal meet and confer process. But anything more than that I don't think needs to be discussed at this time, except to acknowledge that the issue exists, that there are many things here that cannot be done without discussing it with the employee bargaining units.
Why don't you just describe for us, one or more of you, what happens if, just so everybody's clear, the council's going to go through these and discuss them. That's not the end of the process in any case. So in this case, anything we agree to doesn't become, even if we and the Justice Department reach agreement, does not take effect until we've had the meet and confer process and done our collective bargain. Is that right?
If the issue is one that the bargaining unit believes should be subject to meet and confer, and then of course then that process would go forward. If we're not able to reach resolution, going to fact finding, those kinds of issues would be part of the agreement. But you're right, anything that would affect the working conditions of the men and women of LAPD that they believe should be subject to meet and confer under state law does not take effect without going through that process.
But that does not in itself delay anything that's not subject to meet and confer taking effect.
Correct.
Okay, thank you. Okay?
Paragraph 12, I'm just pointing out paragraph 12, excuse me.
Hold on, Ms. Goldberg. Oh, I've got 4 people who want to talk on this one, sorry.
I just have a question. I don't really want to talk on it. You have a consent decree. It says we're going to do X. The league says that needs to be bargained. We agree. We have a discussion and have negotiations, and the city and the league agree to something, but it's different than what's in the consent decree. What happens?
Well, in that regard, we bring it back to the Department of Justice, see if we get them to agree.
I just want to know what the process is, because that could happen. We could all come to a conclusion that says, oh, yeah, that makes a lot of sense, we should just do this, and then, but we'd have to then go and get approval.
And we have discussed that possibility with DOJ before.
Okay.
Mr. Hernandez.
A lot of these issues are going to be dealing with the investigation of potential police misconduct issues. And in what those issues might be and how they're defined have been questions that have come up in previous bargaining negotiations. What you're saying today is that if those kinds of questions come up, then we're going to have to reach agreement with the unions first and then get Justice Department to understand it? And I'm going back to Christopher Commission reform issues that we were trying to deal with that had to go through the meet and confirm process that basically we weren't able to reach agreement on, and then for some reason were never implemented.
We think that we have a framework that provides the opportunity for the bargaining units to participate meaningfully here. We, of course, want to negotiate in good faith, but we think that what's being proposed by DOJ and responded to by the city is something that we should be able to reach agreement with. We think if we honestly sit down and roll up our sleeves in good faith negotiations, we should be able to resolve these issues. And as Councilmember Goldberg pointed out, if the city and the LAPD bargaining units reach some different language, the Department of Justice understand that that's possible. But we are going to try to, as much as possible, reach agreement on each one of these subject areas, and that's going to include, how officers are evaluated, how the discipline system works, and how it's evaluated. Those are certainly things that we want to get the input from the LAPD bargaining units on.
Mr. Holden.
Well, I'm not going to stand here and say the police department is perfect. I can tell you, try to live without them. For those who cross the line as police officers, yes, they should be held accountable for their action, and yes, there should be a system in place in order to notify the public that they've just done that. And I mean, you can't do any more than fire them, and that's what the chief has done. The thing that I'm troubled by is that every time some of you around here get a hot foot, you want a charter change. You panic. And really what you change to is almost like term limits. You panic. You think you're being responsive to the people. What you're doing is making it more difficult to govern. And then when you govern, after the changes are implemented, people are not served. They don't get what they anticipate. Better respect. Better community representation as they promised you. That same Chemerinsky.
The topic is paragraph 9, collective bargaining.
The problem is me.
No, that's not the problem. I didn't say that, Nate, but you may have.
You always say that. You always say that.
No, I'm just reminding you what the agenda item you're talking about is. I know, but I'm going to make
a general statement because that's what I want to say, and that's why I'm your problem. This letter was sent to James Kenneth Hahn on May 8th from the Justice Department. The same Justice Department that filed 50 charges against Dr. Lee, dropped 49, and let him out of jail, put him in solitary confinement. That's the Justice Department.
Okay, Mr. Holden, comment on the item. This is not a free 3 minutes. This is 3 minutes to talk about paragraph 9. Nothing in this agreement is intended to alter the existing collective bargaining agreement.
It's all relative. I just met with the Justice Department, and they said they are not ready. So why are you pushing the panic button here?
I'm just trying to move the meeting along.
Well, you want to move the meeting. I'm going to give you exactly what they said. If you want to hear it now, you want to hear it later.
Can you do it in 54 seconds?
Well, you should add some time to that because you kept interrupting me.
I guess not.
The fact of the matter is this. I showed them the letter that Mr. Lee sent to Jimmy Hahn back in May 8th, which they were not aware of it. That's the Office of Intergovernmental Affairs, the director. He said, I said, it's a threat. You do what we want you to do, or else we're going to file a lawsuit. Nothing about we're going to negotiate in fairness to make sure that the city of Los Angeles get what they do. protection of law enforcement officers who abide
Mr.
by the
Holden,
rules?
Mr. Holden, excuse me, but if I may suggest, the time for you to make that speech is when we get to the first few paragraphs on whether or not to have a consent decree.
Then
This
put-
is about paragraph 9.
All right, then put me
I'll
first.
call on you when we get to those
Put
paragraphs.
me first in the list so I can
I'll
sign
let
off.
you know to push your button, and if you get there first, you'll be first.
right.
Mr. Padilla.
Because these guys in the
Mr.
Justice
Padilla,
Department are not
sit
happy
down,
with what
please.
you guys are doing.
Mr. Padilla.
Thank you, Madam President. I just rise to move the City Attorney's recommendation to forward copies of the relevant documents to the Police Protective League for review and offer them an
I'm
opportunity
sorry,
to
you'll have
respond.
to say that again because I can't do both of these at once. You're moving what?
The City Attorney's recommendation to forward the documents to the Police Protective League for review and provide them an opportunity to respond.
Okay, is that the recommendation under paragraph 9?
That'd be fine.
Okay.
On the recommendation.
Anybody have any objections to Mr. Padilla's motion? All right, then just we'll hold that motion on the desk for the moment. Mr. Fewer is next. Pass. Mrs. Walters is next. Thank you.
Yes, with respect to paragraph 9, that states that nothing in this agreement is intended to alter the existing collective bargaining agreements. It seems to me, if memory serves, and what I'm about to say, if I'm in error, I hope Mr. Deaton will correct me. As I recall, after the Christopher Commission, there was an issue that had to be part of a collective bargaining agreement involving the 402 process. And the bargaining unit would not agree to that, and so we agreed to something less than what the Christopher Commission had recommended. Is that correct?
I don't recall.
Well-
I can find,
All right, the reason I raised that issue is to find out which agreement takes precedence here. It would seem to me that the consent decree ought to take precedence. If the bargaining unit can come along and undermine the consent decree through its bargaining process and saying that they will not do this, that, or the other, then we are right back where we started. And that I find very, very troubling.
I believe that we have to follow both federal law and state law, and I think and the situation is that we do have a responsibility to meet and confer in good faith with the bargaining units on this aspects of this document that relate to working conditions. I believe that at the end of that day, as Mr. Hahn says, that we will be at a point where we'll have major reform, and I think that the situation is different than it was at Christopher because of the consent decree. I think there's a factor here that but we need to work through the collective bargaining process.
Does that mean, then, that some of the things that we would agree to in the consent decree would not be binding on the bargaining unit if they raise objections?
I think it means that we have to go through a process of good faith discussions with them and meet and confer before anything can be implemented. That does not mean that they can they do not have total veto in that process. We have to have, but we are required to have good faith bargaining with them under state law, and Justice knows that, and we have to work through that process in order to get to completion of this.
Well, I recognize that we're required to do that, and I certainly don't object to bargaining on issues, collective bargaining, but this, to me, seems to transcend that process, the need to make these corrections, and knowing how resistant the bargaining unit has been in the past to change, I'm concerned as to whether, after all this effort, that they will be able to come along and subvert it one more time.
It's going to be a challenge to all of us, them and us and Justice and everybody else. Mr. Hernandez. At this rate, by the way, remember, we have 182 paragraphs.
Madam Chair, I just rose to amend a motion made by Mr. Padilla. Hopefully it's a friendly amendment to include all bargaining units that have to go through the meet and confer process. because his motion indicated the Police Protective League only.
Okay, Mr. Padilla.
Yes, that's fine. Thank you for that clarification. And I also wanted to respond to some of Councilmember Walters' concerns. I think the meet and confer process with the respective bargaining units aren't meant to undermine the proposed agreement, but rather to share the information for necessary input. And also because the employee organizations are going to be critical to communicating back to the department as a whole how, if at all, in any significant way, this is going to impact how the men and women of the department do their jobs. Getting that message out to the people on the streets or at the desks is going to be very important in final reform implementation. So that, I believe, is the purpose of these dialogues.
Okay, quick. Nobody
Right.
else wants to speak.
Fine.
All right, so we're done with item 9 now,
Right.
is that correct?
And
Okay. Next.
I'll take a different approach on 12. I'll just
Yes, let me
mention-
just point out that although lunch will be provided, dinner will not be. So please keep that in mind as
And
we move
no
forward.
overnight stays. On 12, I just wanted to point out, city means mayor and city council, and you are responsible. And moving on to the definitions, I think all the definitions have been agreed to. I think it's instructive that supervisor is sergeant and above, manager is captain and above, city means the mayor and the city council, LAPD is the chief in the department, and the police commission is the police commission, inspector general is the inspector general. And that leaves us to go to paragraph 28, which is the major open item in item number, Roman numeral number 1. And basically gets down to a definition of what is categorical use of force. And the team did not want to include head strikes and skeletal fractures in the categorical use of force, primarily because it requires, under other provisions in the agreement, for a rollout of the new OHB investigative team. Regardless, we wanted to say that if it required hospitalization, that then the team would be rolled out. Short of that, it should be not that it should not be investigated, but it would be investigated under the under the regular order of
The ordinary procedures,
rank and
yeah.
file.
All right, just because we do have people listening to this and in the audience who may not be familiar with all the abbreviations, OHB is the Operation Headquarters Bureau and refers to a special investigative team for particular.
Right. We also, in addition to that, suggested that there would be a special audit of those to make sure that they were being complied with, and follow up by the Inspector General and the Internal Affairs.
Okay, ready? Ms. Goldberg.
Yes, I'm looking at some of my colleagues' data, and I think that there's something between requiring hospitalization and not looking at them at all. And I would think as to both skeletal fractures and head strikes with an impact weapon, if we said for which medical treatment is obtained instead of hospitalization, that broadens it, but it doesn't mean anything like the example was used, a broken finger, or something like that might not even be discovered until a person was out of custody. But I think that if it requires medical attention, I'm sorry.
But it would require medical treatment, so you
Yeah, but they wouldn't know about it while they were in custody, so, I'm just saying, I think if it requires medical treatment, we ought to have someone in OHB look at it. So I would move that we, on paragraph 28, that we don't require all head strikes and all skeletal fractures, but uses of force that result in skeletal fractures for which medical treatment is obtained, or head strikes with an impact weapon for which medical treatment is necessary.
The difficulty is that under those circumstances, the unit would have to be rolled out 24 hours a day under our other provisions.
Yeah,
And
Jackie, I think the difference is not whether somebody in the police department investigates the situation, but whether a special team is sent to the scene because of the unusual severity of it. And so the
Exactly.
cutoff they're looking for is whether to make this 24-hour rollout available, which begins to put a lot more personnel in.
Well, I think the concern I have, to just say why I would like medical treatment, is because it's a decision whether to take someone to a hospital or not as well.
Okay.
And if you know, and you're not one of the good guys, you're one of the folks we're worried about, and you know that taking them to the hospital will have X result, but just getting the medical treatment, not taking them to the hospital, result in Y, I don't want to put in the hands of the person who may be actually a problem the fact that, I'll do it the other way. I'll take them in, and then we'll just get some medic to come in and take a look at them. I mean, obviously, there are cases where there's no choice. You have to take them to the hospital. But there are a lot of gray areas, and that's why I'm looking for something that deals with the gray area, but doesn't say every time anybody has any of these things happen to them.
Okay, let me just ask you, as a matter of how we proceed here.
Right. I would like to suggest that, first off, that maybe the chief explain the process, that when someone comes in, who looks at them, what happens, and where they go.
Okay, but I have 4 more council members who want to be heard.
But it might still be helpful to do that before.
You want to do that first?
Yeah.
Chief.
Well, first of all, the decision to hospitalize is a doctor's decision, is not a police officer decision. We have very well-defined procedures for officers when a suspect or a citizen is injured, requires taking that person before a doctor. Then the doctor has a protocol. Right now, the cutoff is if someone is hospitalized for any injury, whether it be a skeletal fracture or a head strike or any other type of injury, is the cutoff point at which we roll people out. If we have a rollout team, then they would roll more often at a greater expense to the city for these, although undefined and perhaps unknown at this exact moment, how many additional types of reports they would take. But those reports are currently cared for in 2 manners. First of all, if the citizen has a complaint, of course, IED is involved immediately. Or if there is a use of force, then that report is taken by a sergeant, reviewed by a lieutenant captain up to and including the bureau chief, and then later on reviewed at headquarters at Human Resources Bureau. So, and the watch commander, of course, based on our rules, has to look visibly at the arrestee and approve either the booking or the taking to the hospital. And by the way, it's not a medic; they're taken before licensed physicians in all cases.
And how fast does it happen in the absence of how fast is this review?
Medical treatment and the review by the watch commander always comes first if you're reviewing how fast they receive medical attention.
Yeah, and that would be like within...
Well, it's difficult putting hours, but it comes before the reports or anything else, so
Okay.
hopefully that would be within a few minutes to an hour or less.
Okay, good, thank you. Mrs. Chick?
Yes, Chief, so are you saying that in terms of skeletal fractures and head strikes with an impact weapon that require hospitalization right now require the rollout team?
That's correct, and just for information, the protocol from our city doctors is that whenever a skeletal fracture, that is usually a hospitalization.
Okay, and then our president asked a question I just want to take a little further. So if we're saying it's hospitalization that triggers the rollout team, in terms of timing, is everyone staying on the scene until this hospitalization issue is decided? How does that play out?
Well, unfortunately, it's not as precise in this venue as it is when it's an officer-involved shooting, when everyone knows. Frequently, the injuries are discovered somewhat later in the type of situation you're describing. So it may well be that even in most cases, that the officers and the witnesses have cleared the scene before we determine there's a need for hospitalization. Then we have to go back and reconstruct. That's quite a burden, especially on those lower level injuries when there's it's not immediately apparent that hospitalization will be required.
Right, and that would occur if we went with the recommendation that Councilmember Goldberg just suggested of, if it requires medical treatment, which is even a lower possible level than hospitalization, it's still going to require reconstruction of the incident rather than having the rollout team arrive in time for everyone to play it out very close to the actual time.
If I understand the question correctly, we'll have more rollouts under what is being suggested. And as a matter of course, it will be more difficult to reconstruct those because the on-scene supervisor, who currently is the person who immediately leaps in the middle of things and does the investigation, will now stand by or start the investigation and stop the investigation and wait for the rollout team to get there, who will then have to reconstruct everything.
Okay, thank you.
Mr. Fuhr.
Thank you, Madam President. I have a procedural question and a substantive one. Procedurally, I think we glossed over some issues that are embedded in item 12. After we conclude this, may we return to item 12 briefly to go through those issues? All right. So
Well, because we're in the middle of 28 right now.
I know, I'm
Let's
just saying
finish
is
28, and then we'll go
once we
back to
conclude-
12.
That's what I was asking.
And also, I'm
Secondly-
trying to clarify Mr. Padilla's motion for relevant to item 9 to make sure we
All right.
have that covered.
So after we'll come back to item 12.
Okay,
But
go
regarding
ahead.
this issue, I want to be sure I understand the distinction between what Mr. Hahn is recommending in the letter that he submitted to us and the current practices of the department on the one hand versus what DOJ is asking on the other hand. Now, here's what I think of the situation. Please correct me if I'm wrong. The department currently rolls out for when there are incidents that require hospitalization, period.
Correct.
Or it doesn't matter what the nature of the injury is, if you go to the hospital, rollout happens. Now, I think, and I understand Mr. Hahn's recommendation to be that that's fine, but add to that a heightened level of attention when even medical attention short of hospitalization is required when there's a head strike involved. Is that correct, Mr. Hahn?
That's correct.
All right, so the spectrum of recommendations would be Ms. Goldberg's, whenever there's medical attention required, roll out. Then there's the current practice, whenever there's medical attention required in a hospital, roll out. Then there's Mr. Hahn's recommendation, kind of in between the two, whenever there's hospitalization, we roll out, but when there's medical attention only for head injuries, we roll out. But medical attention short of going to a hospital would not lead to rollout under your, if it's for anything other than a head injury.
Right, and I suggested that the city should audit that after a reasonable period of time to see whether or not we need to add that category in. Right now, according to Chief Pomeroy, what I just heard is we still don't know how many incidents that involves, and so without committing the city to an inordinate amount of rollouts when they may not be necessary, I suggested that we should agree to audit the category of skeletal fractures resulting in medical treatment after a reasonable period of time to see if we should change that procedure.
Okay, now, given that understanding, I'm prepared to move Mr. Hahn's recommendation, which I think strikes an appropriate balance here, and I think it's important for us not to unduly burden the department on the one hand because otherwise, if we do that, we'll end up with lower quality rollouts and investigations on the things that really rise to the level of importance. And Mr. Hahn, I think, when it comes to head injuries, has it right, because those are always very touchy situations and suggest a gravity of situation that ought to give rise to heightened scrutiny.
Okay. Ms. Goldberg seconds and withdraws her motion, and we'll go now to Mr. Hernandez. Just before we do, let me mention the reason we went on from item 12 is nobody appeared on the speaker queue. So, okay, Mr. Hernandez on 28.
I'm not sure, when do we roll out an investigation team now?
For a matter of injury without a weapon, without a firearm being involved, it would be for any time an individual is hospitalized.
So now we roll out a team anytime an individual's hospitalized.
Right.
Some of the issues that came up or have come up because of the Rampart incident was issues of someone being shot and individuals basically figuring out what should be, the allegations are at least, how do we deal with this issue, and then managerial supervision showing up after the facts have been established by the people who were at the scene so that there wouldn't be any questions. And then there wasn't any questions. So this particular issue that we're looking at right now wouldn't affect that. Is that correct?
That's correct. We would continue to roll on all officer-involved shootings immediately.
But immediately is when it's heard on the radio, or is it when you're called in to do that?
We're called in. We have an affirmative responsibility for supervisors at scene to notify their chain of command anytime an officer discharges his weapon in the course of duty. And that information is immediately relayed to the investigators who roll.
Okay. Now, and when you roll out, how many investigators do you roll out?
Well, it depends on the type of circumstance. Anytime an officer discharges his weapon, for example, and strikes a suspect, that would include at least one deputy chief, perhaps two, a commander or two, a captain, and then a lieutenant with an investigative team of not less than 6 officers and sometimes more.
Now, I'm asking, see, I just had an incident in my district on Friday in Cypress Park, and I asked Harry for some information because it happened a block from my house. And I thought I should know about someone who was shot allegedly because he pointed a gun, and it impacted the whole neighborhood. Everybody's aware of it, except this council member couldn't get any information from the police department. Was there a rollout team there?
Yes, there was.
And it arrived sometime, because I know that it was yellowed off and cornered off at 9 o'clock in the morning, but it happened around midnight. So there was an investigation going on at all that time.
Well, I don't know what you mean by all that time. We have a goal of responding in 1 hour, and the team was there fairly quickly that evening.
And when would there be some kind of informal report issued to the chief?
The chief? Chief of police? The chief was called the next morning. Standard practice is the on-scene investigator always calls the chief in the morning for those incidents when the chief is not there.
And on the average, how many of those kinds of incidents does the chief get? Is there any review of that?
Well, there will probably be 45 such incidents during this calendar year. Does that answer your question?
45 such incidents during this calendar year?
Yes.
Does that mean, well, I guess I'm trying to find out from a procedure process, what are we talking about a change here? Is this one where we're going to have a lot of people involved as part of these rollout teams, a lot of investigators available on a 24-hour basis that will be responding? Or is this something that we don't have? I mean, how many people in the unit now that responds to that do we have?
We're, to some extent, mixing two issues here. We have an officer-involved shooting team. There's approximately 20 officers in total. They respond to discharge of weapons and other important incidents. And then we have a separate unit that responds to the law enforcement-related injuries, which is not quite as large. Another proposal with the DOJ is that we will merge those two units and put them under a unified command. So in total, we will eventually have somewhere in the vicinity of 40 officers responsible for rollouts, for injuries, shootings, and related matters.
And that's not basically an increase of staff. That's basically combining the two units at this time.
There will have to be some increase in staff, but mostly it will be a combining of the two units.
And is there any anticipation as to how many more rollouts would have to happen under, let's say, the proposal by the city attorney's office versus any other proposals?
If I can go back and illuminate one issue, when I said 45, that's the anticipation of how many officer-involved shootings we will have this year.
Right, I understood that part.
We also had a larger number that I don't have exactly, but somewhere in the vicinity of 65 or 70 of these other types of incidents. So given everything that we roll out on, I would expect that there would be well over 100 rollouts during the coming calendar year.
But isn't the issue the question of how many hours of the day you have OHB rollout teams available?
They are available 24 hours a day, 7 days a week currently.
Yeah, so if I'm pepper sprayed, would that basically require a rollout investigation?
No, it would not.
Okay, Mr. Hernandez, yes. Deputy Mayor Kelly Martin.
Hello. One of the really important changes, I think, in this document is the restructuring of the rollout team and the moving of investigations to IAG. I would just suggest on the issue of medical care on head strikes, first of all, head strikes are prohibited. We all should understand that. But the medical care, in order for the OHB rollout team, must be medical care that is an obvious injury because the medical care needs to happen at the time the person's in custody. If it's medical care that happens after the fact, they're released, they go to the doctor the next day, we're not going to know about that. It's an important distinction. We need to make sure we understand that.
I think that, yes, thank you for reminding us. Okay, hold on. It's Mrs. Walters' turn.
I want to know what about other injuries such as a person who's severely beaten. What is the rule on that? And people who are severely beaten while in custody. when is a doctor called? And do these generate a rollout to investigate that?
Well, there's a requirement that all officers, all suspects be monitored while in custody. Anytime there's an obvious injury or a complaint of injury, that person is presented before the doctor. It is then the doctor's responsibility to determine whether the injuries warrant transfer to a hospital or they can be treated in a jail setting.
Do you have a doctor in each station?
We do not. We have doctors in 3 locations currently.
In 3 locations throughout the city?
Yes.
So it's possible that the hour time limit could not be met.
Well, an hour time limit is from the moment that we determine there's a necessity for a rollout.
Well, I'm talking about for the doctor. You said a person that needs to see a doctor, that the hour pertains, that they'll see a doctor within about an hour. Or did I misunderstand you?
I may have misspoken. The requirement is that we take someone immediately before a doctor when there's a need.
Well, what does that mean? Because we have had instances here where people request to see a doctor and it's quite some time before they see a doctor. So how is immediately defined?
Well, to some extent, that's the doctor's call. If there's an obvious distress...
Look, what she wants to know is if you have doctors in 3, excuse me for interrupting, you have doctors in 3 locations,
Right.
and it's 2 o'clock in the morning, and somebody gets beaten somehow or other. There's some incident that happens, and somebody gets beaten. How fast does that person get seen by a doctor, whether you transport them to where your doctor is or you take them to a hospital? Is that
If
basically
there's
the
obvious
trend?
distress, we will call 911 and have paramedics respond to the facility where the person is. If there's less distress, then a supervisor will direct that person be taken to a hospital. If there's no apparent distress but only a complaint of injury, then there will either be a phone call to the nearest doctor with a request on what we should do, or in the supervisor's judgment, we will have that person transported to a jail facility. But we can take the person directly to an emergency room if there's an obvious need.
The distinction here about the skull fractures. A person can have a skull fracture without it being immediately obvious.
Correct.
And what do you do in that case?
We can only respond to what the information is in front of us, either a wound
Well,
or obvious
if
distress.
a person tells you they're dizzy or they have a headache, do you just put them in a cell?
We have someone in charge. We have a watch commander, a lieutenant rank, who's responsible for making these decisions.
Councilwoman, there is a provision in this contract that DOJ requested and the negotiating team agreed to try to get at that problem you're identifying, which is if you have a problem officer who injures somebody and doesn't want to do anything about it, what can we do? And we've added a requirement in the contract that says that they have to go before the watch commander and be asked questions and given an opportunity to, are you injured? Are you feeling all right? And so we've added that requirement of a different person to ask those questions of that person in an attempt to solve the problem you're talking about.
Yes, and I read that and I appreciate that. But given the collegiality that pertains to a police station, I'm not certain the watch commander, not being a physician, would be sensitive to or trained in the kind of observations that need to be made of a person who is claiming injury. And that's my concern on this. And that people claiming injury under such circumstances is not something that is infrequent. So, Chief, do you have a response to that?
Certainly, human nature being what it is, there's a possibility that a watch commander is liable to miss something like that. And although our jailers and watch commanders, to the best of our ability, all of our people are trained to be sensitive to that and provide medical care when it's required.
The city attorney's language, I think, is preferable here. in substituting that, resulting in all head strikes in which medical treatment is obtained. And that does not mean that it's obtained if he doesn't get it through the police officer right there. If somebody's released and goes to a doctor the next day, is that, would the rollout trigger, would that trigger a rollout?
Can I ask a question
correct.
related to that at the same time? As I read 28, it appears to refer to incidents that happen in the field. Does item 28 also apply to things that might happen after the suspect and the arresting officers are back in the jail or in the police station?
Yes.
If I can make an observation, the reason for a rollout, whether it's a major crime or an allegation of police officer misconduct, is to capture evidence, interview witnesses, do those things that would otherwise be lost. If there's nothing to trigger a rollout and a day or two later something occurs, which had we known at the time would have triggered a rollout, there's probably less need for a rollout immediately because you're now trying to reconstruct what previously happened.
Right, no, I understand that, and what I'm trying to do is see if we can narrow this back down to what this really deals with. This whole paragraph 28 deals with the circumstances that trigger a rollout. It doesn't deal with, it's not a comprehensive addressing of the problem of potential need to respond for with medical treatment.
And one more thing, it's
But
also...
wait, excuse me one second, just yes or no, does this refer just to incidents in the field, or is it, because where else are you
No.
going to do a rollout? You could do a rollout to something that happened at a police station.
If there was an officer involved shooting at a
Okay.
police station.
Okay, all right.
Well, I'm not talking about a police station. This is talking about skull fractures and injuries to people.
Okay, Mr. Chaliff.
The commission, through the use of force review, already reviews incidents that occur in the police station. Therefore, the rollout team would go to the police station if something happened at a police station. What the difference...
That was my question. Mrs. Walter's question was, say again, your question had to do with...
Well, my question had to do with injuries sustained that perhaps did not rise to the level of a skull fracture or were not immediately obvious to be a skull fracture. Beating, perhaps, some other type of injury that could be very serious.
Any injury that requires hospitalization now requires the same type of rollout that would require here. If somebody gets beaten in a jail or comes into a jail appearing under stress because of being beaten, they are supposed to go to be seen by a doctor and or taken to a hospital depending on the circumstances.
Yeah.
Let me just say one other thing. I agree with the chief in that the purpose of a rollout is to freeze the scene so that you can do an investigation. If somebody reports a skeletal fracture 2 days later, it's impossible to go back and freeze the scene. The best you can do is what this agreement requires, which is have an investigation, have that reviewed, and have that audited by the Inspector General.
Well, the other question went to your definition of immediately. The chief did not define immediately. To say immediately, seen by a doctor when there are only 3 in the city, is a little disingenuous.
Those are intake doctors at 3 facilities. We also take people to hospitals. We also dial 911. I didn't mean to limit that those are 3 are the only ones who look at
But I
prisoners.
think we're getting a little off paragraph 28 here. These are very important issues, but paragraph 28 deals specifically with the circumstances that trigger a rollout. And we have a motion from Mr. Fewer supporting the city attorney's recommendation, and I've heard 3 other people say they agreed with that. So is there any objection to that motion?
And Ms.
Galanter, yes, what?
Galanter, sorry about that.
That's okay.
While this deals with circumstances of a rollout, the bottom line of my question is, are there not other injuries where a rollout should be triggered?
Fair enough. That's where we started this debate. And I think the concern that was expressed in the early part of our discussion on this item was to look at whether there is a different line to be drawn. Mr. Fewer then moved, after we batted that around for a while, moved to go with the city attorney's recommendation, specifically with the rollout. And if there is an objection to that, we'll take a vote on it. But at the moment, I don't have anybody else listed to speak. So is there any objection to that to the city attorney's recommendation on 28? Mr. Hernandez.
Am I
Should be on.
Yeah. One of the questions that's before all of us is giving the city attorney direction as to the position that should be taken in regards to negotiations with Department of Justice. Now, they have taken a position that's different from ours. I would like to have an understanding why their position is different from ours. My concerns on when the rollout team went out, and the reason I was asking questions is, I'm sure that the department, through some system or other, knows when there's a shooting or an officer-involved issue for the rollout to be able to go out before certain circumstances could happen. But here, this category, we're talking a whole separate set of circumstances where there aren't other ways of knowing what's going on except if we're called out for some reason. And so why is Justice taking their position, and how does that, because of the audits and the reviews, differ from the position you're asking us to take?
Well, as I said in my document, they wanted to include all uses of force resulting in skeletal fractures and all head strikes with an impact weapon. In discussing this among the members of the team, we felt that that would be too great of a burden on LAPD, especially all head strikes where if somebody didn't go and get medical treatment, we didn't think that that necessitated the heightened investigation. Remember, this does two things. The first is, if you include it in categorical use of force definition, it means that there's an OHB rollout whenever it's determined that it meets those criteria. So it could even be, the next day when someone gets hospitalization or needs medical treatment. Then we'd look back and say, okay, this should be done by OHB rather than the regular use of force investigation done at a lower level at the division level. And the second thing is these heightened procedures for investigation, that we do much broader, much more intensive investigation than our regular use of force investigation. So the difference between the DOJ and the team was we felt that we should try to stay with the more serious incidents in defining categorical use of force. I recommend that we agree with the Department of Justice that all head strikes with an impact weapon, and then I had added the language for which medical treatment is obtained, should be included for an OHB rollout and for the heightened investigation procedures that are done once OHB takes it over. And on skeletal fractures, they wanted every skeletal fracture subjected to this other unit doing it. We still don't know how many that is yet from the chief's testimony this morning. We still don't know what that number is, and that's why I'm suggesting that maybe this is something that evolves over time, that we agree to do an audit of how the skeletal fracture incidents are investigated and to determine maybe DOJ was right or maybe they weren't right, but at least we don't know yet how many that involves, what kind of burden that puts on the department, so we'd like to hold off that lesser, it could be a broken finger, a broken toe. Does that really need the heightened investigation of the specialized unit under OHB, or can that just still be investigated? It won't be swept under the rug, it'll still be investigated, but at a different level of investigation.
But, Councilman, I think that the differences, and you'll see it throughout the document, is that they come to the table with problems they see and how we've handled certain things in the past. They want, in our view, way over to the far end. We can agree to certain ones of those, and what's happening is that trying to define where to draw the line. And it's where you draw that line and making it clear. We're concerned about we want to be sure that we get the most serious, whatever the area is, but in this case, the most serious categorical uses of force. We also do not want to use we want to use a commensurate amount of resources in order to take care of that problem. And so I think we are trying to say that we want to be able to follow up with audits, et cetera, on these lesser situations, but it's basically drawing a line between a major injury and maybe a fractured big toe. So that's...
All right, now, I don't have anyone else listed to speak. Don't all jump to do it because it's 20 to 12, and I thought this would put us through 3 items, but I understand Mr. Fewer wants to go back to item 12, so we're not through with even 3 out of the 42 or so where we do not have agreement, and the other 100 and something where we do have agreement. So on item 28, I wish we were on a roll. On item 28, we have a recommendation from Mr. Fewer to go with the city attorney's recommendation. Is there any objection to that? Seeing none, that's the recommendation. And now, do we need to go back to item 12? All right, so let me just, before we do that, let me just caution everybody that when we get to as we go through an item and the team does its presentation, if you feel the need to discuss something, push the button, and I promise I'll keep very close watch on the monitor. But if nobody has to speak, we're going on. So, back to item 12.
Item 12 seemed at first blush like a pretty innocuous provision. I want to be sure that it is, and if it's not, what exactly we mean. Item 12 says that the city is responsible for providing necessary support to the commission, the IG, the department, and the chief of police. What necessary support means is open to interpretation. It could mean 2 general things. It could mean financial support and support if other kinds of problems arise that are operational or logistical or philosophical for that matter. It's very open-ended regarding all those things. Let's leave the financial item on the table for a moment and look back to last week. There was a widely reported series of conversations, a debate really, at which last week the Inspector General and the police chief went at it. And I've talked to people who were there, and the report appears to be pretty accurate. Let me take an example. The concern was expressed by the IG that the department was impeding his access to getting information. The chief challenged whether that was true or not and said, but you told us in public session that was not a problem. My concern is this. We're charged, pursuant to an enforceable consent decree, with providing necessary support to fill in the blank. Let's say it's the IG. If the IG comes forward and says, the department isn't giving me the data we need, what role is justice going to assume the council is supposed to play in assuring that that happened? There's a council, there's a commission, the city of Los Angeles embraces all of those.
Okay, let's see if we can get an answer. What role is...
And then there's a financial issue as well.
This was largely a financial issue that was the genesis of this particular one, but I think in this instance, the Justice Department would be looking at the mayor, the city council, et cetera, to the extent of their charter responsibilities, to make sure that a provision in here is done. Whether that means financial, or if for some reason, if you get a quarterly report either from the internal city structure or for the independent monitor or for some other reason that something's not being done, I think the expectation of DOJ from this paragraph is that we would correct that problem.
Yeah, let me just say, I mean, I don't have an easy answer to this, but this really invokes the difficulties we have among the police commission, the mayor, the city council, the police chief, who's in charge of arbitrating these issues. There have been issues where the council has said to the police commission, we'd like this to happen. The commission says we're going to put this on hold or whatever. The commission wants X to happen. The council may balk. The mayor may want something else. I guess what you're saying is that the wording that we have leaves it up to the collective entities that I've just mentioned to figure it out reasonably quickly, and if there is no consensus as to what the resolution is, then we are subject to dealing with a court?
Absolutely.
Well, that's the point of this whole thing, is to force us to do
No, I
our
understand
job.
that, but this particular provision is what's at issue, so I wanted to ask that. Now, on the financial side of things for a second, on the financial side...
30 seconds.
Obviously, we cannot predict with certainty how much money is going to be necessary to make any of these things work over the long run and what's going to arise here. But this is essentially saying, what? Is it saying that what the department says it needs?
Absolutely
is that
not.
for which we're responsible?
Absolutely
What is
not.
it saying then in this? Because
Okay,
you
let
can
him
easily see when
answer
they'd
it,
be
because
saying
your
no.
time's up, and now we have 4 more people who want to be heard. Go
It
ahead.
says what's necessary to fulfill their obligations. And as I explained, this is an area of some concern to mine, that just because the department or any department asks for a certain amount of resources doesn't mean that they get it. And that if they don't need it for the entire year, they're not going to get the full amount. and that I understand, indicated that there was, I had noticed in some departments a practice to try to get more money during the fiscal year, and that way they would have surpluses at the end of the year, that I had no intentions of doing that. They acknowledged some guilt of their own in the federal process to that practice, and they wanted a much more specific type of paragraph. And I indicated that that we had an orderly process for budgetary considerations, and we would make sure that we had the resources necessary to carry this out, but that did not necessarily mean that we were going to rubber stamp the initial budget request as it made its way through the process.
I press my button again, Madam President.
Okay, now we have 7 people. Ms. Goldberg.
I think this is a good reason why, wherever we can on budget issues, we should get approval by the monitor and the DOJ in this, and not just a monitoring, because my experience has been, not here, but in the school district, and we had a lot of consent decrees, that where we had agreement on what the standard was, we agreed on how much it was going to cost, or roughly how much it was going to cost to put it into effect. Where we didn't have that agreement, we then had a long fight over it, and very often, we thought we had met the standard, and somebody kept coming back and saying we hadn't. So I just think that that's an area where particularly where Teams 2 and other things where there are big cost, big ticket items, I think to the extent that we can get as much agreement in the initial days after this is agreed upon on what these costs are and what's expected of everybody, to that extent you make it a defined amount, and that it goes through a process that is very similar to our normal budgeting process to make that done. Because otherwise what you have is you have a constant battle over what is meeting the standard. And that is very expensive, both in the time, delays, and the final cost. Because then you can do 2 or 3 things before you finally get agreement that that's what the standard was. So I think it's very important we get a standard established immediately following this agreement going into effect on each of the principal cost items.
Ms. Mizikowski, and before you start, let me just announce lunch is available, but remember, dinner will not be, and it's 11:45, and we're not through 3 items yet. Go ahead, Cindy.
I was just, I think, standing in affirmation of what Mr. Deaton explained, and that is that the City of LA, as we've said here, is all of us. And what this is putting forward is that we are all responsible for providing the necessary support, just like we are all responsible for getting to this point today. And although there was disagreement, there has been an effort to work it out. We also are going to have the issue, and I think the most important part of this is the financial, but I don't see this as a blank check. We are not signing away the city treasurer to say that the monitor determines how we spend the money, but the city has to be able to maintain to the monitor how we are funding this. And members of the council, we go through this debate every day, almost, with the issue which we just did recently with the Inspector General asking for special investigators, which was the commission agreed, the Inspector General needed them, it was consistent with the Christopher Commission intent, and yet we had differences among some of the police, the department, and the Inspector General. But the council took that, approved it, the mayor agreed with it. And there's going to be that tension, but that tension that is normal and part of policy that we are going to go through all of this. We are going to decide in terms of our budget, what are the highest priorities? We're going to get the department tell us what its priorities are, as in fact we already have through the integrity package. We're going to get the independent panel's recommendations. We're going to get the commissions on top of that, and we are going to have to make that judgment, and then it's going to be the monitor to tell us whether or not we are at least attempting with all reasonable process to enforce everything that we are now agreeing to. But again, I think that this is healthy. I think it's telling us on notice that we are all responsible and in this together to do what we are saying we are going to do.
And as the council will be a signatory to this agreement, this is something that you can bring back before you also to determine whether or not we're living up to the terms of the agreement, or if any one of the people who is charged with any obligations is saying they're not able to fulfill their obligations. Again, that's something that the council will own and be able to bring back before
And
itself.
if they are saying they're not able to, they'll tell us why. And we
Right.
measure that as along with the whole of everybody else and all the other parts of this implementation.
Mr. Pacheco.
Madam President, colleagues, I believe the debate about this paragraph raises some sort of secondary issues in my mind. Mr. Hahn, you may or may not be familiar with this case, but we may need some guidance from your office on this matter. I have a vague memory during charter reform that there was a case regarding funding that we were looking at in the city of San Bernardino and the city attorney suing the council for not adequately funding the office because during the budget process, they basically eliminated all the investigators for the city attorney's office. Does that case ring a bell for you, or do you remember that case?
President, yes, President, members of the council, that we could pull the case and brief it for the council, but there is case authority indicating that charter offices that are appointed by the people need to be adequately funded to perform their functions.
So here's the question. It's not exactly the same. So the real question I'm asking is, and I ask this openly because I think we may want to equate it to a charter office. That's really the question, is do we want to empower the Inspector General, the Police Commission, to have that type of avenue of recourse if they, independent of the city politicians, feel that they're not being adequately funded? Would this case give us, would the case, I think it's Stevens versus City of San Bernardino, would that case give us the standard of review, or do we want to leave it vague and open? Because we're talking about standards of review here. We're not talking about whether or not we want to have a strong IG or a strong police commission, because we all agree on that. But what happens when they feel, independent of us, that they're getting changed in the budget process? Should we empower them, or should we leave it open?
It's not
does this have the same net effect when we sign this agreement? That's really the end question.
No, it was not intended to empower different officers within LAPD or different actors or police commissions or inspector general to be empowered to have some ability to use the consent decree to force any funding decision by the city council. Again, the agreement with the federal government indicates that the city police department and the city will agree to do a number of things. If we don't do those things, we'll be in breach. But it was the feeling of Mr. Deaton and myself and the mayor's representative that we did not want to be tied down with specific language requiring us to do the specific level of funding or require or enable a specific actor to demand a sufficient level of funding. We wanted to leave that flexibility to this council and to future councils.
Okay, just wanted to ask.
Thank you, Councilman. The chair recognizes Councilman Padilla.
Thank you, Mr. President. Just wanted to rise in support of adopting the language as is in the proposed agreement. I think in this issue and a number of other issues that we'll face throughout the day, we should empower the city's negotiating team with the flexibility enough to negotiate the true spirit and intent of what it is they're telling us. And like City Attorney Hahn said, not lock us into specific language that won't give them the flexibility to discuss with justice later. So I'm comfortable with the way it is as long as we have the understanding of what we believe it to be and have the faith that both justice and the courts in the future will understand.
Thank you, Councilman. Anything?
I think we'd like to move on then to Roman numeral 2.
Well, hang on, Mr. Deaton. We do have other speakers before this.
Because if justice believes that at this time we have not been providing the necessary support and that there has to be a greater financial obligation to fulfill the agreements, then we should know that because we're voting in regards to budgetary issues when we approve this agreement. And I'm just putting it in context because I always argue when we go over the budget that the police department's half of the city's budget. And if they feel that in addition to that, we have to provide more resources, we should know that before we cast the vote. And that's part of what my question is, Mr. Deaton. So I just, in looking at this, I see it as us agreeing to provide additional funding for them to fulfill the obligations of this consent decree. And I just wanted that defined a little bit better.
I believe that is correct. I don't, just so we understand, I don't think Justice Department's position is that you need more resources or less resources. What they're saying is that the things in here will be done. If you want to do them by cutting other things, that's fine. Or if you want to provide additional resources, that's fine. But the items here in this 100 and some odd paragraphs are things that in which they want done in order to enter into this agreement. I have provided you some rough cost. They are not costs that have been run through the ringer, if you will, of the budgetary analysis process. They, in some cases, will go down. It is conceivable in some cases they will go up. However, they are an order of magnitude of where I think you could be looking at for each of these items, and that's why, as we go through paragraph by paragraph, even if there isn't an open issue, I think we should discuss the cost and what are the potential implications. For example, in the rollout team that we were just talking about, the chief indicated that some of that is just a moving of existing resources to another unit. However, there are units within the geographic areas that would have to be replaced if it was in a central location, so that will be additional cost because those costs which are shared will be needed at the geographic area as well, so there will be an additional cost. Currently, for example, in the complaints that are being shifted to internal affairs, those are done by the chain of command now, and you have two choices. You can either add additional resources to internal affairs, which is the cost figures that I've provided, or you can reduce the officers in the field, which I don't think is a good option, but it does, by adding that into internal affairs, you have the additional benefit, if you will, of really providing more resources in the field. So yes, I believe that you are looking at a fairly substantial increase in financial commitment, but I don't think Justice will view it as how much more is added or how much is not added. It's going to be, do you have teams 2 up and running within X period of time, and how much it costs is really not on their radar.
Mr. Fewer.
Not on money, but on those operational issues I referred to earlier. Is it the view of the negotiating team members that the current structure of city government, including the structure of the police commission, is adequate to dealing with issues like the ones I mentioned earlier, where there are meaningful disagreements that exist between a couple of the entities listed in paragraph 12 or among more of them? For example, do we think that Mr. Chaliff is a good example. Somebody, here's a volunteer civilian police commissioner who spends an enormous amount of his personal time doing this to the detriment of his career. Mr. Chemerinsky said that he favors changing the structure of the police commission to have at least some full-time commissioners because of the degree of scrutiny that will be required to be placed in the department, in part under this agreement. So what I want to know is, do you think that the structures of government are appropriate now to do this? Or do you think that in order to fulfill the obligations implicit in paragraph 12, we should be doing some other changes very soon to the structure of government here?
If I might, having a brand new charter, I'm certain that we have the structure in place. The situation really, though, is that I think we have a structure in place. If we do not comply, we're going to end up in court in a breach of this agreement or a court order to do something differently. I think it'll be a very substantial test of the structure we have at currently, and I think that as we look at this and its implementation, certainly looking at other structures would be appropriate.
See, just for us, with my own view is this, that the degree of scrutiny that this document requires that city government places on police department operations is substantially greater than has historically been the case by any entity of government here. Any of us mentioned the council, the commission, the mayor, the city attorney, anybody. And I think that under that circumstance, at a minimum, if we're going to buy into this kind of paragraph, we need to also be buying into police commission that includes some people who have full-time status, for example, and other things. Because without that, it's just too much to expect we're going to have people sacrificing as much as Mr. Chaliff has done year in and year out.
Okay, and I think that the that's a very good example of what I hope this discussion is going to do for us, which is to help us recognize that whatever it is we agree to, as Mr. Chemerinsky pointed out, is not the whole story. But I also want to remind you that he urged us to get through this and then go on to everything else. And it's my hope that one day we will get through all of this. I have no more requests to speak from the council members, so is it safe to deem item 12 now discussed, and we can move on to the next item?
Yes. I believe
Good.
so.
All right, we have now deemed it discussed. That means we have covered 3. We have covered 9, 12, and 28.
But accordingly, I think we have discussed just briefly the other paragraphs in Roman numeral 1 except for those initial paragraphs. So with the exception of those paragraphs which we've held for the end, I think we're now onto Roman numeral 2 and paragraph 37.
Wait a second. What happened to 29 through?
We agree. In those instances, I just pointed out that 22, I mentioned that 22 LAPD was chief and below, and that the department was the chief and below, and the city was the city council and the mayor.
Right.
And just their
Okay,
definitions.
that takes us up to 28. What about 29 through?
Those are all definitions as well. Those are all definitions in
Those
which
are all the
there's,
definitions.
which
Okay,
all
so
parties
now-
agree with,
Fair enough.
and are not
So we're not going to give any
monumental in
council
their-
members a chance to disagree
in
with
their
the definitions.
consequence.
Go right ahead.
So we're now to Roman numeral 2.
All right, Roman
Right.
numeral 2.
Roman numeral 2 essentially is the Teams 2 system. And like to discuss Teams 2 in its entirety, and there are several paragraphs within Teams 2, or in Roman numeral 2, 49, 45, 44, and 41, all of which are open issues, just going over that, 41, 44, 45, and 49. Those issues are open because of schedules, approvals, and definition of terms. And I just want the team's position, and we were still working this out with DOJ at our last meetings, was that the plan here is to implement a database system that can be accessed for a variety of management uses relative to promotions, evaluations of personnel, units, basic information system on the police department. In the implementation schedule proposed by the Department of Justice, they had talked about a quote-unquote beta system being ready in 12 months and the final system being done in 14 months. We currently have a consultant working on this job and has had a preliminary report that was due last week, and the final report to basically provide for direction for us in the development of the system to be done by October 1st. I asked him to put together some information on different options, and the options from a very, very small rudimentary system, which I do not believe we should head, would cost as little as $1.5 million and would take 6 months to implement, and the full major system would cost more like $39 million or $40 million and take 60 months to implement. What he will be recommending, his firm, will be a system that was probably in the neighborhood of $12 to $15 million and take 20 months to develop. We want to sit down with the Department of Justice, indicate that, by the way, this is a consultant saying 20 months. I'm not saying that that's not what will happen, but
Is that 20 months to start or 20 months to be
from
complete?
the start, to be complete. That's his estimate. One has to allow for that sometimes consultants have overly optimistic views of reality and how quickly we can get things done. So I'm just saying that we have a difficult, we have to explain to the Department of Justice that the kind of system that we're talking about, and these paragraphs all play into this. It has to do with how much historical information is going to be provided into the system. And I think our collective recommendation would be that you give us the opportunity to sit down with the Department of Justice and talk about the role of their approvals and how much time they have, the amount of time we have to implement it, and that we put on the table perhaps a staged implementation, because I understand in also discussions there's parts of this, and maybe the more serious parts of it could be, like excessive use of force and those things, might be able to be implemented far ahead of the 24 months type schedule. So those are the main concerns we have in paragraph, or Roman numeral 2, excuse me.
Okay, Mr. Padilla.
Thank you, Madam President. I just wanted to formally make the motion that's being requested by the negotiating team to direct them to negotiate with the Department of Justice for a little bit more flexible of a timeline for design, beta testing, and implementation of Teams 2, especially if we all acknowledge the history of the city when it comes to these technology projects. I think it's important to have an aggressive time schedule, but also a realistic one, and I think that's what's called for here. Also wanted to give them some flexibility to negotiate the capability or the specific capacity of the program. I know in my own conversations with the Department of Justice, they made reference to the LA Sheriff's Department and the sort of computer system they recently implemented there. And I quickly brought to their attention that the capabilities of a system that we're being asked for is much more sophisticated, is much more complex than that in the Sheriff's Department, to which they also acknowledged it, they agreed, and therefore I think there is room for flexibility, and I think it's in the city's interest to pursue that.
Mr. Deaton.
If I might just add one, going back to some of the discussion on cost, it is anticipated that the startup cost for this would be someplace between $15 and $25 million, an ongoing cost around $5 million. And I thought that it might be helpful, given other things on the agenda. This is, I think, on direct point on Mr. Chemerinsky's recommendations 21A, B, C, D, E, and F. And I will point out those as we go through the document. 21. I'm saying, you have in his like recommendation number 21, which avoids the A, through F, et cetera, is implement a system of tracking complaints against police officers. This is on point and is a direct, I think, fulfills that recommendation totally.
Mr. Fuhr.
Thank you, Madam President. A couple questions. Is there a reason in paragraph 38 that the access to city officials given does not include access by the city attorney, who needs to play an important risk management role here? That's why I'm asking the question. If there's no good reason for that, I would move that we include the city attorney in 38 among those who can actually get access to the Teams 2 information to perform that risk management role. Second, is there a definition anywhere of what constitutes the at-risk behavior referred to in paragraphs like paragraph 46? Here's why I asked the question. The Teams 2 system is a management tool to enable us to track who the problem officers are, readjust our training, readjust deployment, maybe have to do with discipline and so forth. As a management tool, there are two issues I wanted to flesh out. One is, if a manager is reviewing Teams 2, and I think 46 refers to the protocol should provide that when at-risk behavior may be occurring, something has to happen. I'm interested in what that means, and also what our supervisors should consider an unacceptable level of that kind of behavior, because otherwise I think we're leaving it very mushy for supervisors to deem certain behavior unimportant, we consider important. Help us out here on that issue, please. Kelly, I think, has some comments about that.
I think I missed the first part of the question. Could you repeat the first two sentences?
Want to boil down what at-risk behavior means in this context and what constitutes an unacceptable level of it.
The reason this is not fleshed out here is because the protocols and Teams, as I understand how Teams will work, is you will program into it sort of bells that will go off, and the department needs to figure out when those should go off.
Okay.
They will be preparatory, they will be before an officer does something that would be disciplinable. For example, if an officer had 3 of certain kinds of complaints, and we'll be looking to, the department's currently reviewing the Pittsburgh protocols and the protocols in other places. So the way the whole system works is it's designed to force a supervisor to sit down when some kinds of behaviors have taken place, to say, hey, this officer maybe needs closer observation, should we move partners, should we do those kinds
Right,
of
just
things?
as my time is about, I just wanted to say that so the answer to the question is, those details will be worked out as we develop the Teams 2 system further pursuant to our agreement to get it done altogether. Last point is this. I have been among those to say that I think the monitor needs to have a reporting role rather than a role that includes directive authority. In this instance, I am interested in, I know the city attorney and I have discussed this, there may be some good reason to give the Department of Justice final approval over the system that we independently think makes sense, so there's not disagreement later on. I'd like to know what the team thinks about that, and if there's no disagreement with that, move that as a component as well.
I think the mayor's office feels that the that the DOJ is going to have some sort of approvals. It has to be, I would ask that you leave the negotiating team flexibility, knowing that conceptually, I don't think anybody disagrees with the concept of approval, but we need to make sure that it works so that the DOJ approvals don't cause us to miss our own timelines. We want to share drafts, do that kind of stuff. The difference between the DOJ having approvals and the monitor having approvals is this. The monitor should be brought along to see and get familiar with, but we're not necessarily looking for a monitor who has computer expertise.
Yeah. And Kelly, I would move the direction to the team to negotiate what has been described. That's what I have in mind.
Okay.
Ms. Goldberg.
First, a procedural question. There's about 10 or 11 items on this that say open. Are we going to go through them one at a time, or when we speak, do you want us to address all of them?
I think what we're talking about in this is 41, 44, 45, 49, which all have to do with schedules and approvals.
Well, there's some items in 40.
Right. When those, I'm not saying.
And in 45 and in 50.
Right, and then we'll come back through and hit those individually because they're not all part of the same issue.
So we're going to go through them one at a time?
Yes.
Okay, well.
Excepting for, what I'm saying is that right now, just what I'm hoping is we're discussing 41, 44, 45, and 49, which all have to do with, in one fashion or another, schedules and approvals of the Teams 2. 40 has to do with some data items, 50 has to do with what we're going to do before Teams 2 is implemented, et cetera. So we'll go through those.
We'll go back through 40?
Right.
And, okay, so we're not doing 40 now. We're doing 41.
Right.
We're doing 44. Okay, on 44, I understand the issue that was just mentioned about approvals have to be crafted so that we can make sure we get schedules on time. I have no problem with that. I just, as I said, having had bad experiences, when you don't have approvals on what you're going to have in a system, you then end up fighting about it later. And when you fight about it later, you spend time, you spend money, you sometimes go down blind paths, spending more money, and so I think we have to say that there have to be approvals, by which I mean agreements as to what we say the deliverables are and by when, because otherwise you just fight over what you thought you meant and what the standards were, and that costs time and money.
I don't think we have a problem, and in fact, the design, one of the things is definition of design document, and some, actually we were at a level to make sure we understood what they wanted to review, and I think there is some value in that.
Okay, I just, I've been down this road in more than one agency, and it turns out that sometimes a little more time in the front end saves you a lot of time at the back end. On 45, you talk about implementation schedules and so forth and so on. Well, I'll address that when we get to another item. 49, timelines. I guess let me just make an overall question. If this is going to take 20 months or 2.5 years or whatever it turns out to be, I think we need to have some type of interim, and one of these addresses that.
50.
I'll wait till we get to 50 then. Because I think we can't wait that long, in my opinion, to have first nothing and then everything. There have to be things that happen in between.
Okay. Now, just clarify for us, did you want to say something? I've got 5 more people here.
Well, before, just in following up.
And what one of them at least wants to know is, are we going to go through one by one, or in addition to what we've just done, or not?
Certainly, I mean, yeah.
All right, we'll see. Okay, you wanted to...
I just wanted to, hopefully in the discussion right now is on 41, 44, 45, 49, as I recall. Just as it relates to protocols, and I think an item that Councilman Fuhrer raised, is that like in the protocols in Pittsburgh, citizen complaint, one complaint per quarter gives you some sort of yellow status, and 2 complaints per quarter gives you a red status. If you're 2 standard deviations away on sick time, you get one, you have another category. So there is an order of process that has to be worked out within the police department on what kind of incidents and how often they happen for them to get into this at-risk behavior issue.
I do think, in fairness to the people who get complained about, we also ought to take note of the fact that there are some people who, when they get caught at something, immediately conclude it must be somebody else's fault. And actually, I remember as a child, my mother showing me somebody who tripped on the way through a subway turnstile and who then began screaming, and there was clearly nothing wrong with the person except they had spotted a potential lawsuit. So I think it's important for all of us to recognize that indeed sometimes complaints are very valid and sometimes they're not valid at all, and that if they're found to be not valid at all, there ought to be some acknowledgement of that, and I think there's
a
provision in here that addresses that as well. Okay, Ms. Chick, you're next.
If we're going to be hearing back on the other items, those are my questions, not on what's before us right
Mr.
now.
Hernandez.
Madam Chair, members of the council, this is an area that kind of bothers me because I understand the importance of the bells and the whistles, and the fact that Teams 2 hopefully will identify those bells and those whistles and give us some indication of areas where we have to improve on personnel training and monitoring of individual personnel. Where I'm confused is we're developing a system that apparently doesn't exist in our department and hasn't existed in most major cities of this country. And so I think the time frame for that development is real important. But part of what I've been hearing and what was bothersome to me, I attended a seminar at Loyola Law School, and it was like there was a focus on the failure of the entire system, legal system. Why was it that judges weren't bringing it to our concern? And then I thought there's a particular judge who has been bringing it to our concern in terms of a federal judge. They were talking about the district attorney's role and why they weren't bringing it to our concern, and our own city attorney's role. And when you put it in perspective in terms of when we deal with issues in closed session, I think we've been amazed at the processes and why it was that we weren't aware of problems dealing with litigation when we're being proposed with settlements. And we've been trying in our own way to develop systems for how do you correct that. This Teams 2 is going to deal with the issue of personnel and provide some whistles. And I guess what's bothersome to me, and the reason I'm bringing it up right now that we're discussing it, and it's not part of the consent decree dialogue, but how is it that the other systems, that bells and whistles that are supposed to be letting us know of potential problems, are going to interact with this council? How is it that the city attorney's office is going to play a role in monitoring potential problem officers or potential problem situations in the department and letting us know outside of the scope of a settlement proposal regarding an individual case? And I'm trying to see if there's going to be any kind of computerized system being put together to allow that to happen. But we've been dealing with it in closed session. This is where the only thing that's brought before us is that item. And we were asking questions of patterns and then kind of shocked when we got answers. And so I'm just asking the question, General, at this time before we enter this discussion,
Okay,
in case there should be something there.
Ask the question as a question one more time, and then let's get an answer, and then your time's
Well, and maybe Mr. Fuhrer was addressing that when he was asking the city attorney. How does that impact your ability to allow this council to know patterns that we should be concerned about in regards to what's going on in the department?
Well, as you know, we've been providing reports on all cases, so involving the police department, to the police commission, and to the council. But what I think is going to be valuable about this agreement is that this computerized system, the additional audits by the Inspector General, and the reports by the monitor, frankly, will be additional communications to this body, to the City Council. Those reports will also be coming to you as signatories to an agreement that the council will be getting the reports out of Teams 2, the Inspector General's audit reports, additional audits that are going to be done by the police department itself, and the monitor's reports. And I think that in that regard, that the patterns that you're referring to, council member, and the grouping of incidents, we're going to have an ability, I think, to do that. And I think the city attorney, in dealing with those risk management issues, also will be a recipient of those reports and will be involved in discussions with the city council on changes that need to be made in response to those. So we're going to get a lot more reports than we've gotten before. The council is going to get a lot more, the city attorney is going to get a lot more, everybody's going to have a lot more information and a lot more timely information than we've ever had before. And that's going to really change how we react to these incidents. We won't be looking at these lawsuits in a vacuum anymore. We'll be able to look at them in context.
For example, if you had a lawsuit over a particular type of incident, you could find out historically how many comparable type incidents, what units, what time of day. You can be able to find out, and the city attorney would be able to find out if these kinds of incidents are happening on a regular basis, or is this an isolated case, and also what the police department would be able to find out what the disposition of those incidents were. In other words, was there discipline, was there whatever, what was the result of?
Well, that's the question we usually ask and have trouble getting an answer. All right, Mr. Wax.
Ron, can I just go back a moment on the costs insofar as they relate to all of this? It's more of an aside, but it's something that bothers me. You're saying that the cost is roughly $15 to $25 million in one-time costs and about $5 million ongoing. Somehow things take on a life of their own. People say things and then it's assumed that they're true. The common thing out in the public is that somehow the federal government gave us the money and we never did it. The money was like $150,000, wasn't it?
No, it was $160,000.
$160,000. So they gave us $160,000 for something that's cost $15 to $25 million up front. And another $5 million plus a year. And somehow, things, it's amazing how people say things and then they get repeated and then it's almost like they're true. And everyone who is listened out there thinks that the federal government gave the city the money and it never did the job that they actually gave us the money to do, when in fact they gave us $160,000 out of $25 million. I just think that maybe if I raised it because I want it on the record, because maybe we can repeat the truth in the future, and that creates an amazing misperception. I mean, it's an incredible misperception that, that this is it is something that needs to be done. There's no question, and it is something that should have been done quicker. And there were a lot of problems as to why it took as long as it did to get here. But it's just thrown out there that, oh yeah, and the council and the mayor and the police department were so bad that it had the money offered to them and it never did it anyway, when in fact the money was less than like 1/4% of the total cost. The other thing is the process. I think it's very clear that I started from the beginning saying all the negotiations should have been in public. And the reason I did one, because it's public business and there's nothing to hide. But here we are now, we're sort of repeating everything that you people did in private. Here's our negotiating team, and you were with the Justice Department, and you went through all these items for 4 months. And now, because we finally got this out in the public, we're starting all over again, but the Justice Department's not here. And so we're like talking among ourselves, and you're doing the best job you can to sort of tell their side of the story and your side of the story and the many sides of the story, since you don't agree on every issue. And we don't even have them here yet. And then we're supposed to be making some kind of a decision. A flawed process takes a lot longer to cure than it ever would have taken to be right in the beginning. So the question, though, I'm raising is not to be, and I told you so, but to how do we get on some of these issues where we're going to have difficulty coming to some kind of a consensus, the other party to the table to have their input. I mean, it's almost not fair to ask you to represent them and yourself at the same time if you're not agreeing. I think you're doing as good a job as you can to honestly do that. But at some point, do we get the Justice Department people here, at least on those major issues where we may not be coming to consensus? I think it's really important. Who can...
Well, I would suggest that if you continue to give us instructions, that we go back, meet with the Department of Justice and work through those. And if they're, at that point, the council's direction isn't reconcilable, then we make arrangements. Because I think
that would be at a minimum, I would recommend that. There may be points, however, where you want it earlier on, because it may help us formulate even our own positions, but clearly at the point that you're mentioning. So I want you to sort of give some thought to that as we come along, and if we come to some issues where where we're at a logjam here, it might be helpful to have the other party to this agreement there, or here.
We did invite them to participate in any of these sessions that they choose to. No, and I understand that doesn't address your...
But that's more like if they want to come, they can come. And
Well,
it may be really advantageous to everybody just to have them here and have some of these discussions.
Well, why don't you just take a minute, and I think we did this earlier, but we're going to probably want to do it periodically, assuming we ever get to the end of this agenda, which actually has, if you read through all the stuff, it has relatively little point of disagreement, considering the volume of stuff that's in here. There's actually an agreement, proposed agreement on most of it. What happens with all the remaining stuff? You're going to go back. We're not going to be approving final language today.
No, I think what our intent, I believe, is that you would direct us, as you have been thus far, to go back, sit down. I think in most of the cases that we've discussed so far, at least, that won't be very difficult, and that we would work out the language, bring it back. If there remains open items, and we believe that we can come back, either do this again, or we can come back and suggest they be here to do that with you.
Madam President, may I just add one more point to this? Okay, that's at best with the issues that we're dealing with that you have negotiated and you have open, and you have varying recommendations. There are a number of other recommendations, such as a motion that Ms. Goldberg and Ms. Chick and I have on the table, and others, and I'm sure there will be many others, that weren't negotiated, that weren't even subject to the negotiation, that some of us would like to see added to it. They're going to have to be here. If there's going to be a proposal to add, for example, some of the recommendations from the Chemerinsky report, they've got to be here. Or they have to, at some point, it's got to be presented to them, and we've got to be able to get some. One of the things I'd wanted to ask Mr. Lee when he was here was whether or not they would be open even to entertaining additional items that weren't part of the negotiation. And I think that some of us will feel that some of those are every bit as important as the things that we're talking about here, and we will be raising those. And if they're not here then it's going to it'll lengthen and extend the process rather than quicken it.
Well, at the rate we're going today, we have time to get them here, because we need to get through the items where they are in the consent decree before we can get to all of those. Mr. Pacheco.
Madam President, colleagues, one of the differences between last week and this week, and my change of position from being against any agreement with the Department of Justice, really starts out in this area in terms of removing an activist judge as part of the process and removing a monitor from being a supervisor. So I would move that in paragraphs 44, 45, and in this whole area at 49, that the words "and the independent monitor" be removed, because in the draft it appeared as if the independent monitor was playing a supervisor or active role in deciding how to run the city. And under the new, what appears to be a new agreement, the monitor will do what we had always asked for, was basically be a monitor and report to the Department of Justice. So I would move the removal of that phrase in those paragraphs. Also, on paragraph 41, when it came to cost, one of the questions that was raised in our summaries sheets was the floating number between 15 and 25, dependent on the historical data, how far back. So I just want to know, what do the experts in this area indicate is the most appropriate length of history needed to determine an officer will be abusive? that may be, at minimum, the starting point in terms of what historical data. We should get some experts to tell us what they think would be appropriate. In paragraphs 44 and 45, I am asking, should the language include that both the design of the document and the protocol be approved by the council before it's transmitted to the Department of Justice? I don't see anything in there that says we have a role in approving the design or the protocol. I would like to know, do we want to take on that role as the council? I personally think we should have that role as the council, but it's not in the document. And I'm not going to assume it's in the document the way the language reads, so I want some clarity on that area. And the last thing, on paragraph 45, it seems to be urging supervisors to conduct on a regular basis to review an officer's Teams 2 record, which I think is appropriate, but I don't know what the definition of a regular basis is, or is it going to be left at the discretion of the supervisor? And finally, should there be a distinction in Teams 2 between those regular basis reviews and reviews that are based or emanate from a complaint or investigation? Because it could have an unanticipated negative impact to have a lot of reviews and not distinguish between routine reviews and those that emanate from some sort of investigation or complaint. So I obviously I believe that with the new developments, this is a document that will really protect the city from the courts and the federal government.
Perfect timing, right on 3 minutes. Now answer his question. He wanted clarification.
Well, first off, I think that eliminating the monitor is appropriate, and in the design document in 44, definition of city is mayor and city council. So in the definitions.
And is that spelled out somewhere up in
Right.
the definitions?
So in that case, the city council and the mayor will approve the design document for Teams 2. In 45, when the supervisor has the information triggered or what will be part of the protocols, and in 45, the department, which means the police department, chief of the police below, shall develop those protocols in consultation with the Department of Justice. And so that would, first off, that's how it would work. Those have to be set up before they're implemented, and that would be a department decision.
Okay.
So the design document will come back to the city council.
Ms. Zukowski.
Thank you. I didn't have a problem with the independent monitor here as part of this, and if they're not going to be part of overseeing it and supervising it, they ought to be a part of knowing what it is, because the monitor is going to be the one who's going to be reporting on the audits that are based on this system, so it's a lot better, as I think one of the other council members said earlier, to have the independent monitor know what we're doing. And members of the council, I actually rose on this one just to say and invite all the members of the council to get the information from the CLA and the police department when our consultant who is doing this program is in town and shows us the prototype and shows us what they're developing. I was lucky enough to see it this summer, and I can't tell you how much seeing this system as a prototype helped explain and clarify all of what's the capabilities that we're going to have, what we need to have, and the information, not necessarily on the individual officers, which will also be there, but needs to be relatively secure and relatively have firewalls on it so that there's not the invasion on the individual officers' personnel records. But the auditing that we're going to get, where, as Kelly indicated, alarms are going to go off, or little yellow flags or something, based on the protocols we'll set up. And once you see this system operating, it truly is a shame that we didn't do it sooner. And although Mr. Wax indicated that we only got $160,000 from the DOJ, I think it's fair to point out we got that just to begin the study, to go out and do and hire a consultant and get an assessment. The Department of Justice also told us that once we have that system ready to go back, we can go and submit again to the COPS federal government grants, because they have money for the implementation of these programs that have been utilized in other cities. So although we only got that small increment, I think we can go back for perhaps not ongoing monitoring of it, but at least a good chunk of the money that it'll take us to pay for this. And is that correct, Mr. Deaton?
Yes, as soon as I'm finished with this, I think we should go to Washington.
Okay.
But I think Mr. Wax is correct. Thus far, we've got $160,000.
Right, but thus far we haven't done anything either, and thus far we haven't done what they said to do with $160,000. So I don't think
We're
it's
very
fair.
close to
No,
that.
no, no, but I think his point was that the public thinks that the feds have already funded us for this, and therefore that we have simply ignored it. And what your point is they've promised to help fund it, but they have not yet funded it, and we have not, that's why we haven't done it.
Because we really didn't utilize the first increment of money to go back to tell them what it is that we needed and wanted. But basically, I just wanted to underscore that it is important to see this system, because once we see it, I think there will be a lot more enthusiasm, interest, and willingness to go to Washington to do all that we need to get this system in place, because it really is a marvelous tool that I think will be telling us, not only individually, but collectively, where the department is going. And that's why it was part of the Christopher Commission reform, the most important item back when, in 1992.
Mr. Padilla.
Thank you, Madam President, and if I may relay your reminder that although we're asking a lot of questions and making a lot of comments, we're also introducing plenty of motions, so as best as possible, if we can submit those in writing. I don't have a motion, but I do have a few questions. First of all, because I don't think it's been done, and there was a critique or a criticism by one of my colleagues just a few minutes ago, I want to thank the negotiating team for the months of hard work that they put into this. And you know, we can have our own opinions about whether or not it should have been done in open session from the beginning or not, or in the public's eye or not, but I can tell you that it's because the negotiating team did such a tremendous job that we have the proposed agreement that we have before us today. If you know, and actually we all heard what some of the requirements and mandates that the Department of Justice started with several months ago. I think it's to the credit of the negotiating team fighting on behalf of the city and advocating our position that has scaled it back to the draft that's before us. So I want to acknowledge them for their work. And to give them a little bit more work, I wanted to, as some of the other council members have spoken about, yes, we appreciate the Department of Justice's original seed money, but direct them to formally, in the process of these negotiations, ask for more. As Councilmember Pacheco probably speaks the best, if the Department of Justice really wants to be a partner in improving policing in the city of Los Angeles and a partner in achieving some of those reforms, and they should also be a partner in committing some of those resources and sharing in some of that financial burden. And finally, I did have two questions when it came to paragraphs 45 and 46. In paragraph 45, it talks about developing the protocols for using Teams 2, and it speaks generally later on in the document about adding supervisor training for using Teams 2, and wanted to ask whether or not this was an appropriate time to talk about how that training is going to be incorporated for managers and supervisors to utilize Teams 2 as a tool. And in item 46, it talks about when an officer is transferred or promoted from one area, bureau, or section to another, that upon their move, that the new supervisor review Teams 2 for the background of that police officer. I know their supervisors periodically review that, but I'm wondering if just before that move or just before that transfer is made official, if one final review by their previous supervisor is in order.
I think those things are going to have to be worked out in the protocols that are in 45. Basically, the police department is going to have to sit down and decide what kinds of reviews and when they happen and how many, the criteria, and then having established those, what kind of training should be used to make sure the supervisors follow through with that. We have, at this point, we're going through the design of the gathering of the data, but I think there is a lot of work to be done that's represented in 45 and 46 about what you do as a result of having that data, what's the significance of that data, and then how do you train people to use it effectively. So I think at this stage we've been concentrating on the data and the information, and I think once this gets implemented, this agreement, we're going to have to begin the process of looking at protocols, which is the essence of how to use it, and we are not very far along. By the way, on your Department of Justice, I've already indicated to the Justice Department, and they indicated with a successful conclusion of this, they would go hand in hand to the other part of the Justice Department to try to assist us in getting money.
Mr. Savornich.
Thank you, Madam President, members of the council. I have found the discussion so far to be very enlightening, but the one thing that I fail to understand is that I believe that there's a predisposition as we entered the discussions this morning that even if we went paragraph by paragraph, word by word, sentence by sentence, there is a disposition of a majority of the body to get on with a message back to the DOJ that we are willing to agree to a consent decree. The question that I do have is that, is there some type of a timeline that the Department of Justice has in regards to our either agreeing to what is on the table versus not agreeing to that? Do they want an answer from this city government October 1st, November 1st, December 1st, the 15th of any of those months? Is there a deadline by which the Department of Justice is expecting an answer? No matter how long we deliberate, no matter what issues that we bring up, do they expect an answer in short term, long term? I'd like to know, and then I have a follow-up question. Well, what is that? Do they want to know by what date? Is there a date that they have in mind that we don't know?
They have not said specifically, but I get the impression from discussions that they would like to have the thing wrapped up by the end of the month.
This month?
This month.
Well,
September.
according to my calendar, that would be a week from Saturday.
That's it.
No.
That's,
Which takes
October
that.
1st is, coming up real quick, 2 weeks from
understand.
Sunday.
Well, perhaps
And
we should
so-
move the
I'm not-
agenda then.
And so my follow-up question would be, is that I believe that an issue of this magnitude should have had greater participation on those who are going to be most directly affected by any decision that we make here. And number one, that should have been the citizens of this city. And we should have included them in public dialogue, in parts of this city, as was articulated by Mr. Wax last week, much earlier in this process, much as we did to the charter. And number two, I believe the representative unit of the officers under which will have to work under this consent decree should have been brought into the process a lot sooner. And now I am being told that we have 2 weeks to make a decision and get something back to the Department of Justice, which will forever change how Los Angeles is policed. The second thing that I'd like to hear is that, is there any type of a sunset in regards to the consent decree? Because, as I recall, the consent decrees to which the City of Los Angeles has entered to, not only in the police department, but in other departments, have not sunsetted. In fact, I don't recall one ever sunsetting.
Okay, your
And
time
so-
is up,
yeah,
Matt.
so the
Let's
question
try
that
to
I-
get an answer to your
Thank-
question, is there a sunset?
Thank you, Madam President.
The proposal before you that was presented by the Department of Justice, we haven't spent a lot of time negotiating this, but they're proposing that the consent decree would continue and could not be terminated any earlier than 5 years from the date of the agreement, provided, however, that the city was in compliance with the agreement for the prior 2 years. So there's an unlimited term, but it's also saying it could be terminated as early as 5 years if we're able to demonstrate that from years 3, 4, and 5 that we were in compliance with the agreement. So that's how they've done other consent decrees in other areas. It's certainly something that the council could give us direction on.
Yeah, but let me just point out that at the moment, we're discussing Unit 2 of this, and we've deferred the question that a couple of council members have started to address, which is the question of whether this will be done in the form of a consent decree or not. Mr. Fewer.
I just wanted to rise to underscore what Ms. Mizikowski said on this item and for other items as well, that it's appropriate for the independent monitor to be apprised of the information, and that while we, I think, should be eliminating the consultative role here, we should not be precluding the monitor from knowing what's happening when it's happening, and to that extent I would differ with Mr. Pacheco's motion and support the spirit of what Ms. Mizikowski was saying.
Ms. Goldberg.
I think if you start back with the Christopher Commission, this may be the single most important part of this document. Because without information, you have no way to do risk management prevention, and you have no way to detect internally patterns in practice if and when they exist. For us to be trying to keep the monitor out, I think is simply to miss the point. And the point is that we haven't done this. and that we are going to continue to be struggling and fighting over how to do this, and we're going to worry about the money, and we're going to worry about this and that. The $20 or $25 million, I believe, will end up being nothing compared to what we pay just in lawsuits for the current problems that we're in. And I really object strenuously to changing DOJ's language on the role of the independent monitor or the role of DOJ in the formulating and carrying out of this particular part of this document. Because I think that if we come back 5 years from now, because we left them out of it and we managed to find a way to make it a little more palatable politically, blah, 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 and we haven't really done this still 5 years from now, I can't even imagine how we could possibly say that we didn't do everything we could. Now, there are many other areas in this document where I'm more than willing to take the negotiating team's position. This is not one of them, because this is too critical. And I do not want the DOJ or a monitor to come back and say, had we only been involved in this, X, Y, and Z wouldn't have had them. I want them on the hook with us. I want them to approve it and consult with us. And then I want them to be on the hook with us about taking responsibility for it if it isn't what is necessary to deal with the problem that the Christopher Commission spent, maybe even an entire chapter on.
Okay. Mr. Hernandez.
No, Mr. Hahn, in reading your recommendations, you're recommending that on items 44 and 45, we basically have language that allows for us to, in consultation with DOJ and the monitor, obtain pre-approval. Now, your word pre-approval versus approval, is there a difference?
No.
Okay, so you're basically recommending what they are asking.
Yes.
And that be done in conjunction up front, and that way we don't deal with it afterwards, which is the same thing Ms. Goldberg basically said.
Right.
And Mr. Deaton, do you have any disagreement with that recommendation?
So long as DOJ is the approval, and we consult only with the independent monitor. The independent monitor is not in the decision-making process.
Right, but my understanding, this would happen previously.
And so long as it does not hold up the development.
Okay, and Ms.
In other
Martin.
words, I'm just sharing, I just want to be sure, because the monitor is not on board. If the monitor for some reason is on board and we have to wait for them, then I don't want that to be, I want to have provision in here that we do not get dinged or we don't get slowed up because there's no independent monitor to
And I think, Mr. Hahn, would you agree with that?
Yes.
Mr. Hahn agrees with that. Ms. Martin, I just want to know, see, I'm trying to get everybody, this is one of those areas where I sense some disagreement, so I'm trying to get all sides so that I can understand all the arguments.
I think, just 1 second, Kelly, before you start, at the same time
Yeah.
as you're doing that, it would be helpful. My reading of this is not clear that our negotiating team objects to the monitor being involved,
Right.
except insofar as Mr. Deaton just described that we don't want to have to sit around waiting for a monitor.
Right, and
So it's not a
think-
disagreement there. Mr. Pacheco, however, moved, I'm not deducting.
Yeah, I understood Mr. Pacheco's movement, and I'm just trying to get all the views here of the issue.
Okay, I'm sorry, go ahead, Kelly.
I've heard three different positions. I've heard Ms. Goldberg's on the one hand, which says monitor, as DOJ has put it in this agreement. I've heard Mr. Fuhr's in the middle, which says monitor role is a consultation role, kind of like what Mr. Deaton said. And then I've heard Mr. Pacheco's on the other extreme, which is monitor comes out. I'm in the middle view with Mr. Deaton, and what Mr. Hahn has said here, which I think I heard was different than what Ms. Goldberg said. Now, either I heard a distinction that doesn't exist, or there is a distinction there, but I'm in the middle with Mr. Fuhr.
Yeah, may I just clarify my view is? My motion is that DOJ on this point have authority to approve what we do here. I think it's very important that we not end up in the position, in fact, Ms. Goldberg described, which is they disagree that we did the right thing in the first place. I do not, however, think that the monitor should have a decision-making role in this. DOJ should, the monitor is a reporter, not a decision maker, but DOJ in this one instance at least should be a decision maker with us. That's my motion.
Okay, now you have to get back in line. Mr. Pacheco is next.
I was going to try to digest what Mike just said quickly, but I think he's on the right track. Michael Fuhr, I'm sorry, to distinguish between Hernandez and Fuhr. But I think he's on the right track in the sense, but which begs the question is, when we invite more people to the table, I usually like to have people at the table who bring something. And I don't know what the monitor brings in this area of discussion. I understand Department of Justice is well staffed to help us design these teams too, or have any concerns. But I really don't see what the consultation of the monitor should be. I fully agree that the monitor should be trained, understand, maybe need some computer courses on understanding how to use the computer system, because with all due respect to most people, computers to many of our more prominent leaders is a foreign thing, because there's a recent development in terms of the information age. And so I understand that we want the consultant or the monitor to be
Are you telling us
educated.
we're getting old?
No. I'm just saying that certain people are more adept at computers than other people, and it tends to be that my 13-year-old and 14-year-old, my 13-year-old daughter is much more adept than I am. And so all I'm saying is that I don't understand why we need to consult with the monitor when we have the Department of Justice and the city agreeing on what this should be, and we still need the Department of Justice agreement. So I think Michael Fuhr is in the right direction, that we definitely don't want a monitor who has a decision-making role. That's really where I stand. So if that's the motion, I can support that motion. I just thought the clearest thing to do is to eliminate the words in this language, and that would just clearly make it consistent with what Mr. Fuhr's motion and my intent is.
Okay, thank you. Mr. Chaliff.
Just a couple points. First, the language lays it out the way I think Mr. Pacheco and Mr. Fuhr said it, which is the monitor gets consulted, DOJ gets to approve it. Second of all, in our discussions, I felt, and I think they stated it, DOJ is willing to put in time limits so that we give them how many ever days we think is necessary, 15, 30, whatever it is, and they either have to come back and say what their objections are, or approve it, or if they do nothing, it's approved. And then they can't come back later and complain. So it isn't an open-ended process. At least that's what I envision us coming back with next time, is some closed-in time limit process.
Okay, so it sounds like there's more consensus here than we first thought. Ms. Walters is next.
I have no problem with the suggestion that the monitor is a consultant and the DOJ is the decision maker. But I also have no problem with the monitor being a decision maker here. It seems to me that in the course of things, there's so much involved here that there really are going to be times where it'd be very convenient for the monitor to be a decision maker and participate. You don't have to stretch it out and go to DOJ and then back to the city for that approval. So I really feel that we don't need to do anything that DOJ perceives as putting a stumbling block in the way, or trying to structure the process in a way that would allow us to make changes that they have not approved and that we're trying to keep them from approving.
Ms. Mizikowski.
I think we've reached the consensus that I was going to make the motion similar to what Mr. Fuhr has, and I think basically it takes the direction from the city attorney, which acknowledges the consultation with the monitor, the approval of DOJ, and I think in answer to Mr. Deaton's concern that we not let this somehow drag us out either before the monitor is in or just in taking more time, because it may very well be that we will be into this part of it before we even have the monitor, because this is something I think everyone that does have consensus is important. We are getting feedback from our consultant. So I think that characterized somewhat under the recommendation of the city attorney indicating DOJ approves, monitor consults, which I think is just reaffirming some of the language but clarifying it, is the way to go. And I think as you indicated, I think we've got consensus generally on that issue.
Let us hope. Mr. Fuhr.
Wanted to clarify my view. It's been done. That's enough.
Mr. Hernandez.
You said it for me.
Goodness. Mr. Pacheco.
I want to speak on another issue when we get to 45 subsection A, so that's all.
Okay, so we are now, I think we have a consensus with respect to the monitor's participation. Do we need to go back through that?
DOJ's
And
approval.
DOJ's approval? No?
Yes, and
Yes.
we're to negotiate on schedule and approval cycles and things like that.
Yes. Now, do we need to go back through, Mr. Pacheco mentioned a specific question on 45. Do we need to just go through these?
Madam Chair, before we do that, 38, there was a motion for me to include the city attorney. I think there's a consensus on that as well.
Yes, was there a consensus? I'm sorry, I forgot. I actually have that written down here.
No problem.
No problem with that.
Just so you
Mr.
understand,
Chaliff.
we may have to write in language that keeps part of the city attorney's office out of it, criminal prosecution angle, and some others, so there has to be differentiation.
Understood.
There is a risk management group that the city attorney participates with, the
Right.
police department. I think that'd be the appropriate place.
Okay.
Thank you, Madam Chair.
So we're clear on, we're okay on 38. All right, now, do you want to just run through these?
Right, and
Pa-
39, we just so everybody's aware, we've limited ourselves to two alternatives. I'd like to probably change that language to leave it a little more open to give our different opportunities other than just it's not a big deal.
Wait a second, this is on
Make the system.
on 39?
Right. Purchasing or licensing.
Oh, I
We
see,
may
okay.
want to, or programming a new system, although we're likely to be doing B,
Okay.
just a
Does
little
anybody have
widened
any
up.
problem with that? Ms. Chick? No.
Par-
That was 39, okay.
Paragraph 40 is two issues. One is, the first issue is 40L, I believe.
Can I just mention before you get to 40L, I thought it was nice that there's a provision in here to take account of compliments as well as complaints. When I first read it, I thought it was a typo, and then I discovered it again, and I do think it's important to have the good information as well as the bad.
And it was interesting in Pittsburgh to see the protocols and that there was a certain member that did some things. So it's kind of,
No, because we actually get a lot of mail in my office, and I'm sure in all our offices, commending the police department and individual police officers, and also the fire department for being helpful and protecting and serving, and it would be nice to have that filter in as well.
for the most part, they do.
I should hope
They
so.
do.
Okay, go ahead.
40L is a
40L.
drafting issue. They want to, as we stated before, city now means mayor and city council. They, I think, want the city attorney on the hook as well, and some other people.
And
So
do we
have no
we
problem, so
no
we just
problem
need to
with that.
draft it.
Okay. Ms. Chick, I have you listed here for which one? Well, all right, this is 40.
Okay.
Go ahead.
This is 40. On N, which has to do with arrest reports, crime reports, warrantless searches, traffic stops, and pedestrian stops. Actually, that's a discussion, this is just the Teams 2 part of that. Actually, the discussion on that item we wait until 67, paragraph 67 and paragraphs 108 and 111, which is the substantive issue, and whatever is resolved there, we will incorporate in Teams 2.
Okay.
67 and 108 and 111. That has to do with the arrest and warrant, the searches, et cetera.
Okay. Ms. Chick, you want to wait then, or you want to?
Yeah, I guess on 40, I just wanted to know, I wanted to know how much of the list of things here that we're supposed to take information on would be new things. I thought a lot of this list made a great deal of sense, and I think I was under the assumption that the department is already keeping this information. Am I correct? Mr. Hahn is saying yes.
I think for the most part, all of it, some of it, I think there's a few lawsuit things that are not necessarily being kept right now. However, they are in 12 or 14 different other systems, some of which we're going to have to replace because of accuracy and timeliness in order to be able to feed into one system. So part of this is the Department of Justice's request for this kind of data. It's not that we aren't collecting it now. We're not collecting it in one
how we're
system.
collecting it, right.
It's not timely, it's not accurate, and it's not in all in one place.
Right.
And it's not on a system that you can, if you will, do a matrix of by employee or by unit or by...
Right. Well, it doesn't make much sense to keep information if it's not giving us what we need. So
Right.
now we're going to keep it and keep it in a way that we can use it.
and make sure that it's accurate and used for management purposes.
Okay, and the rest of the discussion, you say, is going to wait until items...
67, 108, 111.
That's
Okay.
for paragraph N.
Okay, I've
So
got
we'll just-
some other
we'll eventually
comments,
get
but
there.
on another item you
Right.
haven't come to yet.
Yeah.
Ms. Goldberg?
In Section 2, which is, as I said before, in my view, probably one of the more critical issues of this whole business, we don't really talk about, or do we talk about, a couple of things that were in the Chemerinsky et al. Report, which is requiring an analysis of the data over some period of time for divisions, the department, and individual officers. Do we have that anywhere?
Well, definitely for the officers and the, let me,
For individual officers, I know we do, but do we look at it also for divisions in the department? Which, if we don't,
Units are on it.
It's in the audit sections.
it's in the audit section. Okay, well, I'll come back to it then. There's also a recommendation that the data be used in consideration of command staff promotions, pay raises, and assignments.
if you might just turn to page 18 of my
Okay.
chart. And first, and I think it's important, the protocol shall require that on a regular basis supervisors review and analyze all relevant information about officers under their supervision, detect any pattern or series of incidents that an officer, a group of officer, or an LAPD unit under his or her supervision may be engaging in at risk. Second, a protocol shall provide that when at-risk behavior may be occurring, et cetera, that appropriate management shall undertake a more extensive review. And finally, on the next page, G, information in Teams 2 be taken into account when selecting officers for assignment, the OHB, units covered, pay grade advancements, etc.
Yeah, but I'm actually looking for a tweak on G. And the tweak on G I'm looking for is accountability for corrective action and supervision by lieutenants, commanders, bureau chiefs,
Try I.
deputy chiefs. Is that I?
Try I.
Okay.
Now, those are just so...
I have too many documents, that's why I need
Well, I
to
know,
help in
and
figuring out where they
that
are.
makes
Yeah,
at least two
it
of
is
us.
paragraph I, but that's
Okay.
item 46.
Okay,
So can we...
I'm sorry. Okay.
No, that's fine. I just want to keep us on track
I
as
have
to
no
where we
problem
are.
with trying to keep
So
on
item,
track.
thank you.
I'm just,
Item-
I have no way to go from all of these
Well,
documents.
no, I
one from
welcome
another.
your help. I don't either.
Okay.
All right, so we're still on item 40. Item 40 basically describes the type of information, the table of contents of the information collection.
Data items.
Data items, thank you. So on item 40, do we have any more specifics? Mr. Pacheco? No. Mr.
Not
yes?
item 40, in
Okay.
this area, but
Yeah,
not
well,
item
we're
40.
coming back. Stick around, Mr. Wax, on item 40?
Are we including the information on racial profiling here?
No,
in
we'll
this
discuss
discussion?
those in 101 and 108.
Okay, then I'll hold my discussion for that.
Okay, very good. Now we have, item 40 is now behind us. Moving,
No, no.
no, it's not. Sorry, Ms. Goldberg.
Did we agree that we are going to take N out? Did this?
No.
Sorry.
Oh.
What was said was that the substantive issue is in paragraph 67 and 108 and 111, and whatever is decided there will drive the data item.
Will be looped back into this one.
We'll just do that automatically depending on what happens there.
Okay, 41. Anybody up for item 41? I see no speakers. Yep, now I see a speaker. Ms. Goldberg.
Well, on 40, is it 41I or is it 40?
41 is the historical data.
No, I'm sorry, wrong number.
Wrong number. All right. Mr. Pacheco.
That's the one I had a question on in terms of when the issue of cost was raised, we had a sliding scale because it depended on the length of the history. And my only question is are we getting any guidance from a legal expert, or not say legal expert, an expert in police reform, as to how much history will help us in determining an officer will be abusive? I just, who's helping us decide that sliding scale, whether it be 5-year history, 10-year, 15, 20? Are we getting any help from anyone? I just feel that we're just sort of the blind leading the
Firing
blind.
blind here, yeah.
So
Okay, members of the staff, negotiating team, we getting any help on that one?
I think the decision's being driven more by how far we can go back. We're looking someplace in the neighborhood of 3 to 5 years.
Based on
The
what
cost,
data we have available, or?
The availability of the data, the ability to make sure it's accurate, and the cost to do it. And we're looking at, so we have a context of going forward of either in the neighborhood of 3 to 5 years.
Okay,
Where
so
we're
that-
looking at the money.
Not to be rude or anything, but I'm going to be rude. Then what's the decision that you're asking me to make? If the decision's being driven by factors that are out of my control, then it seemed like I had a decision to make here, so I wanted more information to give you a decision, but it doesn't.
I think as a practical matter, at this moment, you don't really have a decision.
Right.
This is sharing with you what they're talking about with DOJ.
But actually, you've made the decision in your first action relative to giving us guidance relative to making sure the schedules are taken into account what we have to do, because in this particular instance, depending on how far you want to go back, it could, and before you implement the system, it could adversely affect its implementation date.
Oh,
okay.
Thanks.
Does that
That was
come
very
close
helpful.
to what you?
That was very helpful.
Well,
I'm glad
I
you
guess,
liked it.
Ron, look, let's.
I'll pass on it for now. I mean, there's
Okay,
other bigger issues,
But is that something where when you have these further discussions, we're going to have another opportunity to look at it, where you're going
Right,
to say,
we'll
if
come
we
back.
do,
We're
if we
gonna
do
sit
10
down.
years, it'll cost this much, and
Right, we'll sit down with DOJ and explain, now that we have some information from our consultants, how much money it will cost,
Right,
how much time delay, what
but
the
I
schedule.
think Mr. Pacheco's concern is if he has to make a decision on something, he'd like to know at the appropriate time what the
Right.
factors are. So
What we're
is that
saying
gonna
right
come
now
back to
is,
us?
given the information we have, we could not agree to a 14-month implementation date, not knowing how much and how long it was going to take us to do the historic.
Right, but once you have all this and you
We will
go
come
to
back.
DOJ, you'll then come back to us, so you will have another crack at it. Okay, Mr. Hernandez.
Mr. Deaton, my understanding from your response is that basically all we're doing is agreeing that we will implement what we both agree on that particular item.
We're going to sit down with DOJ and explain that it takes a certain amount of time now that we have the idea of how much and how long to get historic data now that the consultants looked at it.
Right,
And
but
that
the
we'll
consultant
incorporate
hasn't
that in the
looked-
schedule.
The consultant hasn't looked at it yet.
They're in the process of doing it
Right,
in the
and
next week.
DOJ is saying they will let us know their response when we tell them what the implementation schedule is going to be. I mean, that's what it says according to the
It's a
notes.
bit of a moving target.
Right, so right now, the position of the city is, whatever that implementation schedule is going to be, is depending on this historic data gathering.
That's one of the factors.
And we both have to agree to that.
Right.
Okay.
You know, and this is also one where the council, when we come back to you, you can decide whether or not the proposal that we've made in terms of how far back we go in historical data is something acceptable to the council or not. We're going to try to negotiate what we think is the most feasible thing for us to do in the most reasonable time and with the objective of getting teams 2 up and running, but obviously that's something the council can determine when we bring that
And
back to you.
also getting the information we need.
Yeah, and that we can legally use, because my understanding is there might be some state statutes that limit our ability to use something for purposes of personnel records.
Right, and we have to also be sure that it's accurate, because of what we're going to use it for.
Ms. Mizikowski.
Again, I think I was going to rise to move essentially the negotiating team language as informed by Mr. Hahn's letter on paragraph 41, which basically says move forward with all due haste on teams to put aside the issue of historical data, how relevant, how quickly, how easily can we get data maybe a couple years back as opposed to 10 years back, but let's not let that stop or inhibit us from moving forward with data collection now, and everyone's in agreement, and have this serve as a little subunit, doing it as best and as fast as we can within relevant data, but still move forward with teams 2 from this point forward and everybody getting onto that. And I think that's what the language says. I think that's what Mr. Deaton has indicated. So I think that there's not a significant dispute about that.
All right, that seems to clear the board here on item 41. So can we now move to 42? Anybody
42
have
and
anything?
43 are both items that are agreed to both sides and
All right.
are non-controversial.
Mr. Pacheco, on 42 or 43? No. You have to watch the trigger happy there. Item 44.
44 and 45 we've done.
We've just discussed those.
Okay, Mr.
So
Pacheco,
40.
which one did you want so that I can call you at the right time?
46 right now.
Okay, I think we're ready. 44 and 45 are now behind us. 46, Mr. Pacheco.
Earlier, I misstated when I was raising my concern about a regular basis. I thought, I stated it was a part of 45. In reality, Ms. Walters corrected me. That's part of 46, subsection A. And I have two questions there, one in subsection A and one in subsection M. A is really, it says that the supervisor on a regular basis, this is separate from the bells and whistles in my mind in terms of the automatic triggering because of a certain amount of complaints. That's what it reads, I should say. I can't really say what it really is because that's what it reads. That on a regular basis, the supervisor should do reviews of teams 2 for the officer, whatever officer, all the officers under their supervision. My only question is, are we going to define regular basis or is it left at the supervisor's discretion? And second of all, should there be a distinction in the actual record that's being computerized that it was a routine monitoring a review versus a review that was triggered by some sort of investigation? Because as you know, everyone's experience, if you look at someone's personnel record and you see a bunch of reviews or a bunch of investigations, they tend to sometimes prejudice the person reviewing the file without even going in depth as to what the resolution was to that review. So I want to make sure that there's some sort of distinction to protect those that are regular reviews versus initiated by some sort of malfeasance. And then on M, I couldn't tell reading the language, is it the officer's new or old watch commander or supervisor that promptly reviews the team's 2 record? And let me just say that the only concern I had about the current supervisor, which I call the old supervisor, doing the review, is that if it's the intention of the supervisor to basically move a problem officer, and that's their goal, is to just move them, I'm concerned that they're going to review the record and come out with a favorable result just to get rid of them and put them in another unit or get them out of their unit. So I'm not sure what the actual language reads. Is it the new or old supervisor or watch commander? Because I know I have seen in the school district where problem principals are just sort of rotated around, and that, I don't want to see that happen here. If we have a problem officer, it should be dealt with. So that's my 2 questions on those, subsection A of 46 and subsection M of 46.
Okay, who wants to respond to those?
On M, it's intended to be the new supervisor.
Wait, we don't have your mic on. Hold on. Can you get her mic on? Okay, go ahead.
M was put in, it was intended to be the new supervisor. One of the issues that came up in the course of the negotiations was DOJ raised an issue about whether or not Teams 2 could be used to prohibit people from moving geographically within the city, and the team felt that that was not permitted under existing civil service and employment rules. And so what we said is anytime somebody moved, we would then make sure that the new supervisor knew the kind of person they were getting under their command and take a look at them.
Okay.
And the first part, regular, will be defined by the protocol.
Right.
Okay. And is there going to be distinction between a regular routine review versus a review initiated by some sort of malfeasance?
Right. There will be
Okay.
the distinction, and in fact, the record that the supervisor will make that will also go into Teams 2 when they complete the review will note the purpose of the review and why it was made.
Okay.
Ms. Goldberg.
Yes, I've now had a chance to look at 46 thoroughly, and I do not think it covers the issue that I am trying to cover. It does cover part of it, but it doesn't cover all of it. And so I would like to move that we have a 46 letter N, and letter N would say something like, the protocol will include an accountability measure for the volume of officer complaints and corrective action with respect to the command staff, lieutenants, commanders, bureau chiefs, deputy chiefs, and the chief of police, and that the data should be used in consideration of command staff promotions, pay raises, and assignments. The other talks about supervisors and managers does include the command staff, but sometimes people don't assume that. They think that it's just department level. I want to be sure that we're very clear that we're talking about accountability at the highest levels. Well, you can. If there's a more, I don't care, I have no investment in making it a separate item. If there's an elegant way to make sure it gets included in existing pieces by spelling it out, I have no problem with that. I just want it included in 46 somewhere. And you can maybe add it to E, parts of it, and maybe you could add some of it to I. But I think that the notion that I'm trying to get here is that there should be an accountability for not only the volume of officer complaints, but also the corrective action with the highest, with the command staff. And that whether or not that gets done or not, should be a part of looking at command staff promotion, pay raises, and assignments.
I'm sorry to be confused.
That's all right, I'm a little confused myself trying to put all these pieces together.
What do you mean by volume of officer complaints? If someone under your command gets a lot, so for example, if a 18th Street gang is sophisticated enough to figure out that they can get somebody who's effective moved from their area by making a lot of complaints that turn out to be unfounded, that somehow should be impacting the command officer's review? I don't understand that.
Here's why I would say yes. It's not in every case, because there are, as you and I both know, except for the example that you just used, someone who decides to try and do this, a lot of things that we can teach people on how not to get complaints.
Right.
Okay, I want that part to be part of the accountability, that the command staff needs to have some proactive role that we hold them accountable for, that short of someone just trying to get somebody, which I think will be quite apparent in the number of completely unfounded statements, and that would be taken into account, doesn't mean negatively. It just means I think that we should be looking at it, because what we don't see in a lot of places is proactive behavior to get people to understand that there are things that you can do to reduce the number of complaints that you get.
Okay.
Perhaps, I mean, the challenge I'm having is taking the concept, which I understand, and then turning it into legal language. So maybe the negotiating team can.
All right, well, I want the issue addressed. I'm not in love with the language I used, but I want the issue addressed, that it be the lieutenants, commanders, bureau chief, deputy chiefs, and chief of police who are held accountable for looking at this problem and and also the issue of corrective action.
All right, but first of all, your time's up. But let me just interject something here, since I don't get to do this a lot. I think it's important that what we want them to do is exercise good judgment. We want them to look at it. We want them to exercise good judgment. We had a situation in Pacific Division where we had a police officer who was absolutely wonderful. The whole community loved him. He cleaned up all kinds of places that needed to be cleaned up. The gang members who were the targets of his cleanup efforts filed dozens upon dozens of complaints. And this poor guy, who was absolutely a sterling police officer and still is, but if you looked in the data, his commanding officers up the chain of command would find a ton of complaints, all of which, I think, as far as I know, all of them were found unfounded.
Right.
So what we're asking, and this is part of the challenge in putting the language in, is that when we ask the command staff to review all of this, one of the things they might take note in that case is that this guy was doing such a good job that the gang members had no choice but to file complaints against him because they couldn't think of anything else to do to outwit him.
And the accountability that I'm looking for is not to say that that there's something wrong if they fine for the officer. The accountability I'm looking for is that if they actually didn't review it, and subsequently it turns out that this was not your sterling officer,
right,
that they be held accountable.
Right. Yeah, for not having reviewed it and taken action.
Not having looked into it, not having made the appropriate corrective action, because in part, that's my analysis of what happened in Rampart.
Okay. Now
Not
we have,
entirely,
Now
but
both
in
you
part.
and I have to stop so we can let Mr. Hernandez talk.
In these reviews, looking at a bureau, looking at a department, and looking at a bureau, what is to stop in these reviews? I guess the the placement of troubled officers in terms of a larger percentage in a particular division?
Department management.
Right, at what level? And where's that reviewed? And when I first got elected to office 10 years ago, that was an issue that was being discussed, and when we were doing our reviews, we were finding a higher percentage of officers with problems being placed at Rampart for whatever reason. And so one particular division was dealing with other kinds of issues, while the rest of the city was basically moving along. And so as I'm reviewing this, what is to stop that kind of action? Would that be the chief's responsibility? Would be the bureau, the commission? I mean, how are they going to review it from a system-wide placement where these officers are and so forth?
It's the chief's responsibility, and this system would give them the information to
Would give us the information
very
too.
quickly to find out by trends where certain kinds of officers are ending up. It would be very quick and easy to determine that information. And so I think it's the chief's responsibility. The deployment is the chief's.
Ms. Walters.
And his question prompts another question from me, a question that was a real problem in the school district. The matter of assignment. How are new officers assigned? Do they only go certain places? They only go where they want to go? The chief assigns them, you know, one to one division, one to another, right down the list? Or how is that done?
I think for patrol, that's the way it would be done. For specialized units, I think there's a provision that their records be reviewed and see if they're appropriate for those specialized units. But patrol has so many changes that it would be difficult to make those kind of reviews before each movement of the movement.
Aside from this, I would like for the department to provide data on the precise methods that are employed in assigning new officers right out of the academy. Do the new officers get to indicate a preference, and is that preference adhered to? How does the rotation process occur? And as you said, there's so many changes.
Right.
How often does that change occur? And with that, in each station, what's the average number of years of experience of the officers in each station?
Okay. That's separate and distinct from this.
That's separate and distinct
Right. We'll prepare a
from this,
motion.
but it was prompted by Mr. Hernandez's question, because one of the things that was and is going on in the school district, teachers get to indicate their preference of going to which area. So, you know, nobody prefers to come to inner city. And so then the union's only agreement, their concession, was that the new teachers would all come to inner city. And so they're no longer new after 2 years, and then they transfer out. So the experience factor, I noticed a lot of these in the Rampart division were 5 years and under, right around 5 years. I don't recall, except for Perez and Durden maybe, we didn't see the seasoned officers there. But I'd just like to know, as an aside.
Fine, we'll prepare.
Right, I think but that's not to add into item 46. Right, okay, we're all clear on that. Now, on item 46, the only motion or
Right. I think
discussion point that I can remember that still requires some resolution here is Ms. Goldberg's suggestion, and Ms. Martin suggested that the thing to do is for you guys to take a look at whether there's a way to refine the language in 46 to indicate that it isn't just the immediate supervisors, but everybody up the chain who should be accountable.
Right.
Is there any problem with any of that? Have we achieved consensus? So you guys will do that, and
Right.
it'll come back around to us.
You
at some
stated
point.
it pretty clearly, Madam Chair.
I do my best. Thank you. Okay.
I'll put those words down.
Oh, well, it's on the tape. Okay,
Councilmember?
paragraph 47.
Before you go, 46G, just want to point out that we need to, it doesn't currently fully track the Penal Code Section 832.5, and we're going to need to fix that. Also, I've been informed that the PPL may try to broaden 832.5 in Sacramento, so we'll need to take that into account as well.
Okay. Nothing we could do about that here, though, right? I mean, not
Well,
at
we
this
need to make
moment.
some language modifications.
We'll just
but we
change,
will.
we're going to work on the language is all.
Okay, so we're done with 46. Everybody clear on that? Moving right along to 47. Anybody have any comments on 47? Seeing none, we're done with 47. We're up to 48. Ms. Chick.
Well, I wanted to know what the issue was, and in particular, because I think it's regarding tracking for 3 years after a police officer leaves the force, that there's been an objection to that. I'm wondering why. And obviously, it means holding the information for 3 years. We're not going to track an officer after the officer's with another department.
No, we both agree on 48.
We all do?
Yeah.
Okay, my notes say there's an open issue.
There was an
There's-
open issue, but we think it should be
But we've resolved it.
We've resolved it. How about
No
that?
questions.
Okay, are we all okay on 48? 49.
We've already discussed.
We've already discussed. 50. Mr. Holden left the room a while ago. I just thought I'd mention that.
50 is something that the Department of Justice brought up late in the negotiations, and it had to do, in part, I guess, because we were indicating the teams would take a little longer than they had hoped, and what would be done in the meantime. We haven't had any real discussion with them. We're willing to discuss it. Quite frankly, from my perspective, I would like to do partial implementation on Teams 2 to the extent we can, so we don't spend resources in implementing something that we won't be using in the future. So, like I said earlier, I think that there are parts of Teams 2 maybe we can get up much quicker, and that should be the intent.
So that item 50 is one that's still
Right.
under discussion. Okay,
And we
Ms.
would like it to
Goldberg.
a staggered
Well, we're
implementation.
not done with it yet, though, Ms. Goldberg.
Okay.
I just didn't understand, it says that the proposal is that in the interim, LAPD supervisors and managers shall implement to the extent reasonably possible all provisions of this agreement that require the use of Teams 2 data by utilizing existing LAPD databases, compilations, et cetera, et cetera. And the issue, as it's stated in the commentary, says, we're willing to identify how and to what extent such a transition plan could be achieved, but we won't agree to the language as presented. I don't understand.
Two things: it was late in the process, that this was, I'd say it was in the last week of the discussions. They thought of this item, number one. Number two, as stated there, one of the things that I've been most concerned about, and I think the team has as well, is that we know what we're doing, knowing what is expected of us. And this, if they have some ideas on what systems and what they want done, I'm more than willing to discuss that with them. I would rather discuss bringing on a staggered implementation of Teams 2 earlier for certain hot items, as I stated before, so I know what it is and we can deliver. I don't want, this
I
is
think the
ju-
way you described the issue is not what you meant to say then. Because it sounds like you're saying there's nothing we can agree to between now and when Teams 2 comes up, and I don't think that's what you just said.
And what we're suggesting is that since much of the agreement is requiring a lot of different things to be done in terms of the promotions and transfers of officers, that we think is dependent on a fully operational Teams 2 system. We don't want, if the Department of Justice is saying, take a look at all your 20 different databases now as if they were Teams 2, every time you make one of these decisions, we don't think we can agree to that. And so what we're saying is, why don't you allow us to phase in the requirements of this agreement to before we finish Teams 2 without requiring us to do everything that Teams 2 will do.
See, I would rather you take just a little more proactively and say, rather than phasing it in, why not go through and say, these are the databases we are willing to look at for these pieces right now while this system is being done? Because I think I know I am anxious for this to get started. I think everyone around this horseshoe is. I know the department is. So rather than say, that sounds like it's not, I don't have any sense that anything's going to happen. So rather than that, I'd rather have our position be, we can't maybe do everything that you want in 50 right now, but what we can do is to say is for these assignments, we'll use these databases.
Right.
For these promotions, we'll use these data. For this risk management, we'll use this material, and tell them what we are willing to do in the interim, specifically, so that there's some accountability in the interim.
Well, that's what was envisioned by my use of the word phase in. I agree with you that we need to be specific about which databases and in which ways that's going to be used.
Okay. It sounded to me like nothing until even part of the computer system of that we're calling Teams 2 is up and running. And that's what I interpreted this to mean. Then I don't have a problem if that's what you mean.
That's what
Everybody agrees that?
No. In order to do Teams, you have to, for example, everybody's got to get a computer every supervisor's got to get a computer they can get to. If we had those computers today hooked up to our databases today, that's one thing. I don't think technically 50 will work. The real question is what are the technical, and we just don't know the answer because they threw this on the table literally at 1 in the morning, the Thursday before we finalized this to bring to you. But what can we do technically, and what can we do in a way that doesn't cause us not to get Teams 2 done? And that's a fairly complex question, and I think we have to look at it from the technical point of view. No, I don't think anybody's objecting to using what you can use if you can use it. But if we could use it, we wouldn't need Teams 2, we wouldn't be where we are today. So it's the technical that really needs to be answered. And, Judy Steele probably has the best handle on all the technical of anybody who's not in the LAPD, but we just haven't had a chance to sort of work through what the choices are and what what's meaningful. It may be that there's 3 databases that are most impactful, that tell you the most about an officer, that are the ones you should really check, and it's really easy to check them. So those are the ones we can check, and we can do a manual fix at low cost. Terrific, let's move ahead. But if there's 16 and it's really hard to do it and it's very technically very challenging, somebody needs to sift that who's technically competent, and I think it should be the CLA's office. Outside the departments, you guys have comfort that it's been sifted appropriately, working with the department to get some information and then respond to that. And I think that's a somewhat different...
All I'm really looking for is assurances that it won't be 20 months before some of this starts happening.
That's what DOJ.
Because if it's 20 months before some of this happening, I think that that's an unacceptable amount of time to wait. Now, I'm not saying all of it has to happen, and if you're talking about having the CLA's office sift and give us some implications and give us a projected plan that could be implemented immediately, and then more of it comes online, which is what I heard the city attorney say, then I'm comfortable with that.
Thank you, Councilwoman. Does anyone like to respond?
Well, that's what we intend. That's our intent. Is that as I said before, it came on late in the process. We had an opportunity to look at what we might, and when I say that staggered implementation of Teams 2, I'm not talking. In some cases, I'm talking 2 or 3 months. Some of the stuff could be coming on. So it's not. I'm not talking a long time on some of it. I'm just saying that when Teams 2 is finished, is like 20 to 24 months. To the extent we can't do that, your concerns are DOJ's concerns. You couldn't have expressed it any differently. I understand.
Thank you, Mr. Deaton. Chair recognizes Councilman Padilla.
Thank you, Mr. President. 2 comments. One is, or speaks to the overall timeline again of Teams 2. I think we've overlooked saying the flexibility needed, not just for some technical components of it, but We never know what the unforeseen circumstances are going to be in the city. If we have another earthquake, if we have natural disasters or other states of emergencies. So we hope Justice will have an open ear when it comes to having flexibility in a timeline that we're committing to. But in regards to the phase-in program that we're talking about, I sense that we're getting mixed messages from the Department of Justice. Because on the one hand, they want us to phase something in utilizing existing databases or existing systems that might be Teams 2 comparable, but at the same time, they're telling us Teams 2 should not be an enhancement of what you currently have. It's going to have to be something new, something that's much more powerful than what's currently in place. So on the one hand, yes, I know we will all agree with the general statement. Let's utilize existing information, databases, files, et cetera, to the best of our ability between now and when Teams 2 comes online. But my concern is that at that point, given other requirements of this agreement, given other demands on the department when it comes to policing, that we'll begin to take attention, energy, and resources away from those things to have a patchwork system for now, knowing that the Teams 2 system alone is a gargantuan task before us.
Couldn't express our concerns.
Thank you.
That's
Mr.
what I
Padilla.
said.
Chair recognizes Councilwoman Miskowski.
I think Mr. Padilla raised the questions. Obviously, if we could do everything now, we'd be doing it. We can't. We need to work out what we can do until we get to the new system within fairly reasonable standard. And I think, as Kelly indicated, most of it's not so reasonable and it's so difficult. That's why we haven't been doing it. I think if the department had had that information, they would have utilized it. Even though there are those who may, make a judgment differently on that. I think it's been the inaccessibility of the data in an easy manner that has led to some of the problems we've had.
Thank you, Councilwoman. The chair recognizes Councilwoman Chick.
Mr. Deaton, you are going back to the table. Although I'm certainly interested to hear from anyone sitting at the table that can respond to this, but it seems what DOJ is trying to do here is say, since you won't have Teams 2 up and running for quite a while, unknown period anyway, there are goals here in this agreement that you agree to, and so to the best of your ability, City of Los Angeles LAPD, using what you have available to you, your existing data, et cetera, we want you to say you're going to be trying to accomplish some of the things in the agreement in the interim, and not just sitting with your hands in your lap. A couple of points. One, to me, this is rather telling. Colleagues, for those of us that aren't experts in this, what bad shape we're really in without Teams 2. What we are not able to do with existing data, how badly we needed to be moving towards this, and why the Department of Justice is making such a big thing about it. Because I think, in fact, there isn't a whole lot listed, some of it's in item 40, and other places where they're asking us to do things. We truly can't do those now. It's just completely not feasible. Some of us have experienced this in closed session when we're talking about lawsuit settlements, and we ask questions and we discover LAPD can't answer them because our existing systems can't produce that kind of information. Now to how we deal with this. Obviously, what they want is some kind of good faith statement. Isn't that correct?
No, well, that's how they've characterized it. The difficulty I have with it is this is a legal document.
I understand the dangers.
Somebody's going to look at it and say, what have you done? I want a better roadmap of what we're committing to before we commit to it.
Well, I would be also interested to hear, and I don't expect the answer now, but soon, to hear from LAPD, what can we do with what we've got? And that's the answer to DOJ. This is what we can do in the meantime. LAPD knows what it's able to do and what it's not. I mean, I think the department is very much helping to design Teams too, so I would appreciate, and I'm not putting you on the spot now, Chief Pomeroy, but am I correct at least that the department could answer back what we can't do on this list without Teams 2?
I suspect that we can, although, of course, part of the answer will always be what you can do versus what you ought to do or what you have the resources to do, given everything else that's expected of you.
Well, I guess I was not thinking so much of staff power. I was thinking about the capabilities of our information systems and our complaint tracking systems that exist in LAPD now.
I'm certain we can provide you that information.
One of the systems that came up during the discussion was one that I was quite familiar with, because when I was in the CEO's office,
Lo, these many generations
I've been
ago.
with the CLA's office since 1976. I worked with the person who designed the system, like in the early 70s. I think my oldest son was yet to be born when that system was being put in place. So some of these systems are an old. In fact, I dated it by saying that the system had been mentioned by Jack Webb on Dragnet.
Yeah.
Okay, Mr. Ridley Thomas.
Madam President, members of the council, while I appreciate the tenor of the discussion to some extent, I do not wish for it to in any way to mask the urgency of what's before us, and discussion about flexibility, discussion about reasonableness seems to me to some extent to be appropriate, but if it in any way removes the urgency out of the equation, it is very, very problematic. I would rise to discourage that and to effectively cause us to return to the impulse that causes us to be here in the first instance. We have substantial problems in the department that warrant our rather immediate attention. Pursuant to the consent decree, presumably that would happen. But at a point where we are talking about something as fundamental as the Teams 2 system and all of what that represents, it might be worth our being reminded of the fact, had we taken care of the business that we should have with respect to these systems that would help track, we might not be here talking about a consent decree in the first instance. And yet, the very issue that has caused us, perhaps, that is to say, made the Justice Department most concerned with our lack of forthrightness, our lack of willingness, our lack of activity on this question, the very issue that brings the discussion before us is one where we are still talking about, well, it may take more time. It is not a good sign, in my view, of our intentionality. It reflects, to some extent, not only a muddled mindedness about it, but a lack of resolve about this. And so I would hope that we would listen to what we're saying. And of course not, we don't want to run headlong into a system that crashes before we get it in place. But that's a very different kind of sentiment than that which suggests that we need to be deliberate about this. Well, presumably we are being deliberate, but that perspective should not in some way envelop the whole discussion such that we are immobilized with respect to moving forward with the concerns of reform. And I would want to suggest that this particular one happens to be one of the more critical ones, that is to say, the more fundamental one, and I would hope that we would send that message as clearly as possible, members of the council, to the negotiating team, so they get that message across to DOJ, and DOJ understands that we are serious, and ultimately that the citizens of Los Angeles would appreciate that we are, in fact, going to take care of the business they expect us to take care of.
Okay, thank you. Are we now finished with item 50? Okay, item 50, which means we have now cleared 38 paragraphs out of 182. Well, we're finished discussing it for today. No, that's what I mean.
And the intent is that direction would be that we would go back to DOJ and work out some sort of interim period plan.
Yes, that was the intention before I walked out of the room, actually. All right, 51, Mr. Pacheco.
I do want to, on a different note, echo Councilmember Wrigley Thomas's sentiments that at this point, from my own perspective, with the recent compromise that Council President Ferraro and Padilla were able to bring forward, I think we should all move as quickly as possible to implement these things that we want to see done, especially with the police department. On item 51, I would simply ask that the last 3 words of the sentence, "or the monitor," be removed because it may infer that the monitor has some sort of decision-making role in that process. Otherwise, the rest of the paragraph and the role of the monitor in that paragraph seems appropriate. But I don't want to leave anything vague about the role of the monitor, so if we eliminate "or the monitor," the last 3 words, I would think that that's consistent with what we've been discussing all day in terms of the new role of the monitor under this, the new proposal that's come forward.
So if the monitor had an objection, it would have to be the DOJ who
would enforce
who would say to us, we have an objection.
Right.
Okay.
Just like we've been doing.
Just trying to keep up with you here. Ms. Goldberg.
Are you then eliminating the monitor's role in being involved in the discussions and consultation as well? Well, I think that needs to be explicit then.
So we want to take out the monitor.
Okay.
Right. Actually, at this point, the monitor will have been doing quarterly reports on this for some period of time, and I think that probably would be the genesis of DOJ being disenchanted with where we were headed. So I think that this is a future situation.
And therefore, does that mean there's a problem with Mr. Pacheco's suggestion of taking
No,
it?
I think that's
All
fine.
right. Okay, that's 51. 52. Nobody has anything on 50? Yes?
The city attorney's
Push the button again, please.
Oh, sorry about that.
Back on 51.
The
Go
city
ahead.
attorney's office talked about the council authorizing the expansion of the term city to include elected and appointed officers of the city as necessary to meet the purpose of the agreement. And I just wanted to know whether that's something the city attorney would explain, and maybe we want to add that.
Yeah, that was a term that we weren't able to resolve between the DOJ and the city. DOJ is looking for a broader, more expansive term when the term city is being used, that they know who to go to seek whether or not this agreement's being followed. And so, my suggestion would be, there was difference in the team here, but I think we should authorize that the council expand the use of that term according to the way the DOJ wants it listed, so it will include any elected or appointed officers of the city as necessary to meet the purposes of the agreement.
I have a suggestive language fix. I don't think there's a difference in the team. I think if the language reads, "The city may or may cause the department to," and "the city shall or shall cause the department to do the things listed," that makes clear that it's the city, meaning mayor and council, who keeps the directorial role in this, but that the department has involvement. And I think that provides the flexibility you need, and that will serve and answer DOJ's questions.
Okay, I think that might satisfy the DOJ.
Yeah, I think that'll work.
Does that satisfy the city attorney?
Yeah.
Then I'm happy.
Mr. Pacheco, are you on 51 or 52 here?
Well, I was following up on Ms. Goldberg's question, because it's one thing to alter the language for one provision, which I just heard right now, and it's another thing to expand the definition of the word city as defined in the agreement. And what I heard right now was an alteration of the language for this
51.
provision. And my question is more open-ended, because I felt the city attorney was expanding the definition of the city for the entire agreement. So I want to know, have we resolved that question? Because I just want to get a pro and con on that question, because I haven't heard one.
I thought we had resolved it, and as
So
you
we're not
thought-
expanding it?
No, that this is not an expansion, but that where it says the city, that means the mayor and the city council.
Right. For most items, and if there's a need on a paragraph-by-paragraph basis to change it, I think that's appropriate.
Okay,
For
so that's
example,
the-
the design document for Teams 2 doesn't need to go to the city clerk or the city attorney. That's a mayor and city council decision.
Okay, so we do resolve it in the sense that it would stay as is in the definition, but on a paragraph-by-paragraph basis, if additional players need to be inserted, we will insert them.
And I
Is
think that was
is that the game
DOJ
plan?
That was DOJ's concern.
Okay, but is that the game plan for this document?
Yes.
Okay.
Okay, Mr. Hernandez.
What came to mind to me, there was a recent debate in regards to the role of the Inspector General. And in trying to define that role, the council was getting responses from what we could do and couldn't do from the city attorney, the commission, and the mayor's office. And it was difficult to determine who had that authority. And when I'm asking the question, is that why the word appointed and elected officials? Would that include like commissioners?
No.
I think that finishes 51. Now, the next items, 52 through 61, are all items where both sides have agreed. So if anybody wants to discuss any of those, let me know. Otherwise, we're going to go to 62. Ms. Goldberg, which one?
I have just a couple of quick questions on a couple of items, and I'll
Go
just
right
run
ahead.
through them and hear the answers. On 53, annual performance evaluations, you've got 9,300 or more sworn individuals. I think is absolutely impossible to do what would be a thorough evaluation of all of them annually, or you would do nothing else. I think that there should be some kind of devised system whereby everybody gets a certain type of review every year, but every other year they get a full evaluation unless they're in an at-risk category. And the full evaluation is a very thorough evaluation, because otherwise you're going to have, it's just a virtually impossible thing to do. You just can't do that number, in my opinion anyway. So I just think it should be looked at. I'm not talking about some kind of statistical look at them every year. That can be done quickly. But a thorough performance evaluation takes time. And I think that it should be every other year, except for folks who have been identified as needs to improve in one or more important category. On the cost, I had a question on page 28.
Before you leave 53, though, that also is supportive of what you had before on the accountability issue.
Yes.
This talks about managers being,
Yes.
all that is in here.
Yes. On 54, we talk about the cost of the investigating, units investigating categorical use of force, not today, but at some point in time, I need to know why it's a $3 to $4.5 million ongoing cost. And does that mean new cost above what we're now paying for these kinds of things? And where is it going to come from? I think we need to talk about that, not as a part of this, but through budget and finance, because I am of the opinion that some of these procedures should replace existing procedures and not be an additional cost, but a shifting of costs. Others are new costs, and I think we need to get a handle on that.
But just to give you and this is involved in some of the others as well, in order to create this unit, we transfer directly some people, but some people in the divisions and in the bureaus that are used for both bureau activities and to supplement this cannot be transferred. And so they have to be added to a centralized group that is not supervised by the chain of command, which is the issue DOJ has. So there's additional monies involved for those where we cannot directly transfer the people that's in the bureau.
Okay, I think the rest, what number did we say we're going through that there was agreement on? How much? That's all I have.
Mr. Fewer.
Thank you, Madam President. Just a quick recommendation, paragraph 56, which discusses the deaths of people within custody of LAPD, states in its second sentence that PD should notify the DA's office whenever someone dies in custody or control of LAPD. And I'm going to recommend we remove the balance of the sentence which says, and a use of force by a peace officer may be a proximate cause of death. I see no reason why we're leaving that discretion to PD to determine.
Can I comment on that?
Yeah, please.
We put that in there, excuse me, because there are many times...
Wait, your mic's not on, Jerry.
And it's on now.
There you go.
Thank you.
Go ahead, Jerry.
We put that in there because there are occasions that arise when, for example, the paramedics are called and the police department are called at the same time. They arrive at the location. All the police department did was arrive, assist the paramedics, the person dies. We didn't feel that was appropriate to have this notification when all that happened was they were there.
But Jerry, I guess here's my concern.
So that's why we put in the proximate cause.
I understand. I don't want to belabor the point, but real quickly. On the one hand, if that situation arises, one would think that the DA's office, Jerry, could quickly disregard this as something to investigate if the facts warrant that off the bat. But by contrast...
Guys, what's happening is you're not saying the same thing about what the "and" means. Let me just take this off your time. This is...
No, we are.
I don't think you are. I think that the way you're talking about it, I'm hearing it sound as if a situation in which, whether it was in custody or not, but the use of force by a peace officer may be a proximate cause of death, where you're adding it on, and what I hear Mr. Chaliff doing is qualifying the first part.
No, my point is...
Those are different.
No, let me be very clear. The way this is framed says that PD makes the decision whether it's possible that a peace officer was the proximate cause of death, and it's that decision which triggers whether the DA hears about it or not. I'm saying I don't think that's a good thing to vest in the PD, especially because there are many cases in which the whole question of the cause of death is the issue. I'd rather have the notification be automatic and have the DA quickly dismiss it as something that relates to PD because of the circumstances that Mr. Chaliff suggests.
The problem with that, the organizational problem with that is, trust me, every time you notify the DA, they're going to want to come out there now because they have the same pressures on them everybody else does. And you're also going to have a number of other reviews throughout the department as to whether or not this was appropriate conduct by the officers. All this does is trigger whether or not the DA rolls out. And we felt that since there would be an officer at the scene, a supervisor at the scene, and most likely a commanding officer of some sort at the scene, that there was enough built in to ensure the DA was notified at the appropriate occasions. And I think Ms. Martin will stay after that.
This tracks the existing protocol between the LAPD and the district attorney's office.
Thank you.
It may be that it's better to have the notification, but what I think would be a bad idea would be to set up an expectation in the public that the DA was going to roll when indeed they weren't.
Oh, that I agree with.
And so to put in a contract with DOJ and not with the DA, our problem with, this doesn't prevent us from notifying more often. This can be the floor.
I understand,
But to put it into a contract with DOJ when the district attorney's not going to roll could lead to problems down the road. And that's why we tracked what is the existing agreement between the district attorney's office and the LAPD, which is what DOJ signed off on, because they, again, also didn't want to get into the middle of a three-party dance.
Something you said looks different from what the document says. You said that this tracks existing policy.
Yes.
But the way 56 is worded, it says LAPD shall continue its policy. That's the end of one sentence. Then it says, new sentence, in addition, PD shall notify. So it looks as though there's a change from existing policy. And if we're deviating from it, I wanted to know why.
It's not intended to be a change, and
Okay,
I don't think
So you could say,
that way.
again, you could say continue its policy of...
Or shall
All right, so this
continue to
is not a
notify.
change.
And
This reflects
continue
the status
to-
quo, that in addition doesn't mean we're changing what was already in place.
Yeah, you could
Okay.
say, in addition, the LAPD shall continue to.
Yeah, one other thing, that was also meant to cover the situation where another law enforcement agency was involved, where it says a peace officer, so not necessarily just LAPD, but where the death occurred in, maybe some other law enforcement agency was actually involved in the original arrest.
Mr. Hernandez? No. All right. We are now, I think, ready to move to item 62.
Just side note, 53 is similar to Chemerinsky's 6B and 21E. 54 as his recommendation number 22, and 60 is his recommendation 6D.
Okay. I
Next.
think,
60.
I don't know where Mr. Wax is, but I don't think he heard you. However, we'll remind him later. All right, 62.
61 or 62?
This is city,
You know, in 62, we felt that if you look to paragraph 87, we thought we could remove this language from 62 because we believed it was otherwise covered by the document at paragraph 87. Okay, paragraph 62, considering the non-disciplinary actions, the Teams 2 review would be required in considering non-disciplinary actions, and I don't know if we've discussed what that is yet so far in this discussion, but non-disciplinary actions we think are also covered at paragraph 87, where it requires LAPD continue its practice of having managers evaluate all misconduct complaint investigations to identify underlying problems and training needs. After such evaluations, the manager shall implement appropriate non-disciplinary actions or make a recommendation to proper LAPD entity to implement such actions. Non-disciplinary actions would be things like transfers, reassignment to a different partner, things like that don't have the effect of, wouldn't be called discipline, but are designed to deal with the underlying problem behavior and correct that behavior.
I think what we have to do in paragraph 62 is make clear Section 832.5 of the Penal Code does not allow you to use unfounded or exonerated or, and we've dropped the word frivolous, complaints in connection with transfer decisions, which are non-disciplinary. So we either have to, this is one we just have to fix because it's inconsistent with state law.
Okay.
The idea was that they can't rely on unfounded or exonerated complaints in making these decisions.
Okay, I think,
But if we-
unless
but if we
somebody
drop
else has a
62, we do.
concern, we're on, you just have to keep talking to them about that, and you'll let us
Right.
know what happens. 63, both parties agree. 64, both parties agree. 65, both parties agree. 66 and 67 are before us.
66, I think we agreed.
And 67 is one of the ones you referred to earlier, I believe, when somebody had a question on an earlier paragraph.
Is this when we want to start this discussion, or?
go ahead. I think, well, maybe let the chief explain the difficulty
Okay?
in the field.
Chief?
Thanks, Ron. Understanding the significance of this issue and the predisposition of many in the room, and understanding that principle always outweighs logistics, on the other hand, as a basis for the coming discussion on this, just to point out a few things. First of all, the Los Angeles Police Department engages in roughly 2 million citizen contacts per year. In my judgment, the great majority of them would result in some type of a log or a written report if 67, 19, and 111 are adopted exactly as the DOJ wants us to adopt them. For example, when they refer to a warrantless search, by definition, a pat-down, an officer safety search is a warrantless search and will require a report. For searches and seizures, for example, they are asking us to do a written report, no option for electronic log, that has all the standard identifiers like name, date, place, who, what, when, where, why, and how, and all those things, plus, and I quote, a full description of the facts providing probable cause or reasonable suspicion for the search, as well as indication of what happened thereafter, arrests, weapons seized, etc. What they're asking for is the arrest report on top of what we already do, which is an arrest report when a warrantless search would lead to that type of situation. And certainly when there is no arrest report, they still want an arrest report based on this description. When it comes to the other issues of traffic stops and pedestrian stops, understanding that the whole national debate began with those stops on I-95 in New Jersey and further down in Florida, and then progressed on to situations where a person was stopped and there was some suspicion they were stopped other than for the act they were alleged to have conducted. I suppose we in the department ask, what problem are we trying to solve and what information are we trying to get? And once we identify that, then how far do we have to go in gathering that data to address those problems? We see that if you have a written report for every warrantless search and seizure, or if the data collection is too extensive for the traffic stops, or at all for the pedestrian stops, you might soon be in a position where you have more officers completing those types of reports than you do out in the field. And we see literally tens of thousands of officer days being removed from the field if we go too far in what we collect, and if we are too extensive in how we collect that information.
I think the city attorney has a possibility, and I think we need to...
Go right ahead, and then I have, we're building up a backlog here. I have 3
Yeah.
so far.
I believe that the department is ready to collect this information on all vehicle stops, and has said that they can do that because they're going to be able to capture that information. I'd recommend that we also include pedestrian stops that are otherwise already being recorded, not require every pedestrian stop, but ones where we're already making arrests, I'm using language such as arrest reports or field interview cards are filled out, or gang activity cards. If we're already collecting that information on pedestrians, then we also could capture this on warrantless searches as well. This is, again, this is the issue of racial profiling that we're talking about. So it hasn't been mentioned that way, but obviously we're trying to capture that data. I think the chief is right to say maybe we should exclude the pat-downs searches for officer safety, just a merely investigative pat-down where the officer just wants to talk to somebody and just be sure that they're safe. I think that the chief is right. We should probably write in here to exclude the pat-downs. But I think, we should agree to vehicle searches and to pedestrian stops that we're already capturing.
Mr. Chaliff, wait, we have lots of you there who want to comment. Go ahead, you're first.
I can wait. Let me just say that not to disagree with the city attorney, but this doesn't really get you the racial profiling issue. This is what you want to do in addition to any kind of recordation you may have done in relation to traffic stops, pedestrian stops. This is those occasions when there is a warrantless search, which means every time an individual is, and the chief is correct, technically a warrantless search includes every time somebody's patted down, which an officer in many situations would just do, as the chief said, for his or her own protection. As to what, if you want to collect information about it, and if you do, what type of information. The second part is, if you decide that you don't want to do it on every occasion, do you then want to make it a requirement if there's a traffic stop or a pedestrian stop, and then a warrantless search occurs, depending on how much information you want to collect? So it's more than just lumping it together. The question is, above and beyond traffic stops and pedestrian stops, do you want to require the collection of this information? And I think the Justice Department was fairly adamant in it, but I think the type of information is certainly something we could talk about.
All right, Ron, and
I was
then
just going to
Kelly,
say
and
that
then we'll
we
go back to
need,
the list.
in both traffic and whatever we do on pedestrian stops, to make sure that the kind of data that is collected can be done very quickly and efficiently. Otherwise, we're going to cause a lot of field time that is unnecessary. We also, in the difference between a pedestrian stop and a traffic stop is there's no doubt when your car gets stopped. But when officers are walking around and interviewing witnesses or just doing their normal business, exactly what is and what is not a stop is less of a clear line, and that's a difficulty.
Kelly?
This is the open issue that is not racial profiling, that is exactly the one that is going to have the most impact on crime fighting. And right now, the language that DOJ has put before us is far more burdensome than they have done in any other consent decree in this country. And at a minimum, I think we have to explain to them that we are not Steubenville, Ohio, that our volume of transactions, our geography, our fact that we have 9,000 officers for 400 square miles means we don't want them spending all their time on paperwork, means that we have to significantly scale this back make sure that we have the flexibility to collect this electronically, to make it easy as possible to record whatever it is we end up doing, and make sure that the exceptions that are in Pittsburgh, Columbus, Steubenville, New Jersey, and Montgomery counties consent decrees get into this one, which we have not yet got from them, and I think that's crucial.
If I could add one more thing in support of what Mr. Deaton says, certainly many of our pedestrian contacts are in result of canvases looking for witnesses. Often they're consensual, but it doesn't stop just there. Sometimes our traffic stops are a canvas. Sometimes our roadblocks, although that's not the term we use, are consensual, looking for suspects at the same hour of the same day, at the same time of the week. And frankly, under the way the DOJ would like us to do traffic stops now, would be prohibited from giving away turkeys for good driving like we do every December. So there's a lot of sub-issues under here, too.
All right, well, there's also a lot of council members that want to be heard. We're up to 7 so far. Mr. Fewer.
Thank you, Madam President. I think it's really impossible to discuss this issue outside of the discussion of racial profiling because the data we collect and when we collect it is of a piece here. First, I want to turn to the President of our Police Commission. In general, there are some exceptions, but in general, the array of information sought here is similar to that which is sought by DOJ with respect to the racial profiling sections in paragraphs 105 through 111, I think. Mr. Chaliff, in the Police Commission's work, have you investigated how much time it takes to collect that data?
We had well, in relation to traffic stops, we had a report from our staff that talking to San Jose, the Highway Patrol, San Diego, and Sacramento, I think the longest amount of time was 1.5 minutes to add in data, but that doesn't include, in fairness, the search and seizure information. And the issue there is whether you want to have this additional information or just the fact that a search was conducted and what was found, if any.
All right. But because the length of time in general to collect data and stops.
Well, let me just say one thing.
Yes.
The department doesn't agree with
Okay.
that. Their review would have it be anywhere from 5 minutes to 15 minutes. Is that correct, Chief?
Correct, and San Jose, for example, captures 4 items. DOJ wants us to capture 25 items.
All right, well, see, here's the direction in which I want to go in this discussion. The times that, let's talk about the times that the information was going to be sought here in the whole consent decree. There's when you stop somebody for a traffic stop, when you stop somebody on the street in a pedestrian stop, and I guess, and this section here is designed to relate to situations other than those two, because by and large, in either of those situations, some form of search or seizure is likely to be undertaken. For example, in the case of the mere pedestrian stop on the street, as you mentioned, in most cases, the officer is going to want to do a pat-down just for safety issues. So there's going to be, the search and seizure and the stop are going to be the same incident. In a car situation, there's going to be some nominal search conducted as well. I think the point is, we have to come to grips with whether we want to collect data or not in this section and in the other. And I think that we have to. And I think it's really important for us to, the city attorney has recommended that we collect data in the pedestrian stop situation only under circumstances where we would collect some data of some kind now. I take it that that's intended, Jim, to distinguish, but talking about pedestrian stops, to distinguish between the moments when we stop for an intended purpose of identifying this person and just stop somebody or encounter somebody who we want to frisk for safety purposes. There's a difference between sort of targeting somebody, I'm stopping you for XYZ reason. In that situation, you want to collect the data on the search, even the pat-down, versus you're trying to secure a scene, for example, and are patting down people.
Okay.
Is that what they went through a little colloquy here. I want to finish the discussion.
Well, I know you want to finish it, but you finished. Let them respond to it.
Well, the problem is that
well, there's 7 more people who want to be heard, Mr. Fewer, and they have as much right. That's 21 minutes on this item alone.
I think we need to be collecting the data, and I think we can't be backpedaling.
Okay, well, that's fine. That's very clear. Anybody want to respond to that, or shall I call Ms. Chick?
I think we all understand that there are some exceptions that we're going to ask for, including, as the chief talked about, when they have Christmas, I don't know which roadblocks or whatever, checkpoints.
No, of course.
And things like that. And if the council wants us to collect this kind of information collected in addition to the pedestrian stops and the traffic stops, then we'll have to come up with some reasonable way of collecting it
Well, the question is, what is the universe of those cases?
Mr. Fuhrer? Anybody else on this, or can I move on here? Now we've got 9 people.
I think we should probably hear from the rest of the council, and then we can probably answer
What a
some of these
good idea,
questions.
Ms. Chick.
I would be interested in that answer, and then if I'm just asking questions and you're going to save these all up for the end, then another one is, whatever, makes the most logical discussion, but I would like to know what information we're keeping now in these categories, and what is the difference between current practice and what the DOJ is asking, and even what is the difference between current practice and what you're recommending that's different from DOJ. And I also think it would be important, not just for our purposes, but for the public's, Mr. Hahn, if someone would take a stab at interpreting for us why the Department of Justice is asking for this information, why it's important, perhaps, that we gather it.
To begin with, the Department of Justice felt that in their review over the last 4 years, they'd had a number of citizen complaints about improper warrantless searches by LAPD. Of course, we are aware of the problems in Rampart where there's allegations of actual planning of evidence on individuals in connection with warrantless searches. So the problem was very clear in DOJ's mind that there was a problem with warrantless searches and that they wanted this information captured. To a large degree, the department had, I think, had the idea that we could capture this information on existing arrest reports, whether or not a search was conducted, whether or not there was a warrant, and then the probable cause and everything could be captured in existing arrest reports. And then in other instances where an arrest was not made, there may be some other record already being made. There may be a field interview card. There was a card made because the officer, wanted to talk to somebody. They were in a suspicious location where there was some crime activity occurring just for the officer's own memory, and because they might run into this individual again, they decided, well, I don't have enough to make an arrest here, but there's enough here to make me want to record this interview, record this contact in a field interview card. On that field interview card, if a warrantless search was conducted, that could be indicated there. So both in vehicle stops and in pedestrian stops where there wasn't an arrest, there's other things that LAPD fills out, gang activity cards, if they're confronting people they suspect of gang activity. An arrest might not be made, but a gang activity card is filled out. And what we're saying is there's a possibility probably in using existing recording methods that LAPD is already doing to capture the information that DOJ is seeking. How much extra burden that is on the department, we'll have to get from the department, but it seems to me that a reasonable compromise ought to be that we would provide this data on all vehicle stops, excluding, I guess, the Thanksgiving turkey giveaways, and on the pedestrian stops that are already being recorded. Now, DOJ would like to go further than that. They'd like to say every time you ever encountered a pedestrian and did a warrantless search, we want that captured. So, and they feel very strongly about that.
Okay, but we've already talked about an exception for officer safety when a...
Just a pat down
okay.
on the outside, yeah.
Okay, thank you.
Okay, Ms. Mizikowski.
Again, I think we're getting to somewhat of a definition here. We've understood, I think, that the department has acknowledged that now on pedestrian and traffic stops, which don't yield a ticket or something else, they are now willing to look at how we could collect that data. So the question is, where is a warrantless search different from that definitionally? How many more of those might there be? And if we can use, again, the city attorney's suggestion on this, is again, I think, to limit it in some ways. I think everyone is in agreement that it's not only necessarily a written report, but if we can create a field of data that can be either in a FI card or an electronic kind of form of that's what we're looking towards to go to, and seeing whether or not DOJ will accept that. But I would still like definitionally, or at least from maybe the chief's office, a sense of, if we were going to do data collecting on pedestrian stops and traffic stops, how much more would we be adding to that burden if we did warrantless searches? Or is a pedestrian stop and traffic stop going to essentially collect it, or is it just augmented by the warrantless search issue? In other words, where is the what kind of number and volume are we looking at as we break it down into 3 different categories?
As to searches and seizures, warrantless searches, the DOJ presently requires, in their proposed language, that a written report is prepared for traffic stops and pedestrian stops. Although they want a tremendous amount of information, they have had an exception there, or an offer of either a prepared written report or an electronic log. Assuming that electronic log was a little bit more quickly prepared than is a written report, then we return back to the warrantless searches. If we prepare a report exactly as they've requested, it would be my judgment it would take 30 minutes or more per report, in addition to all other reports, and that might happen tens of thousands or hundreds of thousands of times per year.
Were they aware that they said on traffic stop and pedestrian stop, it was written report or electronic log, and this one was the one that they were making a distinction, or do you think this was just an oversight on their part, and an electronic log would also be acceptable to them?
My judgment was they knew exactly what they were doing.
Okay, well, I think per the city attorney's recommendation, then I don't think that we can burden the department with a written report on that item separately if we can come to some conclusion on the others, that it be a written or electronic data collection, and we just need to make sure that the universe and the number of things that we need to enter are easily enough obtainable so that it can be submitted and then electronically measured and available. So I think what I would like to do is use the form of the city attorney's recommendation here, which I think is somewhat limiting. He doesn't say electronic log, but I think we should include that, and instruct the team to go back and essentially coalesce a little bit and draw in, so that we're not creating an exceedingly burdensome responsibility for the department on these, but that they be folded into the traffic stop, pedestrian stop, and or the other category as is necessary to get the type of data that I think DOJ is looking for.
If you look at paragraph 68 and read it with 67, you'll see they want it in writing, because they want a review of that report within a week. So I think they were pretty clear.
Ms. Walters.
Yes. My concerns go to the objection of the department to collecting this data. It seems to me there are very good reasons that the Department of Justice is requesting this data to be collected. There have been complaints by many people in South Central Los Angeles for many, many years about being stopped and hassled for no reason at all. Young people and even some middle-aged people being required to prone out on the ground or up against a wall and be patted down and all that sort of thing for no reason other than, that they could find, other than the area of the city in which they live or the color of their skin. I am also concerned about, I've expressed this before, the department keeping these gang activity cards on young people, where they see a kid walking down the street, just stop him and want his picture, name, address, write something down for him. They have no reason in the world to suspect that he's doing anything, other than he's walking down the street, he may have on baggy pants or have a tattoo. I think those things are in violation of a person's rights, and I'm pleased that the Justice Department wants to collect that data. When I look at this, at the DOJ data collection proposals, and as I read the document that DOJ gave to us, it seemed very plausible to me, and as the police object, as they have so strenuously about collecting such information, their technical devices, their devices with advanced technology in them, the advanced Palm Pilots that folks can carry with them and do it in just a matter of seconds. I got a certified letter last week, and the postal guy had something that looked like what our traffic officers, what our parking folks carry, right in the hand, put all the information in, and it was just no problem. Signed it, it went right on to the computer where it signed the slip. So I think that the protestations from the department that this is too much trouble, that it's going to take too long, really just need to be set aside. And we need to go on and get on with the business of collecting this data and get on with the business of responding to the Department of Justice. I'm sure all of you received Bill Lanley's statement, a written copy of his statement before the council here last week. And as you read through it, council members, it's very self-explanatory, and it says in very clear, firm language, this is something that you must do unless you want to go to court, and you must do it immediately. And I think that's what we need to do and get on with this.
Thank you. Mr. Savornich.
While I know I speak in the minority of my colleagues today in regards to a lot of the issues that we're talking about, I think this one paragraph that we're discussing has some of the most foreboding implications that I can think of. Chief, if you could just confirm a couple of questions that I want to ask. Since the Rampart scandal broke in this city, I believe that serious crime has gone up, has it not?
It has.
Okay, is that both Part 1 serious as well as Part 2 offenses? Is overall crime up in this city? Thank you, Chief.
Total crime is not a Part 1 serious offenses.
The most serious crimes are up.
Right.
Is the average, what would you say that the average officer in the Los Angeles Police Department is under 35 years old? The patrol officers? Under 30?
Definitely for patrol officers under 35 years of age.
Okay. Under 30?
I can express it this way. As of now, the average patrol officer, uniformed officer, has 3 years' experience or less.
Okay, so they're three years with the department, basically a younger officer.
Correct.
And about 3 years' experience. What my concern is that we have seen, since this terrible scandal has embraced the city to begin with, crime going up. What I have a very strong feeling about is that, based upon what I know of the profile of our officer currently on patrol, is that they are young, they are new to the force, they joined the force because they wanted to get into law enforcement. And I think that they probably don't understand a lot of the ramifications of what we are contemplating or asking them to do, and that there is going to be at some time fear or consternation or concern in regards to their doing their job and not fully probably ever going to read this consent decree from one page to the next over how that will affect them performing their duties. Because knowing very well, I'm sure that those of us who operate under the city charter, I'm sure very few of us have read it from cover to cover and can't tell you every paragraph that's in it. All we know are the generals and the basics. And how those generals and basics are transmitted to these young officers, I believe, is how they will perform their duties. And while we may or may not think that an officer will perform their duties as they took an oath to swear to do, I really do believe that if they feel that in the performance of those duties, it's going to put them under a microscope or a looking glass, which I believe maybe some of us around here think that that's what we need more of, and obviously we do, that they are going to be concerned that, should I make this stop, should I make this search, because this is going to end up costing me mounds and mounds of paperwork, and if not taken in the right context, could blemish my career if I want to be a career officer. That sometime, somewhere down the road, somebody's going to look at this and say, oh gosh, look at this or look at that.
Okay.
My final comment would be, is that I do believe that we do need to have additional oversight in what we are doing, but I don't think anyone yet here today has put themselves in the shoes of that 3-year, 30-year-old officer and the decisions and the things that they're going to have to do based upon what we're talking about today.
Okay, thank you. Mr. Pacheco.
I've already shared my support for the agreement that's coming forward based on the work that's been done by Council President Ferraro and Councilman Padilla. But one of the things I wanted to make really clear is that I'm still very uncomfortable with data collection. And one of the things I found most interesting about Bill Van Lee's presentation, if we're going to defer to his presentation for any significance, is that if you review his written comments on page 7, he never once mentions data collection when he talks about racial profiling. Now, I can only interpret that as one of two things. Being the first time that he's going to present this to the council as a whole and basically the community at large through this forum here, he either didn't want public debate on it or he felt that the consent decree would cover it and there was no need to bring it out into the light. So I have a concern about all of us putting this heavy weight on data collection when he stepped forward, and he's a lawyer, he knows how important words are, and he knew this was an important moment in this whole process that he was going to present the Department of Justice's point of view, and not once in his presentation did he mention data collection. So I don't know what you make of it, but to me that's significant. It's either not as important as you or people are making it seem, or he either didn't want it to have public debate and didn't include it in part of his presentation. My big concern is that the law distinguishes between a consensual encounter, a Terry stop, and a full arrest. And what exactly are we, under what circumstances are we asking the officers to fill out more paperwork and spend more time with that individual? And my primary concern is that will it then move that stop into another area? Does it move a consensual encounter into a detention? Does it move a detention into an arrest? Because there are significant legal consequences and rights depending on what your status is. And we have had, as I can tell you as a prosecuting attorney, we have had full-on hearings and arguments and briefs filled with case law on arguing that what was a consensual encounter versus what was a detention. So I don't think what we're talking about provides guidance to an officer, and really I'm not sure what we're doing here, because it seems like we may be jeopardizing the city because we may be moving something from one area to another area which has different legal obligations, while the officer is just merely trying to comply with this paperwork, and he may have failed to exercise the right or done the right thing at those different levels of a status of an individual. And I'm really concerned on how this is going to deal with citizens who step forward to talk to us about crime as neighborhood watch programs, any of this sort of information gathering. So I'm really not sure that this pedestrian stop area has been well thought out, considering the huge legal distinctions between a consensual encounter, a detention, and an arrest.
Okay, thank you. Mr. Padilla.
Thank you, Madam President. I don't think it's a secret that a big part of setting the stage for today were some occurrences at the end of last week, and especially my decision in consultation with Council President Ferraro and the mayor and the chief of police. And so I was the focus of attention a little bit. And that held true on Saturday and on Sunday when I was in my district attending some events where I had police officers approach me about this. And police officers had some questions. They had some comments. They weren't overly in favor of what was going on. They weren't overly against what was going on. They had questions like, how is this going to affect me? How is this going to affect what I do? And so I take that into account, and I take into account just some realizations that we all get, colleagues, those of us who are involved in the League of Cities, whether it's at the state level or at the national level, that we can exchange ideas, we can exchange models of programs, but we know that when it comes to implementation in the city of Los Angeles, the size of the city adds layers, if not magnitudes, of complexity, of size. And so we're talking about data collection. And we're talking about, will it take an additional 30 seconds or 90 seconds? We're talking about whether a police officer may be more or less inclined to make that stop, to have that conversation because of the paperwork involved. And I have actually concerns about paperwork, workload, and time involvement, not only on this issue, but on the number of other issues in the following paragraphs. But you multiply those 30 seconds, those 90 seconds, those 3 minutes by the 9,300 men and women on the force, and you get into large volumes. And we have to look forward at the inputting of that data into this computer system that we have to design. And we look at the memory space available and the number of computers available. To me, those are arguments for trying to streamline and simplify the data that we have to collect. We have to collect it, but the way in which we collect it, the type of information we collect has to be strategic and, I think, somewhat limited, unfortunately. So those are my concerns, and also in the context of knowing what the Department of Justice has required of other cities. In my opinion, they have set a standard, and I don't believe that on the same issue, given the same challenge or the same concern, that the city of Los Angeles should not be held to the same standard that they are holding other cities. So I think we should look at those other cities' consent decrees or MOUs as an example, as a model, and we know of Pittsburgh, of San Jose, and others, and we should replicate that model here in the city of Los Angeles and give the negotiating team that directive.
Ms. Goldberg.
I don't know, I guess I'm just completely out of step with everybody. I apologize for that, well, except for Mrs. Walters. This is about search and seizure, elevated as such a high importance to the framers of the United States Constitution that it's one of the amendments in the Bill of Rights, protection against unreasonable search and seizure. It's not just about stopping you if you ran a red light. This is about searching you, seizing property. They're pretty fundamental rights here. And we're talking about, oh my God, we might have to fill out some paperwork here on why we're doing this. This is about search and seizure without a warrant. Not with a warrant, not where there's already been established probable cause, you got a warrant. We're talking about without a warrant. Now that's a pretty fundamental right to be protected against. And I don't know about where all of you live, but we get complaints about people being stopped and frisked and made to face down on the street from young people all the time, continuously, about 16 to 20-year-olds. We get complaints from people who say that they were simply driving home from work, and yes, they ran a stop sign, but they were asked to get out of their car and spread their legs and put their hands on their hoods of their cars, and all they did was run a stop sign, give me a ticket and send me on my way. This is not an unusual complaint in our office. Maybe it is where you are all representing, but it's not in my office. And people need to know that this is going to be tracked. Now let's take a look at the terrible tracking that this is going to do. This is terrible. Except for a full description of the facts for the probable cause or reasonable suspicion of the search under search and seizure, everything else except putting in the time and date and location can be answered yes or no or by circling on a form. You don't even need a Palm Pilot. I'll write the form for you. You can circle yes or no on every one of the other ones. On the traffic stop, you need to write down the date of birth and date and time and location. And other than that, you can put yes or no or circle one of the choices. I'll write the forms for you if you're having trouble. You could have them on a clipboard. You could already have the officer's name and badge number printed on the top. It'll take them less than 30 seconds. This is not complicated. This is not brain surgery. Now let's talk about the 2 million citizen contacts. Well, there are 8,000 officers roughly that are not in management. If you take 8,000 officers working 200 days a year, that's 1.6 million officer work days. They're making about 1.25 citizen contacts a day. 5 a week. 6 a week, pardon me. 6.25 a week. All right? We're not talking about thousands per officer. We're talking about 6 a week with a form where you can write yes or no or circle an answer for all of the data. Now, where will the time come is in data input. And that is going to be a burden. And we're going to have to hire people to do data input. There's no doubt about that. But I do not believe that this is going to interfere with police officers' ability to do anything that they need to be doing out there. And we need to be talking about search and seizure as if it were an important right to be a person to have protection against unreasonable search and seizure, and not so much about whether or not this is going to have people filling out too much paper.
Mr. Hernandez.
I guess I've heard the spectrum of both sides here, and, you know, which one is more real, I think, is my concern. Members of the council, I think this is not as big an issue as some of us are trying to make it, because, as already stated, some of the information is already gathered in one form or another, and it's a question of how you input it. As I read the report, and correct me if I'm wrong, they're asking for a written report from each officer. Is that correct or not correct? That does such a stop.
On each search and seizure.
On each search and seizure.
Not on the traffic stops and pedestrian stops.
And the traffic and pedestrian stops, it would be the filling out of a form.
Or a log.
A log. And that could, that basically could be systemized in some form or another.
I think for the most part, the traffic stops could be, because you have the automobile there, that would make it easily handled. Right now, the pedestrian stops, you'd have to have some sort of form or other electronic ability. It's not quite as clear how we do that.
But, I mean, that can be defined.
I think that should be part of the agreement. How we're gonna-
And that's something to be, I'm more concerned about the whole issue of what is a written form, and again, on unwarranted or search and seizures, where basically is what we're trying to get to. We're trying to identify when is it that an officer is abusing that authority versus when is it that he's using it right. There should be some kind of report issued. In terms of pedestrian stops and traffic stops, I mean, I just had a parade in Pico Union on Sunday, and I thought it was phenomenal, but there was like 50,000 people there, and then the park had 5,000 to 10,000 people there, and a lot of officers, and I would suspect a lot of stops were made, and a lot of reports would have to be issued. I want us to have a reasonable approach to this issue that doesn't really overburden the work a police officer has to do. One of the reasons we're trying to computerize our substations was to allow officers to spend more time on the streets. And every time an officer has to be filling out a report, that's not the case. And so, again, I want to leave it at the discretion of the team, but there has to be a clear understanding that we are willing to try and identify that unwarranted stop, that harassment stop. One of my concerns is that an officer is just not going to stop people because he doesn't have to do that, versus the one where he should be doing it. And so I know that at Rampart, and members, this is a true story. I was at Rampart one day, and Tom Hayden showed up to file 44 complaints. And basically a lot of officers had to come in to take those complaints and deal with the paperwork involved in them. And at the time, he was making a political statement, but that had nothing to do with fighting crime at Rampart. I need to share with you, I had a special task force dealing with a drug issue, and on a Friday night, they were arresting people who were selling drugs, who on Saturday became women selling drugs, and on Sunday became pregnant women selling drugs, simply because of where they had to be booked. And when you're dealing with crime, there's a sophistication out there that actually happens when it's organized, and we're trying to deal with it. So again, I know that every time an officer makes an arrest and has to go to court, he's not on the streets. And so for me, it has to be a reasonable approach, and I think it's somewhere in between. So again, I want to let the team to deal with those issues in a more substantive manner.
Mr. Fuhr, we're now on round two.
I'd still like an answer to my question. What is the universe of cases we're talking about where a search or seizure would be conducted pursuant to something other than a traffic or pedestrian stop? How many cases are we talking about? Warrantless searches and seizures not associated with a traffic or a pedestrian stop.
I can't tell you that, Mr. Fuhrer, because I cannot divide people that are arrested into those categories, nor can I tell you how many people are not currently reported because they're just let go.
Chief Palmer, the reason it's such a critical question is Here we are determining whether to carve out a different rule for warrantless searches and seizures than we are for traffic stops or pedestrian stops. We haven't formally addressed the latter two yet, but my suspicion is we're going to be directing that we in fact collect the data in more or less the fashion DOJ is recommending. So I want to know what distinguishes, what kind of numbers we're talking about if the major reason not to do what is requested by DOJ on warrantless searches and seizures is the allegation it'll take too much police time away from important police work.
Well, in my personal opinion, it's not the major reason.
What is the major reason then?
I'm not aware of any statistical model anywhere in the United States that allows you to adequately interpret that data to give significance to us. I certainly agree that the Fourth Amendment is the most important issue we're dealing before us. And I certainly agree whenever we find an officer violating someone's Fourth Amendment, and we should do something about that. And I certainly agree we should have extensive auditing, we should have extensive internal affairs intake, we should have extensive systems to allow us to identify those officers who are abusing someone's right. I'm not personally aware of how this data that's being collected relates to all of that.
Okay, so your question is this a solution in search of a problem rather than, and what can you do with it once you get it? The answer, let me tell you what I think the answer is to that question, and it relates to each of these three categories. Once we get, the data is not intrinsically valuable. The data is a tool. It's an instrument. It's a management tool by which you determine, are we training properly in this area or that? It helps you to determine which officers, if any, are behaving improperly. It helps you determine how to redeploy people if there are issues involving certain officers or command staff. Is supervision appropriate? All those kinds of issues that go to the heart of the reason that we're here all together can be informed, not decisively, but informed by the information that is sought here. Now, with that, at least that's my view, and with that in mind, the question is, if that's the purpose, what's the and it's a legitimate purpose, what are the reasons not to do it? Because they have to reach a pretty high threshold, I think, not to do it, given that there are legitimate uses to which good management can put this data. So if it's not the raw number of times officers might be having to collect this data for search and seizure purposes, I don't know what it is, and if you can't tell us, or if no one here can tell us, the universe of cases is going to be so onerous that it's going to take time from police work on the street, I don't know what the strong argument against doing this is. So that's why I'm asking the question, and it's frustrating not to know what the answer is, because I'll tell you otherwise, I can't, give me the paradigm. What is the situation in which a warrantless search and seizure occurs and it's not incident to a traffic stop or a pedestrian stop?
Okay.
Call for service. A call for service.
And that's about it, right?
Well,
No, that could be
Well, but what are we talking about?
Well, wait, let them try to answer it. Go ahead, Jerry.
situations incident to arrests of other people, where a number of people are searched and it's not put in a report, the data's not captured. There can be a number of different times when some incident occurs which requires people to be patted down or searched that isn't incident to a traffic stop or a pedestrian stop, but to come up with a number, I think, would be next to impossible.
I might be able to add a little illumination to that, Mr. Fuhrer. First of all, keep in mind, we are about to embark on a system which the department wholeheartedly endorses and in fact requests, and that's Teams 2, which will help us to identify those at-risk behaviors you're talking about. If we include searches, stops and frisks as part of warrantless searches, then it would be literally hundreds of thousands of times a year. But there might be many other, even if we exclude that, it still might be tens of thousands or more a year if we include such things as probation searches, parole searches, emergency searches, consensual searches, which are extensive at this point, consensual searches of the individual, of a vehicle, of a home for narcotics, if you keep in mind what a problem narcotics is throughout our nation. So I would say it's not an insignificant number, although I'm sorry I can't put an exact count to it.
All right. Press my button again.
Ms. Chick.
So it seems one of the things we have to figure out is what types of warrantless searches and seizures we should include. There's been an argument, I think I'm understanding correctly, that doing this could potentially interfere with police doing their work. And I think the two reasons that have been put forward is it's going to take up too much policing time, and it's going to discourage officers from actually doing their job diligently. And Chief, I'd like you to correct me if I'm wrong on that, because that's something, I keep hearing that inferred and sometimes explicitly stated, and it's very distressing to me. I've said before, I actually think it's insulting to police officers to imply that because they might be asked to fill out a form or something, that they're not going to do their job diligently. So I want to make sure before I finish that you correct me if I'm mistaken on that that's one of the objections. In terms of why we're being asked to do this, I think it's very important to be able to answer the question, why are people being stopped? Why is a police officer stopping someone? I think it's important for an officer to be able to ask and answer the question, her or himself. Why am I stopping this person? Not to stop and have a long discussion, because that's going to interfere with expedient police work. But there always should be a very clear and appropriate and understandable reason why an officer is stopping someone. And it seems that clear that DOJ doesn't think that we are able to answer the question right now, or that we always have good reasons to stop people. So I'm very much inclined to support our obtaining this information. I'm interested that it's done in a responsible way, but I would like to know how the difference between search and seizure with a warrant and without. The bulk of police work is without a warrant. Is that correct?
Correct.
Right. And so how else would we be able to answer the question, why are all these people being stopped and searched? The reports are being written now in all cases where there's an arrest. So we're looking at search and seizures that do not result in an arrest, correct? Okay. Well, I think until we're at the point where the Department of Justice and the city agree we don't need a consent decree anymore, that we have to gather this information, that we have to answer the question to the public as well as to the Department of Justice. Why are people being stopped and subjected to searches, et cetera, without a warrant? What is the reason? And I know there's lots of good reasons, but we're only going to know it from this.
Okay.
And it's also going to move us towards eliminating stops and seizures that are not done appropriately.
Thank you. Mr. Holden.
Nobody's talking about rising crime. I think that Mr. Fuhrer, Mr. Hernandez, Mr. Padilla, Mr. Pacheco, were at the news conference that the mayor called, and he set aside an additional $14 million to try to correct the problem, rising crime, people not safe in their neighborhoods. Can you imagine what this laundry list is going to do in terms of taking police officers off duty effectively? It's nothing more than a boilerplate laundry list of requirements on the part of a police officer when he might have to stop somebody. What you don't understand, the Department of Justice is not saying, do all of these. Do what's reasonable and feasible. But you guys are so gung-ho about your own agendas. Step out of the way over there, Tim. You're blocking me from the TV. You're so gung-ho about your own agenda that you're overlooking not just the cost in terms of the paperwork, but the time out of service for the police officer. Now, can you imagine a police officer stopping somebody for jaywalking and got to ask for the name, rank, and serial number of the individual and give his own? And then you got an alert, an alarm come through in a radio call, police officer down, neighborhoods being blown up by some gang members, dope busters on the way. We have an emergency in the neighborhood. He's got to say, hold it now, don't go away. I've got to go put out this emergency. Fail to get all the information, Pacheco. And once they don't get all the information, then somebody's going to say, why didn't you get the information? You just not being police officers. You really don't know what it's like to be out there in the field. Now, what you're doing is really, in my view, when the end results come in, when crime is up more than what it is today, then I can say what you're doing is stupid. Wasting a lot of time. Certainly things need to be corrected. I don't support what happened at Rampart. I don't support a police officer abusing or taking away the rights of an individual. I'm tough on that. And I don't want to see it happen. But those corrective actions could be, I like what you're doing discussing it. Then let's implement it. And the Department of Justice can monitor what we've done from time to time. And I said to the director of the Office of Intergovernmental Affairs, Brian Dave Valance, then you can monitor, you can file a lawsuit anytime. He said, that's right. I said, did you see this letter that Lee sent to Jimmy Hahn? He was shocked. It's an ultimatum. It was an ultimatum. You have friends in Washington, yes, who want to correct the problem. You have friends in Washington who want to do the right thing within the Justice Department. But there are those who made it just too political to serve their own interests.
Okay, thank you.
Well, I didn't.
Yeah, you
know,
did.
you let Fuhrer talk after he goes on and on. He'll talk the third time. I'll watch you upstairs on television.
You push the
I'll
button
watch you
again,
on
and you can
television,
come on
and you
before
just-
Mr.
you let
Fuhrer
them all
gets his
slide.
third
There
time.
you go, Ruth. I know what you
Mr. Pacheco.
I just want to set the record straight about one thing. The data collection surrounding traffic stops, I do not have a problem with because it's part of the compromise. I'm setting aside my personal objections for the betterment of all of us when it comes to traffic stops. But I think you're really making it extremely difficult to do anything reasonable when it comes to pedestrian stops, or what you may call a stop, where the courts have already given us, like I said, 3 different levels of analysis, because even the courts can't agree what a stop is. So I just want to be really clear about this. I don't know what the arguments are about in terms of traffic stops, because no one's, or at least I should say no one, but I am not opposing that any longer because we've come up with this compromise agreement. But I don't believe it should go to pedestrian stops, because I believe that a lot of situations where people are talking, officers are talking to pedestrians, aren't all equal to a stop, or don't equate a stop. And the information I received is internally inconsistent. A stop, by definition under the law, is not consensual. So I'm not sure what we're doing here. It seems like we're mixing up terms, and I really have a problem with that, because I think the non-lawyers are trying to decide a very legal issue when it comes to pedestrians. And I'm very concerned about where we put the city in terms of liability when it comes to pedestrians. I want officers to be able to talk to whoever they choose to in the community. That's part of community policing. Now, is it a stop when the officer goes up to someone and says, hey, I'd like to talk to you about what you've seen in the neighborhood, and then all of a sudden we have to go through all this paperwork? I mean, what do we mean by a stop? Does it require an officer to give a direct order? Is that what we mean by a stop? Because then that's not a consensual encounter anymore. That's a detention. So I think the whole area of pedestrian stops is vague, unintelligible, and really should be rethought out. And the final point I'll make is really, I don't even know what to do with this one, because when I was a candidate, there were some really concerned citizens that in the poor neighborhoods, in the communities where they're predominantly people of color, the Los Angeles Police Department goes out of its way to do field interview cards and gang activity cards on the minors, on the youth, so they can develop a paper trail so that when that minor gets into some minor incident, that will be used against them in court when it comes to facing the judge, that they're going to have all these police conducts reported to the contacts, I'd say, reported to the judge as part of the sentencing. And there were some citizens very concerned that the police officers were being very abusive in their field interview cards, and were using them to commit paper trails for our youth. So I don't know how that factors in. Are we just equalizing the table now, so all youths throughout the city are going to run through the same victimization, or is it going to be predominantly our youth who are of color?
Okay, let's see.
Well,
if any-
the suggestion that I've made, Councilman, I think addresses what you're trying to do, in that that if we're just talking about the entire universe of contacts with pedestrians, I've suggested that a reasonable compromise is if the LAPD is going to fill out a field interview card, if they are going to fill out a gang identity card, if they're going to do some other record of that stop already, then we ought to be able to also capture the information on warrantless searches. That doesn't add that much to that record. They're already filling out the name of the person, the age, all the other identifying information. They're already filling out why they were stopped. And then to add that to that warrantless, and then to say, we are going to capture that information in a way that we can look at it in teams too. So if there is an abuse, Councilman, as you're saying, of the use of field identification cards or gang identification cards, then that will be spotted in teams too. So I'm offering as a compromise so that we don't get stuck in what you are legitimately raising. Is it a stop? Is it a detention? Does asking this additional information lengthen into detention? Just do it where we're already recording information. Let's also include warrantless searches.
That sounds good to me. I was just trying to set the record straight, separating traffic stops from pedestrian stops in terms of my position. So that sounds fine to me.
Mr. Padilla.
Thank you, Madam President. Talking about a couple different things here. One is what information we're going to be collecting and gathering and inputting and reviewing later on, and the other is when we're going to be collecting it. And they're both of equal concern when it comes to the burden on the officers. It may not sound like a lot when it takes the extra 30 seconds or the extra 90 seconds like we've been talking about before. But when you multiply it over the number of times we're going to be doing this, it adds up. But let me also put it into this context. We have car areas, divisions, bureaus that vary throughout the city. Not in terms of the duties of a police officer, but in the demands of a police officer. And this is an area where I actually differ from the police department because the chief and I have had our disagreements about this. What percentage of a police officer's time is spent on proactive crime fighting versus the percentage of that officer's time responding to calls? Well, when you have the percentage of time responding to calls so great that you only have a small window of that police officer's daily hours actually fighting crime proactively, then yes, the precious minutes that it takes for additional burdensome paperwork makes a difference when it comes to fighting crime. I'm not saying we shouldn't collect any information, but again, we need to be prioritized and strategic about what that information is and when we collect it. But third, let me explain how important this issue is when it comes to trying to come to an overall agreement. You're all familiar, you've seen the letter that the mayor, Council President Ferraro, and I distributed last Friday. It says we are willing to accept a legally binding agreement based on a few conditions or a few certain resolutions to some of these open issues, one of which is limited paperwork. I don't want to say this is a threat, but an overall agreement may be in jeopardy if the limited paperwork concern in this letter is not achieved. And I believe this paragraph 67 falls within that limited paperwork concern.
Ms. Mizikowski.
I think the city attorney has given us a framework in which we try to deal with this, to both eliminate unnecessary burden of paperwork, try to get as close to possible to achieve the data collection that's going to be important both in teams two and just in general doing of police work. And the only other caveat I would ask is two. One, that we look if we can get electronic data recording of this, and as much as possible, as Ms. Goldberg indicated, by way of a checklist, yes and no, so that just enters that data. And the other caveat would be that it also, as closely as possible, reflects and mirrors what has been done by the DOJ in the other cities or states where they have put this in place. So, because we don't, again, have to reinvent the wheel, but they have gotten through this burden elsewhere, and I think the clear part of it, and I think, for instance, you can also add things in the warrantless search. Was there consent? Were there exigent circumstances? Was it probable cause? Just yes and no. And again, all these things start to form or inform both the supervisors and the reviewers and the monitors ultimately in those quarterly or regular reports that will start telling us whether or not we need to go further. But I think the city attorney's suggestion starts to embody that, again, as long as we make sure that it is as much effortless, or as little effort as possible, effortless entry into some kind of electronic form that starts data collection, but without the excessive burden.
Ms. Walters.
Thank you. I was just reviewing, thank you, Madam Chair. I was just reviewing Mr. Lanley's statements to us because Mr. Pacheco had brought to our attention that there was nothing in here about, what did he say, nothing about racial profiling or collecting data or whatever. I would direct council members you to page 7 of his statement and paragraph 2, where he indicates, as you all know, we have also proposed and strongly advocated that the proposed agreement directly address the issue of racial profiling. We have included in the proposed agreement strong provisions prohibiting discrimination in law enforcement activity on the basis of race, ethnicity, national origin, gender, sexual orientation, or disability, and forbidding the use of such factors in conducting law enforcement activity except where it's clearly appropriate to do so based upon suspect-specific grounds. This is too vital an issue for this community to leave unaddressed in the proposed agreement. Now, the words collect data are not here, but there's no way you can get to this, what is proposed here, without the collection of the data. And he specifically stated upon suspect-specific grounds. And hopefully, one of the things that this would get at would be to stop this random stopping of people or harassment of people because they look different, walk different, dress different, or just because you want to have a little fun. Brighten up for some officers and otherwise dull day. I think it's essential that we get on with this, that we do it and get on to the rest of this decree and pass that and get it behind us.
Mr. Holden.
Once again, I think it's real simple. We can do in the future as we have in the past where we currently are in terms of enforcing the law. If you have a reason to stop someone, then you stop them. I mean, and it's called probable cause. If an officer wanted to just talking to some mic and say, yes, here's what I've done in this computer, I have no problem with that. But I got to tell you, as already been stated by Mr. Savornich and others, that whereas we went from each part of this city, north and south, east and west, when we had the discussion regarding the charter reform, and you made some kind of overt effort to involve the community, you ought to be talking to the community about rising crime. You really ought to be doing that, because that's going to be the consequences of our action if we were to implement point for point what's being asked of us. Crime is going to go up. We're going to hire police officers, but they won't be doing much work. Imagine yourself being a police officer and having to make 30 stops a day, fill out 30 reports. It could be overtime, or you just won't stop. Sure, you won't stop a lot of people who are innocent, shouldn't have been stopped in the first place, but there are those who should have been stopped, probable cause, committing a crime, and just by routine stops under those circumstances, very often that some of these people are apprehended and crimes are solved, even major crimes. That's what the public want us to do. I think you're closing your eyes to that. The public is watching you on TV today, and I think you should make note of the fact just how you've been talking. What are you actually doing? The Republic should remind each and every one of you why you're here. You should start making those phone calls to the members of the council, letting them know that if you support them, fine. But if you don't like what they're doing, tell them that you don't like what they're doing. You still have an opportunity to get a good report, but one in which it gives the police officer in the pursuit of a crime, stop it or apprehend the person who commits it. We got to start talking sense around this council. Just because a man or a woman wear a uniform does not make them the criminal. We go to so many funerals. In fact, we have a ceremony once a year about officer dying while on duty, and it goes into hundreds, hundreds, and hundreds. And then each of you sit at the funeral, try to block out the TV to make sure you're seen, to be in sympathy with officers who lost their life. But I don't see much sympathy about those officers who put their lives on the line every day to provide safety for our community, to protect and to serve us. I don't hear that in your being echoed in your voice at all. You don't give a damn about some of these police officers. All you care about
Mr. Holden, we all try to learn from you.
Well, that's true. And if
Your time is now up. And Mr. Wax would like to speak for the first time.
I'm sure I'll hear some good from Mr. Wax. You
I'm
want me
sure
to,
you will,
Should I
too.
carry on, Mr. Wax? You said on
Wait a
next time.
second, wait a second. Let me just remind you all that we are still on paragraph, no, he's not. We are still on paragraph 67 out of 182,
Well, Mr.
and we
Wax,
still haven't done the
I'm
first
sure we'll get something really good
12,
from Mr. Wax
8,
on this
10,
subject.
whatever it is. Mr. Wax.
I'm really asking questions rather than making comments.
That's just fine.
I thought there's a difference between 67 and 108 and 109. And in our discussion here, I thought 67 was about searches and seizures.
That's
I believe it is,
And
yes.
it just stops is something we're going to be getting to and has perhaps some different policy considerations. But somehow it's all lumped together and I'm confused. Because 67, 60, this sheet that was handed out, I think, doesn't... Is the debate that we're really having now, though, over 108 and 109, or is it really over 67? It sounds to me like it's more over what we're going to get to in 108 and 109. Is there as much a difference of opinion here on searches and seizures?
I think that the...
Maybe Alex, or go ahead.
I would suggest that
Kelly can-
there's less controversy over traffic stops, and then pedestrian stops and searches and seizures has more controversy than the other.
And in each of those cases...
You say there's less controversy over traffic stops?
Yes.
We're green.
Well, we may want to do it, but I think that raised, I thought we were going to get to the issue, to that issue at a subsequent point where we talk about not only about obtaining information, but ascribing meanings to it, and the framework and the guidelines in which you interpret it and the meaning you give it. I mean, I remember the discussion we had here when Chief Parks was here. One of the issues that he raised was not so much an objection to obtaining the information, but wanting to have an understanding of the meaning we give it. And I thought that discussion was going to come when we dealt with 108 and 109. Perhaps I'm wrong on that. I thought 67 was limited to searches and seizures, and I didn't know that with respect to searches and seizures that there was actually that kind of split opinion around here. Kelly, help me out on the problem just on the searches and seizures part, because I'll reserve a lot of the rest for 108 and when we get to 108 and 109.
108 and 109 is the racial profiling
Okay,
paragraph.
so we're not there yet.
We're not there
So
yet.
dealing with 67, searches and seizures, what is the actual difference of opinion?
I think there's several points that various people are making. The first point is that there are certain categories of searches, frisk downs and pats in particular, that were carved out in Pittsburgh and every other jurisdiction that need to be carved out. And as I understand it, those relate to situations where the officer's safety may be involved. So DOJ does not object to carving those out in other jurisdictions, and at a minimum, we should get those carved out
All
here.
right, do they object to carving them out here?
I don't think they will when we sit back down with them.
Okay, all right.
The other question is on car stops, motor vehicle stops, and we need to correct the definition of motor vehicle stops to exclude the handing out of turkeys at Christmas, but I'm sure DOJ will not object to that. And I think everyone acknowledges that if you're going to fill out a form in connection with a car stop, and if there is a search incident to the car stop, you should explain that you are going to...
But we're now at 67, only talking about car stops that involve a search and a seizure.
Right, no. If there's a search in connection with the car stop, I don't think anybody objects to making sure that whatever paperwork is filled out, that it covers that search. It's just that...
Okay, well, 67 deals with that, doesn't it?
Yes.
108 and 9 deal with non-searches and seizures?
Okay, then there's the issue of pedestrian stops.
Yeah.
Now, there's the definition of what a pedestrian stop is, and we're going to have to carve out from that definition all kinds of things like canvassing a scene for witnesses and bike safety programs and that kind of stuff, and we'll do that. But the real question is, are we going to require additional paperwork to be filled out on a pedestrian stop where it's not otherwise filled out? And the city attorney has proposed that we not do that. If it's an incident to an arrest, we'd fill out a form. If it's incident to a field interview card, the information would be captured. All of those things, and I think that the negotiating team would agree with that approach.
All right. Is there a motion here to? I've heard of two approaches. One is to allow the negotiating team to, in essence, negotiate this, and the other was to accept the city attorney recommendation if it's different. I'm going to make the motion we give this to the negotiating team. There are so many key issues that we've got to deal with here, not only in this, but in the Chemerinsky report and others that are really amazingly substantive issues that I don't think we ought to get bogged down here on this issue. And I think there has to be some reasonableness to this whole issue in terms of what do people really want, and what do they have a right to expect? They want to make sure what happened never happens again. And they also want to make sure police officers can do their job and protect the public. And the two aren't mutually exclusive. And so I just think we ought to keep in mind what it is we're trying to do. A terrible thing happened, and it'll happen again unless we make changes. On the other hand, every day we need to send police officers out there to do a job in our community, and we all expect that. And that we shouldn't see these as somehow inconsistent. We shouldn't see these as somehow exclusive of each other. And so let's try to, for the moment, deal with some of the broader things and give some discretion here. So that would be my motion, because I really want to...
I think if we take the framework that the city attorneys provided, the framework that's in the other consent decrees, that the negotiating team can come back with a proposal.
Okay.
Okay, now, I have two more people who wish to be heard on this item. There are only 11 of us here, and it's 3:20, and we're on paragraph 67. We have many more to go. I was going to wait till we finished this one, but I despair of ever finishing it. So I want to suggest to you now that Mr. Deaton and I had a brief conference, and my proposal is that we plan on sticking to this till about 7 o'clock and trying to finish it, because we are not, in fact, going to adopt a final package. What we're adopting here is a series of recommendations, and we're presenting to our negotiating team so they can present it to DOJ the concerns that the council members have. And my concern is, if we try to keep putting this off and scheduling more and more meetings, we'll never get to the end. So we're also going to have trouble scheduling it. Yes.
Yes, I will cancel my things and stay till 7. I'm happy to. I'll stay till 10. But if we're not finished, I don't want to close the books on this.
That's fine.
There are too many items on the agenda that have to come up that if
Joe, that's not my proposal.
Okay.
My proposal is that we try to finish.
Okay.
That there are many items, as we've said all along, that are not necessarily part of the consent decree, but are related items, and you, of course, have brought forward many of those.
And I think we should order dinner and stay through the evening if we need to, but I don't want to not have the opportunity.
I don't want you to cancel
Okay.
everything if we're going to wind up losing a quorum anyway. So if people are planning to bail, you better let us know before the rest of us cancel the rest of our lives in order to finish this. Now,
A point of order.
yes?
My point is that I came all the way back from Washington to be here today.
Yeah, I
but
know.
not
You were
necessarily-
gone most of
Yeah,
the
you- well, let me
morning. We
just
also
say-
noted
Right,
that.
that's all right, but...
So what's the point of order?
The point is that I just got a word that Senator Lieberman is coming to town. You know who he is, Senator Lieberman?
I remember him, yes.
Yeah, he's going to be...
And Mr. Gore is coming as
Right,
well.
so
We remember
I
him
got to
too.
get out of here, and I'm leaving out of here in a half hour. If it breaks a quorum...
Well, Nate, we really appreciate your dedication to this. If that's your point of order, we're going back into item 67.
Okay.
Others of us, we're going to go to the airport
That's
as
all
well,
right.
but we're going to stay here
Well, I can talk
and
until
deal
4
with the
o'clock if you want me
DOJ. That's fine. You go right ahead. Next is Mr.
I'll do that.
Hernandez.
Madam Chair, for all it's worth, I'll stay here as long as this takes, so that's my job. One, I stand to move the city attorney's recommendation in regards to us keeping track of these systems. I appreciated hearing from Mr. Padilla, not a threat, but the fact that John Ferraro is going to do whatever he does. But also, the reality is that I don't think any of us, including Mr. Padilla or Mr. Ferraro, want to subject the city to having a judge tell us what data we have to keep, which is our other alternative if we don't have 10 votes for this consent decree. And as I'm counting, I think we're closer to 10 than most people think. And so I don't think we need to be reminded of how we got here, except that this particular item, I think that the city attorney's recommendation as presented to be able to use the information we're already gathering in one form or another as part of that tracking mechanism should be acceptable to all of us. And my understanding, and correct me if I'm wrong, but isn't that kind of the position of the negotiating team on the issue?
Yes.
The city attorney's position plus the exceptions in Pittsburgh.
Right.
Uh-huh.
Chief, no.
And,
I mean-
making sure that the information is kept in a form like Ms. Gold, that it's easy.
Right.
Those
And-
three things work.
And I think those are the three things that are being proposed. I just wanted to bring us back because we got off on this
What a
debate.
good idea.
In different places, and I think that we're pretty much in agreement that it's an item that still has to be discussed, but we are gathering information in one form or another. We want to be able to use that, and we want to have a simplified method in which to do that. And just want to bring us back.
Thank you. Unfortunately, we're not all the way there yet. Mr. Wax. You're okay. Okay, Mr. Fewer, round three.
Yeah, I just want to, in the context of this, I think one of the keys is the electronic piece of this and working with DOJ to say, because the term paperwork is being floated around here, and that would in fact be a big impediment, but I don't think anybody's talking about it. It's a false argument. So if we can get the DOJ to say, work with us, we'll do this by Palm Pilot, and let's work subsequently on getting those things in our hands, we'll be in good
Let's not have a
shape.
monopoly on anybody's particular technology, but that there's some way of collecting the data. Okay, and I think we actually have achieved a consensus on that in support of the recommendation with all those three things, which brings us to
68.
68, and the discussion says see paragraph 67, which we...
Right, but 68, I think the team believes is a little onerous to have the report up through the chain of command in a week. We'd just like to have the opportunity to negotiate a better
time on
Do we have any objections to directing them to see if they can negotiate a better time?
No.
Hearing none, we are in agreement. Item 69, both parties agree. Item 70, both parties agree. Item 71, both parties agree. Item 72, both parties agree.
I think 73, too.
And 73 is open. 73.
I think item 73, we have resolved that to change the, to make sure that we do not require anybody who's a potential complainant to sign in any form which limits their ability to file a police misconduct complaint or file a lawsuit in court or threatens them with adverse legal consequences from a false or misleading complaint. We have agreed and have so advised the police department that they need to modify any documents, and I think this issue is closed.
Okay, so just if I can summarize that in plain English, basically, we're not going to require anybody who has a complaint to waive any other rights that they would have as a complainant. Mr. Pacheco.
Well, I think we all agree in concept, so I was really just looking to see what the in practice would be. Because I was simply suggesting that we do the same thing we do for voter registration, whatever the language is on voter registration, since everyone's used to that form, that we do the same thing if it's something under penalty of perjury or whatever it is, but just something really simple that is sort of standardized.
We did have a form, Councilman, that was, there was a case on this that came down August 9th that we had been advising people of a law that the federal courts have declared to be unconstitutional, that actually advised someone, you should be aware that if you file a false complaint against a police officer, you could be prosecuted criminally. That language has been declared unconstitutional, and that was part of our form, so we've advised the department to drop that.
Right, well, that seems pretty intimidating. But what we do on voter registration is sort of more generic in terms of just, be honest, be forthright, and just know that under penalty of perjury, you're signing this document. I think that's all I was wondering, is if we can just recommend that.
Okay, and you don't have a problem with that, right? Okay. Now, 74, 75, 76, 77, 78, 79, 80, 81, and 82, we have agreement. Unless anybody has some reason to object. Ms. Goldberg, press the speaker button.
On the
Push the speaker button.
complaints,
Push the button.
I did.
Oh, okay, there it is. All
I
right.
did. On the complaints, I think we need to do more than what we're doing about how and where one can complain. I think that to say...
Which paragraph are you on?
This-
Sorry.
It's really all of the section that's about
Okay.
complaints. In writing or verbally, in person, in mail, by telephone, facsimile, or electronic mail, but where do you get them? Who helps you fill them out if English isn't your first language? I think we need to have and I think it needs to be in the consent decree, and I don't have all of the answers to that, but I think that if you look at some of the things that were in the Chemerinsky report on the issue of complaints and removing barriers to complaints, and I can't find my piece of paper, there are a couple of recommendations that I would think that we might want to look at.
Something to this, this language on assistance in...
Number 16, creating an Office of Citizen Complaints modeled after the San Francisco system, which is his item number 17 under problem 4. And also, I don't know which one, but it's in this section, the whole question of longer-term assignments to internal affairs and civilian oversight of internal affairs. And I think those are three important issues, and I think we should discuss them in the context of all of this, and where they might fit into these items. I think that this is a major issue with respect to how complaints are handled, and again, I would have to say that part of the problem in the Rampart situation was that there had been complaints, but that most of the time they simply were just not thoroughly or appropriately or deeply enough taken seriously, and I don't mean just by PD. In my opinion, that included by the public defenders that represented some of these folks. It included the courts and judges. It included the district attorneys who were prosecutors. This is not about one group, but I do think we have to look at this system beyond just the measures that are here, and I would hope that we would look at those items at this time.
All right, the real issue is whether I don't think there's any question that we need to look at those items. The question is only in terms of putting them into the consent decree, or whether they should be dealt with as part of our compliance with what is listed in the consent decree. All right, well, Ms. Mizikowski is the first one who wants to talk about it.
In general, in response to Ms. Goldberg, it's interesting. I think it was the one area that I found direct conflict between what DOJ wanted and what the Chemerinsky report had recommended. That the DOJ had recommended relatively short stints on internal affairs for purposes of not creating a serious either onerous assignment or something else, but really meant to be department personnel learning and understanding that there is an important auditing functioning, that it's both people in the field who get into that and then get out of it again, and that it's not an assignment that stays forever. And given those two issues of a recommendation from the Chemerinsky report that people really stay in IAG for a long time, which I think could be somewhat difficult for both an officer to handle as well as how other officers would view that officer, I think I opt on the side of the DOJ recommendation of a more healthy rotation of officers in and out of internal affairs. I also agree that this whole issue of internal affairs is something that both by the Chemerinsky report and I'm sure a lot of other information, both by, in fact, it was in the Board of Inquiry, and I'm sure we will have recommendations coming out of the independent panel under the Inspector General right now. But I would not like to see us add more to the consent decree in general, other than that has been put for us already. As was indicated earlier, it's not the end. The consent decree need not, should not, in fact, cannot be the end of what we do on reform. We can't say, okay, we've got a consent decree and now our responsibility is over. We're going to have a whole heck of a lot more to do ourselves as the city, whether it's the council, the mayor, the commission, the chief, in looking at other reforms, such as a different model of what the commission shall be. Should it be full-time, in whole or in part? How much stronger should we make the Inspector General? How much more should we deal with civilian review boards? All of those are legitimate, but need not be part of the consent decree. And I feel the same way with that issue, except as it relates to the DOJ issue on healthy moving in and out of the Internal Affairs Group, as opposed to a longer-term permanent commitment there. And I really think the DOJ has the right attitude, both for the officers who will be assigned, as well as for the other officers' review of them.
All right. I'm now going to announce, contrary to my previous announcement, we are ordering dinner. So plan to stick around for a while. Mrs. Walters.
Does attempt to deal with it. I think that they're pathetic.
I have a question on 73H, where it indicates that the city's negotiating team has not agreed to the DOJ language. And the DOJ language, it seems pretty straightforward to me. In addition, the department shall prohibit officers from asking or requiring a potential complainant to sign any form that in any manner limits or waives the ability of a civilian to file a police conduct complaint with the LAPD or any other entity, including filing a lawsuit in court, or that states that adverse legal consequences may arise from filing a false or misleading complaint. Why?
Ms. Walters, I think that Mr. Hahn said a few minutes ago that they've resolved that.
It was a drafting, it was a language issue, not a substantive.
But substantively,
We've substantively and worked out draft-wise, and so.
And indeed, no one will be required to waive any rights.
Okay. Very good.
The rotation of internal affairs is recommendation number 98, and it is in total opposition to what Mr. Chemerinsky had. So when we get to 98, we can discuss that. There's also another provision someplace in here about how we outreach for misconduct complaints, and I'm sure that before the evening's over, we'll get to that point.
You think so, huh? Ms. Goldberg.
Also, civilian control of internal affairs would be a charter change.
Right, which we can't agree to in a consent decree because the voters would have to adopt it. Okay,
Well,
Ms. Goldberg.
I'm not asking for civilian control in the way the commission is the control of the department. I'm asking for oversight. They review, they look at, they give information to the commission, to the chief. There's somebody who, like as being done in San Francisco, or pardon me, in the sheriff's department's just done something like this. Was it San Francisco? I'm back and forth. We need, all I'm saying is that there's widespread belief on the part of people who are the civil rights advocates of the city that this is not the solution, that just simply expanding the number and power of internal affairs is not the solution unless there is some kind of review Maybe it's the Inspector General, I don't know, but there has to be some kind of review, otherwise you have, and this is beyond my field of expertise, I'm just reflecting on what I read both in the Chemerinsky report and also the conversations I've had with people who represent the civil rights bar, for whatever language we might want to refer to it, in the city. They do not believe that without some kind of civilian look at these investigations, that you will get beyond where we are now, which is not a satisfactory conclusion. So I just think if we're going to raise it, we ought to raise it while we're talking about these things.
But remember also that we are not, if and when we finish with a discussion of the proposed consent decree, we are not finished with the issue of police reform. We still have the other 4 motions that are on today's agenda, and we have Mr. Chemerinsky's whole report. So I urge you to keep that in mind. Mr. Wax.
Well, but the fact is that what gets in here is going to be much more apt to be done than what does not get in here. That's why we're here today to begin with. The issue on the role of civilian oversight in the investigation of complaints and in a disciplinary system is a big issue. And yes, we can't change the charter in here, but we could have an agreement to put a charter change on the ballot for the voters. And that could be a part of an agreement like this. And I'll tell you what, if we agreed to do that, it's much more apt to happen than if we leave it to subsequent negotiations and subsequent discussions. So the difficulty is inserting it right here in this language as we're discussing this section, as opposed to when we get to the motion, Ms. Goldberg, that we've raised, that's going to raise these issues anew. And if we pass some of those, it may be inconsistent with some of these, but then we would have to go back and modify it. It's hard to, as we go through this, to pick out the appropriate references in the, say, Chemerinsky report of these, to start addressing them here, although it's relevant. But the reality is that they weren't written in a way that they go down parallel tracks. But some of these fundamental issues, I don't agree with Councilman Miskowski that they should be delayed. I think that some of them will. I'm a realist around here, but I think that everyone that gets delayed is much less likely to occur or over a much longer period to have it happen. And some of them would give strength to this in a very meaningful way, and some of them might help us to form consensus by some of the people who feel left out, including the police officers themselves who are ultimately going to have to live with this and deal with it. And there are a number of things, for example, in the Chemerinsky report that are really critically important to them that I think if added to this would not only be more meaningful in terms of reform, but might form a bigger and broader consensus in the city. So I don't think we ought to overlook putting at least some of those, addressing some of those in whatever final agreement we have.
On the civilian involvement with internal affairs, I think if you would delay that until we discuss paragraph 86, which is the discipline report from the chief that's reviewed by the commission and inspector general on all discipline that happened in the last 3 months, and then also used as part of his evaluation after the commission has reviewed it, and also paragraph 142, which is inspector general review of all the categorical uses of force and discipline on a regular basis. I think there's 2 ways in which at least this is addressed, and any additional items could be handled in a discussion at that point.
Mr. Holden.
Madam President, members, I'm going to have to leave. I will not break a quorum. I have 3 people. Mr. Williams, are you raise your hand? Was waiting for me earlier today, and they've been waiting for the past 2 hours to meet with me, and so I'm going to have to excuse myself, number 1. And number 2, I've had enough of some of the conversation where on the surface it appears that we're just carving up the men and women in blue, butchering police officers, and making it very difficult, virtually impossible for them sometimes to serve and to protect. Sure, we need some changes, they need to be made, but when you're doing this global attack on the entire department, when you find a chief like Chief Parks, who's unlike any other chief of police that I've known of, took it upon himself to purge the department of some of these police officers who crossed the line. And nobody ever commends Chief for what he's done. I made it known to the Justice Department that I thought they had some other overtones there, given the fact that he was making some progress, and other chiefs, I know Daryl Gates was around, and nobody even attempted to speak out like this when he was the chief, and nothing was being done. But you get Parks in there, the good guy in there, and you want to smack him around. Anyway, I excuse myself. Thank you.
Please give Senator Lieberman and Vice President Gore our collective regards and tell them we would have been there, but we're working. Okay, that seems to complete, uh-oh. I don't think we'll put you on the mic for that. All right. Now, have we got an unresolved issue here? Ms. Goldberg and Mr. Wax have suggested that we look at adding in some additional material. Do you want to?
Well, as it relates to, I think
You wanted to defer that to 86?
Well, at least on the internal affairs oversight, relative to the potential of a department or some complaint, this is in fact the complaint input area of the consent decree, and that would be an appropriate time to discuss that issue.
But now the issue that was raised that's not in either of those, which we'll get to somewhere toward later on, is the question of additional civilian review in addition to the police commission. Okay, but that takes us to paragraph, that was 73, right?
That's right.
74, 75, 76, sorry, 74, yeah, 76, 77, 78 through 81. These are all C paragraph, and that brings us to paragraph 83. And excuse Mr. Holden, since he's gone. He's still here. Well, he said he was leaving. Oh, sorry, I thought you said you were leaving. Yeah. All right, ladies and gentlemen, that puts us at a quorum. Anybody else leaves, and we're done. 83, Ms. Goldberg.
I just first had a question about why we would want 13 categories, which include policy, procedures, chronic, crank, frivolous, and complete, withdrawn by chief of police or other judicial review. Why do we want to hold on to those? I just don't understand.
I'll try. We had fewer categories some years ago, and then there was some distrust because of something called a miscellaneous memo. Many of these categories were embodied in that miscellaneous memo. So in an attempt to show all the possible ways and reasons which misconduct allegations might be adjudicated, we began using all those possible ways. Some of these are fairness to officers, some are a matter of fairness or precision in exactly what happened. Because of the exceptions, the great majority of them are found in the sustained, not resolved, exonerated categories.
So for example, policy and procedure means that if somebody's complaining about, a homeowner complains about a helicopter flying over their home, that's not attributable to any particular officer. All these complaints are taken, processed, put on Forms 1.28. I'm sorry, I've had the misfortune to learn. And then it would be adjudicated in that way. That one shouldn't be attributable to a particular officer. Also, I point out that Penal Code Section 832.5 contemplates the notion of a frivolous complaint. So that's one of the categories, and it's contemplated by state law, which is different than what DOJ is proposing here as well.
Why would we have an incomplete investigation, or why would it be withdrawn by the chief of police?
I can give you an example of each. We had a case some some months ago where the city attorney advised us we could not proceed. We came up with some information that was judged to be the kind that we would face civil action or legal action if we proceeded in any fashion. So that became withdrawn by the chief of police. I'm sorry, the other category you asked about was? Oh, incomplete. There are those legitimate times when we get an initial bit of information that can not go any further. By that, we take all reasonable efforts in finding out the who, what, when, where, and why, but for one reason or another, because the source was anonymous or has moved or has refused to cooperate with us, you just can't, in fairness, ascribe it to an officer and come up with a finding, so you have to say it was an incomplete investigation, because that's the facts of the matter.
Also in this section on 83, it shows you lining out virtually all of what the Department of Justice suggests and replacing it with the LAPD shall not close any misconduct investigation without rendering a disposition. Why do you prefer that to shall adjudicate all misconduct complaints using a preponderance of the evidence standard?
As I understood, they didn't like our 13 categories because they were afraid that in those 13 categories we were burying or hiding things rather than dealing with them face on. We thought that our adjudications were fair and reasoned and developed by Chief Parks with due regard for many concerns, and so to get around their concern that we were losing legitimate allegations somewhere in that 13 complaints, on their suggestion, we agreed that we would always reach a conclusion, so it would be retrievable. If anybody had a complaint later, we could go back and trace the entire history of that allegation.
So there's no disagreement now on the language there? There's only disagreement on the number of categories?
I think even that was resolved by their latest language, which said we should try and limit the majority of our findings to 4 or 5 specific classifications, and that there should be, in their judgment, some kind of an audit to our use of the other allegations, and we have no objection to that.
Okay. So you're saying there's no disagreement left on 83?
Well, unless my team members tell me I'm wrong, that's my understanding.
I think the issue that I understand is left open on 83 is working this audit into the other audits that we're doing and just making sure it's not redundant of all the other audits we're doing. But this was one that, again, I think was proposed at about 2 in the morning Thursday night, and frankly, we got fatigued and marked it as open but wanted to go back and reread it after we'd had some rest.
Okay.
Okay. Jerry, did you want to add anything to that?
Just say, if we haven't worked it out, we will, because it's not, there's not that much of a disagreement.
Okay, Mr. Hernandez.
We bought into that one. Right.
Members of the council, and again, I was interested in the first example given by the chief as to why the investigation was incomplete or withdrawn by the chief. And you mentioned an example of where the city attorney talked about potential city liability exposure.
Correct.
How do we differentiate those kinds of issues and have a clear understanding as a council of what's going on?
One of the features of this agreement, Councilman, is also that all the discipline investigations, all the IAG investigations are subject to audit by this agreement and currently by the Inspector General, so that the Inspector General will audit all of these instances, either where discipline was imposed or where it was not imposed, where conclusion was reached or some other disposition of the matter came forward. So the check on the department's handling of the misconduct complaints is audits by the Inspector General, as well as, review by an independent monitor of the Inspector General's work.
Right, but that still won't tell us what the potential liability was, right?
No.
Is there a reason why we want that firewall?
Well, we don't want someone's decision or review of a decision, whether or not the discipline was appropriate or not, to be influenced by a question of financial liability. I don't know if that's
Well, I'm just
question.
saying right now there was a lot of issues we weren't really aware of because they might have created potential liability. And, what I'm hearing is something.
I'm not entirely familiar with the example raised by the chief. I don't know, I'm kind of speaking in the dark here, but there may be occasions where our office, in reviewing the way the department is proceeding on a matter, flags a problem that indicates that the investigation can't proceed because of a variety of circumstances. They may have been, done something improper in the investigation, or there may be impact of a criminal investigation going on. I don't know exactly what the situation is.
And you're saying
here.
that kind of situation would not arise under this program?
No, it could still arise.
And so then what would happen in that instance? See, that's the question I'm really getting to.
Well, that even though if there was some legal reason we stopped it, I can't, put my finger on that particular case. That's still subject to audit by the IG, who could look at that case and determine whether or not the city attorney's, conclusion was fair or not.
Okay, that was more my question. So that would still be subject to an audit by the Inspector General?
Mrs.
Also,
Walters.
it also would go to the commission.
Mrs. Walters.
Thank you. I just want a clarification on paragraph 83. Mr. Chaliff said he thought, and Ms. Martin said they thought it was worked out. Is that your understanding, Mr. City Attorney and Mr. CLA?
I think we can work this out with DOJ. Quite frankly, it's one of the issues that I have a hard time understanding either side. So it seems like it's imminently negotiable.
Well, let me just say that one of the challenges in this document is to get it to where people who aren't lawyers can also understand it.
Right.
And
The
since
question.
most of the world aren't lawyers.
Well, in this country, it's about half, but...
My position was that we ought to try as much as possible to go with the Department of Justice in limiting the number of categories that would constitute an end to the investigation, because that was, to deal with that situation of too many complaints falling through the cracks or being unresolved. And that if it didn't fall into one of those categories, that, it's still subject to audit by the IG in the rest of this document. So I don't know if they've agreed with us that as long as we get a majority of the investigations resolved by one of these 5 categories, that's okay with the Department of Justice. I don't know that to be the case. I think that they would still prefer that we finish investigations with one of these resolutions or explain why we didn't.
Okay, and this also would mean then that there would be no more cases without disposition?
Yes.
As they are requiring?
Right.
Right.
Okay, fine.
Right. Additionally, as another paragraph down or so, there's within 5 months, most misconduct complaints have to be completed. And also, there's a provision that within 60 days of the statute of limitations expiring, they have to bring them to the commission and explain. So there's lots of checks on making sure things just don't get lost.
Absolutely. Okay, thank you, gentlemen. And Mr. Chaliff, you seemed to start to respond to me and didn't
No, you
finish?
mean in relation to this? No, I'm still convinced that we're going to work this out. It's not that difficult, and as long as there will be a closure with the disposition attached to it, there won't be the chance of what was happening a couple of years ago where there were miscellaneous memos that got put in people's drawers and never saw the light of day.
Yeah, okay.
Okay, I think that finishes 83. 84, both parties agree. 85, 86, 87, 88, 89, 90. Well, we can go back to them if you need to, but we have agreement between the Department of Justice and our negotiating team on 84 through 90, which would bring us to 91, except, hold on, one thing. And I have 2 people who essentially want to call those special. Go ahead.
Okay, 86 we should discuss. That was talking a little bit about coupling that with the Chemerinsky report relative to the independence of internal affairs.
Okay, but Mr. Pacheco, Mrs. Walters, and Mr. Wax each have comments, so let me call on them, and then we'll see which paragraphs those relate to. Mr. Pacheco.
Madam President, you were moving so quickly, I thought we were going to get to 92.
Well, we're not quite there yet. I wish we were, but we're not. Mrs. Walters?
Yes, on the timeline further down that, to which Mr. Deaton refers, the set of timelines that are, whose...
I'm sorry, which paragraph are we in?
This is paragraph, it's the first paragraph on 86.
86,
86,
okay.
first
That's fine.
paragraph, end of that paragraph, the last sentence of that paragraph.
Okay.
In fact, the last
That
phrase.
is a very long sentence.
Yes, and I'm not going to read it, just the last phrase, absolute last phrase, the last two lines of that paragraph that states, or whose conduct is the basis for the city being found civilly liable by a judge or jury. And they're proposing 3 years time limit on data. And they're talking about a judge or jury. It seems to me that some of these cases take longer than that to adjudicate. So are we in danger with the 3-year timeline here of opening another area that something could be lost in?
I think there's two different informations. The 3 years is the information, how long it has to be maintained in teams after the officer has left the force. So once the officer has left the force, you wouldn't be disciplining the officer, even if the officer had resulted in the city being found civilly liable by a judge or jury. You have, however, hit on an issue that is problematic. Under our current 1070 in our charter, you only do have a year in which to impose discipline, so it is quite possible that the chief would be unable to impose discipline under this category if the judge or jury made the ruling after the 1-year period. So, but the chief would be constrained by the charter and would have to make note of that in this report to the
Well, there's
commission.
some other areas that require charter changes. I would move that we put this area there as well. If a charter if a charter provision is going to prevent us from acting in the event of a liability decision that goes against the city.
It currently does. Yes.
Yeah, well, I would move, Councilmember, that we put it on. And Madam Chair, I have one more quick question here on the second paragraph after this one. It's still 86, where it says, LAPD shall continue its practice of having managers evaluate all misconduct complaints. And my concern is that the evidence of current practice, questions arise in some instances.
Okay, that's the 87, but just talk
Oh,
about
that's
it
87,
anyway.
all
No,
right.
it's okay.
My
Just-
notes are on top of 80, of
Yeah,
the number there. So can we, you still have other things on 86?
Mr. Wax wanted
All
to be
right,
heard.
so then may I ask a question on 87?
Certainly. Well, let's finish off 86 here. Mr. Wax?
Grouping.
Yes, we were. I'm sorry, go ahead.
Well, but I'll wait if you want to, I want to talk about number 90.
Okay, why don't you hold that for a second, and let's, on 86, then, are we,
I just wanted, this, in part, I think, responds to Mr. Chemerinsky's proposal, because what it says is that every quarter, the chief of police will give a report to the police commission on all discipline, and that report will be given to the inspector general, and within 45 days of that, the commission, based on the report made by the inspector general, will sit down with the chief and go over the discipline. That every quarter will become part of his or her performance evaluation, and that seems to me to be the kind of civilian oversight to the discipline of both internal affairs and
That's
anything
what-
else
yeah, that's what
that
you
goes
were-
along. And I think it's actually one of the more meaningful parts of this whole document of how, in a very public fashion, requiring the commission every 45 days to address it, every 90 days, and a time limit in which to have to do it, that I think that really gets at the heart of
all right, but,
anything.
and the only other question is, at what point is that essentially a report to the public? The commission meetings
Once
that
it
would
goes
cover
to-
that would be a public meeting.
That's right, and the response, in all likelihood, of the Inspector General, the nature, and I think that since it's talking about it in general, I think that even the evaluation of it would be at least somewhat in public.
All right. Mr. Hernandez, did you want to talk on 86?
Yeah,
Okay, go ahead.
I just have two questions. One is, what happens now in that regard? Is there any kind of a quarterly report by the chief regarding discipline?
Not like this. There are different reports, and we've now instituted a new procedure about 6 months ago about getting back responses to discipline imposed when we found an officer-involved shooting or other out of policy, but in a manner where it's all put in one place, no.
So this is a pretty comprehensive point
Yes.
that's before us right now, that's very different from what's happening now. And two, part of the criteria that's to be part of that report would include conduct that, for example, was the basis of a city being found civilly liable by a judge. Would that trigger a different kind of review in that report? Because normally when that happens, it's years after the fact. And to what extent is that review?
Well, if, as Ms. Martin says, it would normally occur more than a year or two later, then the only discipline that could be imposed would be a paper penalty. It couldn't be actual discipline. But even then, the appropriateness of what the chief does or doesn't write would be reviewed.
Right, and, but at least we would be reviewing the process that went into the review of that incident from its inception to...
Additionally, the commission would be in the position of knowing when these things were happening to see if a pattern was developing that should be addressed too, through this
Okay.
report.
But that's not part of the requirement.
No, but because we're getting this report and the way we're getting it, it gives us more information to be able to do that.
Okay.
Also, just might add, I'm sorry, but it is in context of all the discipline. It's not individual cases that
Right,
may take
right.
off. in a-
Individual cases are personnel actions, and that's a whole other issue.
But also, individual discipline items can take on a life of their own when they don't have context. This is 3 months of discipline.
Right. All right. Ms. Goldberger, you want 86?
I think that the item that we're talking about does go a long way to deal with part of what I was trying to raise. I don't think it entirely deals with whether or not there is oversight of the actual looking into complaints. Because that one goes to the end result, that would be reviewed. The other would go to the process. So I'm still not sure that we're all the way there yet. But in the Board of Inquiry report itself, this is not Chemerinsky now, this is the BOI, it says, time and again, it was brought to the board's attention that there's a strong perception of a dual disciplinary standard, one for captains of above and the other for lieutenants and below. That's in the Board of Inquiry report regarding recommendation number 32. I'm still concerned that nothing so far in this document addresses that widespread perception. And so I am inclined to think, although I've never really taken a position on it up till now, but I'm inclined to think that we ought to be looking at some point in here at a uniform penalty guide, which I know has been resisted by the department, and I have never pursued it because I don't have an opinion on one way or the other, but I just want to address this whole widespread perception that there's a dual standard, which even BOI attests that they know that perception is out there. We have to address that at some point, and
Well, I
don't...
think what we're doing is setting up a situation where, if that is the case, it will become very visible. We are setting up a procedure where every discipline has to come to the commission, where all misconduct complaints have to be, are, to the extent possible, completed in 5 months. If within 60 days of the statute of limitations not being running out, they have to report to the commission and explain why. There will be a whole database of who has been, what are the complaints and what has been the result of those complaints. We will have in black and white exactly what the situation is, and if at that point that perceived notion is correct, it will be very visible And all that information also is going to be audited by the chief's audit team and also by the Inspector General. And so I think that there will be a very visible and very auditable track record on this issue does not exist today, and it won't be an assumption that people have. It will be, in fact, cold facts.
I hope you're right.
I
Mr.
think I am.
Pacheco.
I just wanted to comment that the disparity in treatment between the rank and file and the commanding officers was an issue brought up during charter reform, and that the league had recommended an additional or a changing of the structure for the review board, the Board of Rights panel, and that the elected Charter Reform Commission did adopt that as a remedy for this issue, but during the negotiation process, the appointed Charter Reform Commission felt that it should not be included in this compromise charter. So we can always reopen that chapter and look at that as a possible remedy for this perception issue and the disparity in treatment between rank and file and commanders or other supervising officers.
All right, I have nobody else on item 86, but you were on 87. You're on 87 and Mr. Wax is on 90. We do have one more person who showed up after we closed the public hearing, who wanted to be heard. What is your pleasure? Do you want to hear from her? She's been sitting here for hours. Everybody okay? All right, in that case, thank you for your patience, and we'll hear from Margaret Enright. And ask you to be relatively brief, but we do appreciate your patience.
No, thank you for hearing me.
Pull the mic up. There you go.
My name is Margaret Enright. I'm a married homeowner in Encino, 39 years old, and have no criminal record. Since last December, I've been the subject to bias and, in my opinion, outright harassment from the LAPD. On 12/7, I was assaulted by a neighbor's boyfriend while behind a fence in my own yard. The LAPD would not arrest him despite my visible injuries. Several minutes after the officers left the scene, they returned and arrested my husband and myself on felony 422 PC, making terrorist threats. We had not said anything to or had any contact with the alleged victims. There was no legal basis for the arrest, yet we both spent about 21 hours in jail on $50,000 bail each. I did not receive medical care for my congenital heart condition until hours after my arrest and transport to another jail facility, despite our numerous requests and notice to the LAPD that I was experiencing severe chest pains. There are also serious constitutional issues concerning the method of the arrest. The arresting officer was on the scene shortly after our release the next evening, asking questions about how we got out. We installed multiple fixed security cameras. On video, May 17th, I had an LAPD sergeant raise his voice to me in the middle of the street, telling me several times that if I called the police one more time, this place will burn to the ground before the LAPD will respond. On video, June 9th, a police call on a loud transistor radio is placed by the neighbor after she sees me leave. The first set of officers state they do not hear a radio and leave. The second set of officers is at the location for about 45 minutes, jumping back and forth over my fence, pounding and kicking on my windows, saying things like, "She says she has a whole arsenal in there." Not only was I not home, no radio is heard on the tape. On July 12th on video, 11 p.m., the neighbor's companion identifies himself as a cop and has a scanner. The neighbor screams at our house that I am digging my own grave back into jail again. You be heading that way. She then says that the arresting officers, whose name I will omit here, will mess me up. Not complying at all with the LAPD mission statement and management principles, there are many other instances of unprofessional and biased conduct, including on 2 separate dates on video, LAPD officers trying to open my locked mailbox. Multiple failures to make police reports despite ongoing and witnessed incidents, and multiple statements that if we do not leave the neighbor alone, we will be in trouble or arrested again. I have spoken to the neighbor on 1 occasion. I told Internal Affairs about these incidents August 30th. While I was not turned away, I have the feeling that if my allegations do not agree with their findings, that I will be subject to penal and civil remedies. I refused to sign the advisory form 148.6, but it was present. About 2 days later, on video, September 2nd, at about 4:15 a.m., a marked LAPD police car goes by my house twice, and on the second pass shines its spotlight over the entire front of my house, and only my house. I went to the police station the next morning and found that there was no call in the area. I worry every day that the police will come and arrest me again for no reason. I have gone in person, phoned, email, or written to everybody I can think of, from the Inspector General's office, police commissioners, Chief Parks, Deputy Chiefs Bostic and Gascon, Mayor Reardon, and my councilwoman, Laura Chick, with no responses from anyone. There has been no accountability or apology offered for what has happened and still continues to happen to me. Anyone that wishes to contact me may do so through margaret@emailvista.com. Thank you for hearing me.
Thank you. Okay, moving back to item 87. Mrs. Walters, would you press your speaker button again, please?
Yes, thank you, Madam President. Paragraph 87 states, and it's a very short two-sentence paragraph, that the LAPD shall continue its practice of having managers evaluate all misconduct complaint investigations to identify underlying problems and training needs. After such evaluations, the manager shall implement appropriate non-disciplinary actions or make a recommendation by the proper LAPD entity to supplement such action. We get an awful lot of suits for settlement that have at their core some action that could have saved the city a lot of money had the officer not done that. Now, the police department isn't the only department where that occurs. It happens in other departments as well. But the police department is the subject here and the subject of the consent decree. And it seems to me that the evidence of current practices do not bode well for the future when these future practices are based on a continuance of what they're doing now. Just based on the questions that I have raised, and others as well, when we get these suits, some have attached some corrective action, but the majority of them, no corrective action has been attached, in my opinion. And the corrective action could, run from, I think the most innocuous corrective action is a letter in the person's personnel file. Sometimes we hear that the person was ordered to undergo some retraining, but it is by no means, it seems to me, widespread. And I would like to, if this is going to be part of the consent decree, like it to be a much stronger statement and mandate to the department to do this. Because I think we pay out a lot of money that shouldn't be necessary, behavior that adult people shouldn't become engaged in, adult people with judgment. And the police department are supposed to be adult people with judgment, with very good judgment. That's one of the selection criteria, I believe. So, Madam Chair, that's the concern I have on 87, that it needs to be strengthened beyond what current practices are.
When I might respond, the current practice, this is I think the policy of the LAPD. In order to back this up in the consent decree, however, as you recall, we have Teams 2, which can relate any incident back to whoever the supervisor and or the manager. That the managers will be evaluated on how well they do under Teams 2 and how well they follow through on this. This will be audited by both the police department and by, in some cases, the Inspector General. And then the independent monitor will be looking over the shoulder of the whole process. So I think this has, with Teams 2 and with the other auditing process, some teeth to it. And basically, since it's the existing practice, the thought was in the consent decree that we would continue to do what we're doing, but we would agree that if we're not following through, which is true with a lot of the continuing policies, concern of DOJ is that not so much that our policy is incorrect, they don't believe that we follow through on them as well as we should. We have set up a very elaborate mechanism to make sure that we follow through. And so I think that is one of these, that's the case. Okay.
For years, I have one. Oh, thank you.
Okay, I believe item 90 was next. Mr. Wax, you want to hit your button, please? Thank you. Go ahead.
I think that the Chemerinsky report singles out retaliation as one of the really significant factors in maintaining the code of silence and in maintaining the problem within the department that often turns its back on the kind of things that we've seen. 90 here is, is fine where it says the city shall prohibit retaliation in any form, but it's one sentence, and I think the Chemerinsky report sort of tries to set out something to give meat to that, a set of policies, of guarantees, of encouraging people to come forward, be able to speak with confidentiality, prohibiting retaliation, punishing supervisors who do try to retaliate. The whole idea that somehow if you speak up you're a traitor, or somehow if you speak up you're not one of the group, the less than desirable assignments that occur, the freeway therapy, I guess it's called, among other things. The whole range of issues, retaliation is a really important factor. And I think that you need more than just one sentence, in essence, saying thou shalt not retaliate. I think that there's no reason why that can't be beefed up so that there is a set of procedures and guidelines for people to speak confidentially, for people to be rewarded rather than punished for their efforts. And I think it made it a very persuasive case that retaliation is one of the ways that you keep the code of silence. Retaliation is one of the ways you sort of keep the lid on people. And I don't think we have enough here in number 90. It just seems, it's one sentence, and while it's nice, it doesn't seem to me to back it up with a set of policies and procedures that could really make sure that whistleblowers are not retaliated against, and that people are in fact encouraged and protected and possibly even rewarded for doing that. So how can we beef this up?
Well, let me just say that recommendation 8, Mr. Chemerinsky, 8A was establish a policy, which we thought 90 did.
Okay. 8B is a system whereby they can report to officers,
right,
especially on the assurance of confidentiality and protection for reprisals. 8C is a procedure and standards,
right,
investigating and punishing those who do retaliate. I'd like to, I think we should add that kind of thing,
sure.
Language
Paragraph
in.
145. If you turn to 145, the inspector.
145.
Yes.
Dun, da, da, da.
Ta-da. Paragraph 145 says that the inspector...
That's pretty tricky. Each time he comes up with something, you refer him to another one down the pike. It's hard to keep track of all of that. That's very slick.
There's method to my madness.
I always suspected it.
I have a lot of C codes in this.
Okay, but it lacks the confidentiality issue.
City attorney has ruled, I think, I'll let them discuss that under the charter is not...
I can't imagine the city charter prevents confidentiality in a situation like this.
Well,
in fact, we have whistleblowers.
An anonymous complaint can come in, and we are supposed to investigate anonymous complaints. But as to confidentiality, this is the issue that the chief of police was very strong about, is that the chief is going to be responsible for discipline. The chief's going to have to be able to do an adequate job of in investigation here, and that may mean need to talk to the most important witness, the one who's complaining here. And so if giving the some group the ability to give confidentiality interferes with the ability to complete the investigation.
Well, then you have the situation you have now. And people can't come forward. And we're trying to say what went wrong so that it doesn't happen again. Retaliation and the threat of retaliation is a big issue. It keeps people from coming forward. It maintains the code of silence. The code of silence is a part of the culture that gives rise to the problem in the first place and tolerates it. You've got to find a way to correct that. And if one of the ways, and it seems very, very reasonable, In fact, I think we have that on our own city ethics laws, that people can go to the Ethics Commission here and make complaints, and there's prohibitions against retaliation among other department heads and all and other city employees. We've got to be able to instill that in the police department. And I can't believe we're not looking for a way to be able to do it rather than a reason why we can't do it, because not doing it maintains the status quo. If doing it requires a charter change, then let's put in a charter change. I don't think it does. But the point of it is, it's an important issue. It's been identified by a lot of people who've looked at the issue of the broader culture. They identify retaliation as a major issue. We're not going to change things unless we then deal with those issues. And if confidentiality is needed in order to prevent retaliation, then we've got to find a way. We can define the framework in which it can come, the guidelines for it, but I think we've got to work at putting something like that in here.
Okay, thank you.
Councilman, the point that I guess this all hits is the person can request confidentiality, but if they're an LAPD officer, the point where this hits, and we have to make this policy decision, is right now we're saying that doesn't relieve the officer of the requirement that they are supposed to report misconduct through their chain of command. And, so that's where we're in conflict. If confidentiality, they can do this confidentially, but we're saying, the department is saying, that doesn't relieve you of your
But they
responsibility.
don't do it because they're afraid of retaliation. I mean,
Okay.
therein lies the whole thing. That's
Joel, press your button again, because I think this discussion's going to take further shape. Ms. Walters.
I had a concern marked in my notes about the same thing, and I wondered if some type of penalty were attached to an officer, whether they were a command officer or lower-ranking officers, for trying to threaten somebody with retaliation. Would that help in stopping the threats and stopping the retaliation?
That's misconduct.
I know it's misconduct,
And-
Mr. Deaton, but it happens.
Right.
And from all that I hear, it happens on a regular basis. Officers, in fact, we've had some cases where people have sued and won because officers, their fellow officers, were trying to exercise some intimidation over them. And a particular case, the officer, I think, wasn't personally aggrieved, he just didn't like this person.
Now, Chief can correct me, but I think at this point, those misconduct complaints go to the chain of command, and now, under this proposal, they would go to internal affairs?
For investigation, correct.
Right, so...
Talking about initial reporting?
Right. We've switched, I mean, to some degree, we have on paragraph 91, when we've shifted quite a few of the misconduct complaints from chain of command to the internal affairs unit, that is one of them, the J. Any act of retaliation or retribution against an officer or civilian would then be investigated by internal affairs, and it would not go through the chain of command. So there is a shift.
So does that have a high probability of changing this culture of retaliation?
I'm assuming that by sending it to internal affairs, have it audited by both the chief's audit team and by the inspector general, that this would again bring light to these misconduct complaints would not be ignored or could not be ignored, not lost in a chain of command process. Also, it has to be reported. There's a goal, these being completed by 5 months, et cetera. So
All right,
I
not
think
all-
there's a
Go ahead, I'm sorry.
there's a reasonable expectation that this would be done very fairly in this kind of a process.
All right, so it will be dealt with fairly, going to internal affairs as far as the reporting procedures and investigation procedures go. But I'm looking for what will cause a sea change in the culture of the group that makes them feel, or some of them feel, that they can engage in this retaliation without any untoward thing happening to them.
I think it's the same sea change that when the CHP starts pulling people over, going over the speed limit on a repeated basis, the speed drops. And I think that if...
Yeah, but the penalty attaches there. They can, all this reporting and auditing, it's just reporting that something happened and auditing that reports were kept of what happened and that somebody looked at it. There's no penalty to the perpetrator.
If the misconduct complaint is correct, and then the police department doesn't follow through on it, then you have two problems, and I think that would be sorted out in that process as well.
Okay, I hope you're right.
Let's check. I do too.
When a complaint is filed against an officer, I think I'm asking you, Chief Pomeroy, when a complaint is filed against an officer, does the officer know who made the complaint? Is that part of the process?
We do have the ability to prevent the complaint against officer from knowing who the complainant is for some period of time, but eventually the complaint against officer will find out about it.
Through the years on this whole issue of retaliation, I've often heard that there's a problem that occurs if, for instance, I'm an officer and I file a complaint against you, and you counter-file complaints against me in retaliation. But the department is obligated to investigate all complaints. And so what is the solution to stopping those complaints from coming in a retaliatory way? Or is there a way to stop that? Because from what I'm understanding, one of the most common forms of retaliation is to hit a complainant officer with cross complaints, if that's the right terminology.
That's a difficult problem. We have wrestled with it, and I think the only solution to that is a quick and competent investigation that wades in and figures out exactly who was retaliating against and who was at fault, and if that can be determined, then the person who was retaliating, there should be some action taken against them.
And that was my next question. That is misconduct, isn't it?
Absolutely.
It's considered a frivolous complaint, retaliatory complaint. What's the track record with the department being able to do that?
Very few. It's very difficult with all the complaints and cross complaints that go on. It's very difficult after the fact to figure out exactly the motive on the person filing the complaint.
But just the fact that Officer A files against Officer B and then B files against A, is not that a glaring clue?
Well, it's a glaring clue, but often when you wade into that, it's so difficult to figure out which side was the more at fault and what penalty should be meted out, and if at all. I'm not saying it's impossible. I'm just saying in my personal experience, it's difficult once you get in there to figure out, forgive the phrase, who was the bigger jerk.
Right.
There are times when one's completely innocent and the other one's completely at fault, but
And then there's times when they're both
exactly.
have
There's other times
problems.
they're both at fault.
Right. Well, anyway, I raised it also, colleagues, because I want to make sure everyone's aware that this is one of the biggest problems of retaliation and not so easily solved.
Ms. Goldberg.
I think that's why 8B is so important, to develop a system whereby officers may report wrongdoing by other officers to the Inspector General with the assurance of confidentiality and with protection from reprisals. If we don't have that kind of whistleblower legislation in this consent decree, in my humble opinion, after working on retaliation personally for 7.5 years and making not one whit of improvement in the situation, my belief is nothing will change in terms of code of silence. That's my prediction. Nothing will change. We will just go on merrily as we are now. Because here's what happens. I complain that I saw someone be involved in something pretty serious. not writing down a report on something they observed that was a felony, whatever it is, something serious. That person finds out I complained, they get 15 of their friends to write complaints about me. And now, because everybody has to discover everything about every complaint, and since I have, the fact that I have never had a complaint about me at all is not used to dissuade Internal Affairs from investigating each of the 15 complaints. Every person I've ever known on the department no longer wants anything to do with me because they are now being interviewed as witnesses. Everybody who I've ever known doesn't want to work with me anymore because now I've been labeled. And I assure you, this only has to happen in a division once before everybody gets the message. And I get exonerated 3.5 years later because 15 complaints take a long time. Suddenly I'm not a shining star moving up. And if I'm Liz Hatter, I'm now on disability retirement. That's not a stupid scenario that I'm describing. And it happens. And it happens all the time.
So,
and the policy has to
focus on what you want us to do.
Well, we have to have some confidential way for people to report wrongdoing by other officers to the Inspector General. We have to have that. If we don't have that, then we're dancing around the problem of retaliation. And we need to have whistleblower kind of rules that are the type of whistleblower kind of rules that are used throughout public and private large sector organizations. And they have to exist for the police department as well. And if we don't do those two things, the code of silence will remain intact.
Mr. Fewer. Wait a second, hold on one second. Let's finish this item and then give these poor people a stretch break. I think we can take like 5 minutes afterwards, but let's try to finish this item first. Mr. Fewer.
Thank you, Madam President. Mr. Wax and Ms. Goldberg have both raised the same issue. I'd like to turn to Chief Pomeroy, if I could, for a moment. I think, Chief, the arguments that have been made obviously have some merit to them. I also understand the Chief's perspective, which is if you aren't going to enable the department to interview the major complaining witness, it won't be as thorough an investigation or as fair a one as otherwise might be the case. But clearly the status quo isn't good enough. How do you recommend we get past where we are at the moment with a seemingly intractable problem?
Well, there's some other subtleties in this. We are dealing with people who are sworn to uphold the law, and I find it difficult on a personal level, not necessarily representing the department, but trying to add to the conversation, that we would allow someone who should have intervened in a criminal act, such as witnessing an incorrect report or a beating or something, and then let that person who's sworn to uphold the law wait 2 or 3 days. Not a civilian, not a citizen, but an officer. I have some personal difficulty with that. You know the arguments. We've all heard the chief. I have, on a personal level, agree with that. It seems to me that where we separate confidentiality is when it comes time to make judgments about why people have come to us. And if a person delays or doesn't report, and we understand why, because of the reasons Ms. Goldberg points out, then that's the point for the chief to say, I understand, and there'll be no penalty attached. When we believe someone has delayed and only come forward because we now have them, so to speak, and they're trying to fess up to avoid some sanction by the department, that's the time we should have some sanction on that individual.
Chief, actually, you've raised a piece that we should have focused on earlier and had none, and that is this very complicated, publicly discussed issue. Do you let an officer off the hook for failing to disclose something that they were aware of earlier? That obviously implicates the confidentiality issue as well. But yet, I mean, I think that the council, at least many members of the council, are very concerned that enabling the status quo to continue really does foster not only a code of silence for reasons related to wanting to protect oneself against retaliation from other officers, but also a code of silence related to wanting to save one's own skin because one didn't come forward in a timely way and therefore is in violation of department rules. Both of those issues, which are independent of each other, are going to perpetuate the status quo. It doesn't. Are you satisfied that this is the best we can do given that conundrum now?
I'm not necessarily satisfied it's the best we can do, but I would point out, as Mr. Deaton hinted at, we have a document that in total deals with a number of issues, and that's one of the major issues that this document before us deals with. And among our 10,000, nearly 10,000 sworn employees and 3,500 civilian employees, we have a great many who come forward and who the department does the right thing in taking a complaint and quickly adjudicating it, and has the support of other officers. And that's not to deny the situation that you and Ms. Goldberg described don't exist, but we have to show our support, I think, for those people who do come forward and who do uphold the policies and procedures of the department.
Well, I'll press red again just to finish.
Ms. Mizikowski.
Members, I think we're coming to grips with something that has obviously been a very, very difficult issue. Where I think I differ a little bit with some of those who have spoken, absolutely I agree with the strengthening all mechanisms and policies and putting in place enough force so that we can identify and prevent reprisals that become retaliation. And I think that is the key and the focus, particularly of item number 145, where Mr. Deaton suggested we look at that if the Inspector General determines that such complaints indicate possible retaliation, he's supposed to create a report, an investigation, and send it on to the Police Commission. That's where I think we need strengthening the policy and strengthened by way of the IG having a real focus on that. I agree, I think, with the chief and the city attorney that we can't absolutely guarantee confidentiality because, in fact, it would impair the department's ability to investigate it. I can think of any number of instances where there might be, if not an assurance, some latitude within the department. For instance, what if two patrol officers are in a car, good friends, working things out, and one officer is aware that his partner may be, quote, on the edge, having trouble at home, difficulty with a spouse, and that officer wants to go to a supervisor and say, I think you ought to look at Officer A because I think there's some problems. I would hope that the department creates some latitude of confidentiality there. It's sort of preventative, it's not accusatory, but it's informing and giving the department something to react to. It may very well be that Officer A would know that it came from Officer B, but nevertheless, that makes sense. Where there is a real confidentiality of really reporting absolute wrongdoing, I don't think we can guarantee that, and I think the department, any other mechanism, is going to need to know that officer and talk that officer into coming forward at the appropriate time to deal with the issue. And as far as the sort of defensive, Officer A makes a complaint against somebody, Officer B, and Officer B says, well, the complaint is really against Officer A. We see that in real life. I don't know how many of you have seen a complaint from a neighbor not having to do anything with police officers, and they say so-and-so is doing something wrong, adding something without a permit, and that neighbor says, well, yeah, but this guy did this without a permit. So it's sort of human nature that once someone blows a whistle and makes a complaint, someone else makes a complaint against the first party. But I don't think we can guarantee confidentiality, but I would like to see, as Chief Pomeroy said, perhaps adhering to the spirit of that, allowing some latitude, either in why an officer might have come a little bit late as opposed to immediately, and also some sense of protecting relationships. And the other thing that this doesn't deal with is not only protection from reprisals. It sounds as if it's always talking about with the supervisor. I think inherently the code of silence isn't so much within supervisorial reprisal, but within peer group reprisal. And that I'm not sure how we get at, but officers have an acceptable, whether or not it's a code of silence, they have an acceptable tolerance within some ranges and not within others. And that's the more difficult issue that I think we need the IG to have some more latitude to get at.
All right, it's been suggested to me Mr. Chaliff wants to be heard, and we have our expert on these things, Mr. Merkin, here as well.
Can I just have one short statement?
Yes.
If there is this people reporting each other or some disproportionate punishment,
Jerry, we can't hear you.
if there is this Officer A and Officer B, we're going to see the results of that, the commission is, with these 90-day reviews, because we're going to see what discipline is imposed and why. So Sure we will.
Well, no, wait, no, just hold on. That's Mr. Chaliff's comment. Mr. Merkin,
Yes.
can you enlighten us here?
Yeah, Madam President, members of the council, I hear that the issue of the ability of the Inspector General to promise confidentiality to individuals is now being discussed. And you should understand that there are limitations upon which, that are placed on the ability of the City Council or even a consent decree to control this subject. We have to bear in mind that there are the privilege that would be attached and claimed by the city with regard to the confidentiality of the information or of the identity of an individual are dictated in California law by statute and in federal law by what is known as the federal common law, essentially what the judges determine to be the privilege. In each instance, it's really very much the same privilege, or there are differences, but in the end, there's a balancing of the need for confidentiality of this individual who's gone to the Inspector General against the claimed need of the litigant, whoever that litigant may be. That litigant may be a criminal defendant, it could be a civil rights plaintiff. So right there, you have a built-in limitation that's beyond your power to control. What the Police Commission has done, and the Police Commission has the ability to determine what policy should apply to the flow of information from the Inspector General. In January of 1999, they adopted a rule that attempted to balance out these competing concerns. And there are 3 exceptions to confidentiality because the rule begins with protecting the identity of the individual who's gone to the Inspector General. But the 3 exceptions are these, where it's necessary to effectively investigate an allegation. That's the first. The second is where the law otherwise requires it, and I think that contemplates, for example, where a court would order it. And then thirdly, where the city attorney requires it, and I think in contemplation there is in the defense of the city in litigation. So that is how the Police Commission early last year, tried to balance these concerns out. The Police Commission has the ability to modify that rule should so desire, but even the Police Commission has limitations imposed upon it by the law.
But can I add one thing to that?
Please.
The effective investigation and the issue with the city attorney is basically determined by the Police Commission. So it's not just somebody comes in and says, I need to do this. To finish my investigation, we determine whether or not we believe that's true and whether the information should be.
So there is
divulged.
some level of check on that.
On all of it, and if the Inspector General comes to us and says some court ordered us to...
That's a little different,
That's
yeah.
different, but, and the same thing with the city attorney if there's some court order attached to it. But otherwise, I think you forgot one, which exception is whether the commission feels it needs to know who the confidential person is for whatever it's doing, and we can keep that private among ourselves.
Yeah, but right, I think that's the issue, is that if you find out who it is, does that then subject the person who complained to retaliation from somebody else? And that's the issue that's going on through all of this.
Well, that's where 145 comes in with the Inspector General monitoring all of those investigations as a result and determining what happened to the person after if the name becomes public, what happened to the person.
Okay. It is now 4:45. I have 3 more speakers so far on this topic. Excuse me? Sorry, I didn't hear what you said. Mr. Ridley Thomas is back. Mr. Fewer is next.
Thanks. Fred, what was the first exception? Just shout it out.
What he said was effective.
Investigating allegations.
Right.
All right. See, the thing is,
But that's determined by the commission, just so you
Right.
understand that.
Yeah, thank you. No, let's assume that for some reason we decided to eliminate that exception, just for the sake of discussion for a moment. I guess one of the practical concerns to contend with here is as long as officers know that we can't control the fact that if it's a serious enough allegation, it might well get to court, and then the court's going to require discovery in the revelation of who it is, we're in a tough spot. And your point, that's your point essentially, is to say, look, no matter what you say about this, courts ultimately, if it's serious, are going to require that the person's name be discoverable. And therefore, what can you do? I'm uptight about that because we'd like to think we can control this to some degree. And your suggestion to us is, in the less serious matters, we can. In the more serious matters, we're very unlikely to. When someone goes to the IG right now, is there some kind of, let's assume I confidentially go to the IG today. Does the IG, before I disclose anything, say you should know, here are the rules governing confidentiality at the outset?
Yes. He reads that portion of the January 99 motion that we passed that says I'll do everything I can to keep your name confidential, except you should understand if a court orders it, I have to produce it. If the commission orders me to, I have to produce it.
Yeah, how many, under that circumstance, how many confidential complainants have we had in 6 months, a year, ballpark? Hundreds, 50, 10?
I can't answer that question because I don't know.
Okay.
Yeah, it's too confidential.
Yeah, that's right, it's too much of a secret.
Thank you.
All right. I mean, I don't have a good answer here because I'm afraid that no matter what we say today, at least 2/3 of that statement are either going to be read or implicit in any relationship that a confidential person has with the IG, and that's going to be enough to deter a whole lot of folks, even if the chief said, we're no longer going to sanction people for failing to come forward in the first, 24 hours after they discover something. But last question. Are other departments dealing with this in any different way? Have we analyzed what happens in other police departments which are thought to be hospitable to whistleblowers? If there are any such places, I don't know. I got to think we can learn from somebody on this, because this is just...
I think that Mr. Hahn stated it correctly. The real issue is if we give somebody confidentiality, and assume we do, and the commission decides not to release their name ever, and it never gets released, the only time it becomes an issue is if that officer ever gets accused of not reporting misconduct that he or she should have. It's not a defense. The city attorney gave us that opinion in September of '99 that the commission couldn't establish a rule that would say that. So basically, it becomes an issue of what happens to the officer if the name ever becomes public.
Okay, Mrs. Walters.
You know, it seems to me that so many of the problems that we have in LAPD can be traced back to attitudinal problems. And I think the attitudinal problem on this one was reflected in what Chief Pomeroy said very resolutely, with his arms folded. Well, if it's somebody just that waits 2 or 3 days and is just trying to get off and wants to get in before they think we know about it, so that they won't get penalized or whatever the rest of it was you said. I don't understand why you wouldn't turn that argument on its head and consider that a person, given the culture of LAPD today, might need 2 or 3 days to dialogue with himself or herself about what this is going to mean to their future with LAPD if they disclose, if they initiate a contact with anybody in the department to report something, and if that's a chance that they feel comfortable taking, whatever's weighing in the balance for them, or in their opinion for them. To just assume automatically that it's somebody trying to protect their own backside is problematical. It's extremely problematical as far as I'm concerned. I think that there are people in LAPD who are well-meaning, who want to do the right thing, who are sickened by some of the things that they see and hear. But because they cannot be assured that their confidentiality is going to be protected, they hang on to the information and do not disclose it, try to get a transfer out or some of the other mechanisms for getting away from a bad situation. Now, the other thing that comes to mind here on this issue is that there should be ways for a person to disclose something without going to the IG. What about somebody that wants to disclose it to their captain, or to their commander, or to their chief? There ought to be a mechanism in there where that person's identity is not disclosed, that it's protected. And I don't see the harm in protecting that identity unless you're just automatically suspecting that the reporter is indeed suspect himself or herself. So I'd like to hear some reaction to that, reaction to alternatives. Yes, report to the IG, but if they don't feel comfortable going to the IG, that was one of the reasons that people were talking about moving the IG away from here so that they would not be seen going to the IG.
Okay, let's see if we can get a response to that.
Could I ask?
Kelly?
This is very complex. I thought that ultimately, whether it's the department or the IG, that at the end of the day, you can't maintain the confidentiality of the complainant, is that if you are going to take disciplinary action or something, doesn't a person who's accused of wrongdoing have a right to confront their witness?
Yes.
I mean, isn't that the fundamental, okay. So I think it's not that the department doesn't attempt to maintain confidentiality of witnesses as long as possible. I think it's that fundamentally the law says that you have that right. Maybe the city attorney can address it.
We have that in our city laws. We have
Right.
Well, look, can we still have two more people who want to be heard, and I will call on them in a minute, but I think the message here is pretty clear, that the council is very concerned to assure a system that allows for the greatest possible reporting and follow-up of things that are wrong. Yeah. go
Just
ahead.
wanted to say that the commission's readdressing or reviewing this issue, and it'll be taken up in the next 3 or 4 weeks, as soon as we get our city attorney opinion, going back to reviewing what kind of confidentiality, if any, we can grant, and how to do that, and among other things, dealing with the Inspector General and access to information.
All right, now we have 3 more people to be heard. Mr. Wax.
Okay, I'm going to make a motion. And seriously, the approach is the wrong one. The approach is basically trying to find ways not to do it and rationalizing, and there are some good reasons. Obviously, if it's legally required to do otherwise, you have to follow the law. No one's trying to say that. But what's missing here is the point that retaliation is one of the most fundamental areas of all to address what went wrong. And a failure to adequately deal with the problem is going to almost guarantee that we will repeat it. I move that, to the extent legally permissible, this agreement incorporate the recommendations of the Chemerinsky report regarding protection of police department personnel against retaliation. Basically, it's recommendations 8, 8A, 8B, and 8C, all against, obviously qualified to the extent it's legally permissible.
Okay. Yeah, maybe you can get us copies of that, because we don't all have it in front of us.
Well, okay, someone can Xerox it. I mean, I
Yeah,
have
no,
them
we'll
here
just have
too.
no, don't pull it out. We'll just have somebody Xerox it. And while we're doing that, we'll call on Ms. Goldberg.
First,
Okay,
if you want
I'm
me to
sorry, go
summarize
ahead
them
if
for
you-
you, I can. The summary are, recommendation 8, require greater protections for whistleblowers within the LAPD who expose wrongdoing by other officers. And then there's also narrative beyond. The culture of silence, the police department must be dealt with directly. Officers who know of wrongdoing by other officers must be encouraged to come forward and must be protected, indeed rewarded when they do. In this regard, some reforms to be implemented include recommendation 8A, establish a policy protecting officers who expose wrongdoing from retaliation. 8B, develop a system whereby officers may report wrongdoing by other officers to the Inspector General with an assurance of confidentiality and with protections from reprisals. 8C, develop a procedure and standards for investigating and punishing supervisors who retaliate against whistleblowers. And I would have all of that qualified by the fact that obviously, to the extent legally permissible.
Okay, so while I call on these other people, you'll decide how you want to respond to that, or do you want to respond to it first? Huh? Well, I've got 3 more again. Ms. Goldberg.
Yeah, I just will support the motion. Obviously, everyone knows that if you're compelled by a court or those other exceptions that were mentioned, but that was not the policy of the department. That's different. Policy of the department was the one the chief mentioned, which is that you have a duty to report, and confidentiality is not an issue. You got a duty and you got to do it. That's all, period, end of discussion. And in the best of all possible worlds, Chief, I absolutely agree with you. I mean, the principle that you're trying to assert is absolutely the correct principle. It's just that in the current culture of the department, as all of us hear about it, it doesn't work that way right now. I think we could get there. I don't think we're there now. And but in terms of what you believe ought to be, you have no argument from me, and I don't think anybody else here. The question is, how do we prevent corrupt behavior on the part of some individuals from going undetected? That's the real question. Now, sometimes it's smallish end corruption, and sometimes it's the current scandal. But if people feel that they are going to be doing something which has been described to me as career-ending by blowing the whistle, whether they're right or wrong, believe me, they believe that, and I think we have some anecdotal evidence that in some cases they're right. I don't think it's universal, and I've never said that I thought it was. But I think that's why you need to say, to the extent allowed by law, there has to be a confidential way to make a complaint about these kinds of issues to the IG. And that is, I think, a big step forward, a huge step forward. But I didn't want to leave this discussion without saying that in terms of the values that you're trying to promote, I couldn't agree with you more.
Up three again, Ms. Mizikowski.
Members of the council, I was generally inclined to not amend the consent decree by the Chemerinsky report in general. And in fact, I think Mr. Chemerinsky said that too. He said adopt the consent decree and then go forward and do all these other things. I'm willing to make an exception in this instance to a certain degree, because in fact what we've been told by our team is that they thought item 90 or 91, whichever one we're on now, as informed by 145, essentially said we shall do a policy. And most of the Chemerinsky recommendations talk about establishing a policy. So I don't think that there's necessarily a conflict other than his going forward, with the one exception. And I would be willing to ask if, and I understand this may not be a friendly amendment, that we adopt 8A, B, and C, and with the exception of the assurance of confidentiality. Because, in fact, we've been told that there are any number of reasons why that ought not be the case by the city attorney, by law, et cetera. And I think if we do establish the policies other than that, so that the department has latitude to work with officers who are coming forward, to guarantee sort of that safety net, and clearly focus more on the issue of retaliation by the policies that Mr. Chemerinsky suggests need to be further developed, then I think we get there. But I cannot vote for it, which is saying that we create an assurance of confidentiality when we have the city attorney telling us that there are reasons not to do that. We have the police department telling us there are reasons not to do that. We have the police commission who established new policies itself, establishing those guidelines. And I don't think we can just throw all of that out or ignore it. I think we get to the same point by saying we need more work on this, more emphasis. We need these policies to do more and spell it out, but take out that with an assurance of confidentiality. So that would be my amendment to Mr. Wack's motion.
I feel like the sorcerer's apprentice here. There's three speakers again. Mr. Pacheco.
I just wanted some clarification. I don't have a problem with confidentiality until we prosecute or go to a Board of Rights. So, I mean, I just want some clarification. What do we mean by confidentiality? I mean, does that just mean from the beginning part? Because once we decide to act against an officer, I don't think due process allows us to continue that confidentiality. So I just want some clarification from the people who are advocating for confidentiality. Is that what they mean?
Everybody has said so far in advocating confidentiality that we all recognize that there are situations in which other law would govern, including the right to confront your accuser.
Right.
So I don't think there's really a disagreement there. What I'm hearing is a strong consensus that we want to protect confidentiality to the extent it is legally feasible, which is basically what Mr. Wax's motion says.
I don't mind that. It just sets up the situation where your confidentiality is only going to be protect it when the claim is either found to be baseless or unable to proceed to some sort of board of right or some sort, because...
That's correct.
Because otherwise, the due process
That's right.
requires that you be disclosed.
You've got
So
it. You're right on target.
I don't-
That's true.
That's how, I mean, that's the end result. Not that's what we want. I don't want that. I'm just saying I think that's what we're
Right.
going to set up, is that your confidentiality only survives until your case is basically found to be baseless, because once it's found to be credible, we will want to act against that officer who's doing wrongdoing, and then therefore due process requires exposing your name.
That's correct. So Mr. Wax's motion says to, essentially what I just said, we want to assure confidentiality to the extent legally feasible. Ms. Mizikowski has raised as a possible qualifier to Mr. Wax's motion that we may be incorrectly perceived if we assure in item 8B of, is it B? Where is it? Yeah, in 8B of the Chemerinsky report, there's a phrase in there that says, with an assurance of confidentiality, and she has raised a concern that maybe we should drop that phrase because we can't assure it if there are all these other legal things. So you guys work that out. I'm coming back to you.
Sure, to the extent legally permissible, and that's a very different, it's different than Cindy's. It's not a friendly amendment, it's two
No,
different-
she said it
two
was
different-
not a friendly amendment. So we'll get to that. In due course, I hope. Mrs. Walters.
Good.
I wonder how other agencies, federal, state, and some local, like our city, has a hotline for whistleblowers where you can call and make a complaint, leave the information without identifying yourself. This is not something new where people don't want to identify themselves. And they look into it and very often find a problem that can be taken care of without the accuser ever being brought to light. Because in many instances, the folks that will call and give that information are people further down the chain than a person in a supervisory or management position. And I don't know why with police officers the same thing can't pertain. Folks couldn't call and a hotline and make a complaint
This agreement provides
anonymously.
for that?
Pardon?
This agreement provides for that. This agreement has the 24-hour hotline. On top of that, there is an affirmative obligation placed on the Los Angeles Police Department to investigate every anonymous complaint, so that they cannot just say, oh, well, it's anonymous, we don't have to look into it.
But
So-
you're saying that you cannot promise confidentiality.
Well, if
And if
it's
you're
an-
going to have a hotline, why can't you promise confidentiality?
No, if it's anonymous,
It's
you-
anonymous,
you
you'll
have
get
it.
confidentiality because you won't know.
Mr. Deaton.
But if somebody wants to come forward and you get to know and see who they are, you should surely give them the same promise of confidentiality.
Subject to the due process clause.
Right, of course. Mr. Deaton, did you want to respond to that?
I'd like to refer to paragraph 155.
Okay. Everybody will now look at paragraph 155, and I will call on Mr. Fewer.
Keep coming up with these. How do you know? I don't know, he finds these. Oh, that's what we were
Mr.
talking
Fewer?
about before, that's what I said.
No, it's your, he's through.
Well, I
He
just-
referred
I
you to
think-
150, I'm sorry.
I think that maybe I think 155 is on point, and maybe the motion should be to amend 155 in some fashion.
You think we'll ever get to 155? It's a
Well,
half
it's-
hour now since I thought we were about to where we could stand up and stretch.
What I'm just saying is 155 is on point to what we're discussing.
Yes, thank you.
And we need to remember that if there is a situation where an officer is beating the crap out of somebody and the other officer doesn't report it, and our OHB unit doesn't roll within 24 hours, we're going to have to get an exception for that from the agreement too. So this all ripples through several places.
Okay.
You know, in the
Fewer?
case of Rodney
No,
King...
No, hang on, Mrs. Walters, it's Mr. Fewer's turn.
Ms. Walters, she has the bat. We gotta be careful.
It's only excessive force if there's a skeletal fracture.
All right. All right, now, Mr. Wax's motion has three elements to it, A, B, and C. A and C, I think, are relatively non-controversial here. One says insulate officers from retaliation from their peers and get a system to do that. The Chemerinsky report is not specific as to how to do that, it just gives that headline. C says really go after any supervisor who engages in retaliation. not specific. I think that's okay. We get then to B. So I think A and C are not the issues, it's only B. Now, when it comes to B, Mr. Pacheco said something I said earlier I agree with, and that is anything that really matters, there won't be confidentiality when you come forward, because it's going to come to fruition and then it's done. And if that were all there were, I would say that if it's true that any serious matter is going to preclude confidentiality, then I think Chief Pomeroy's arguments against confidentiality, having to do with the importance of people coming forward in a timely way, probably carry the day on balance. But then Ms. Walters raises, I thought, a very important point. Why won't the system that we are creating encourage officers, as well as members of the public at large, to simply use the 800 number if they're concerned, because there they will be fully insulated from anything. And is that what we intend to do? Aren't we, by virtue of creating this system, doing what in essence Mr. Wax has moved? The difference being that sort of the disembodied voice will be making the complaint rather than somebody in person, but the disembodied voice will be fully protected. Isn't that the unintended consequence, if that one form of complaint versus another? If that's true, how do we feel about that being the result? Because otherwise the logic of Ms. Walters' argument, I think, is pretty much infallible. So what's the word on this, Mr. Deaton?
Well, first off, I think that the system does allow for anonymous complaints, and obviously, if it's anonymous, you wouldn't know that it was a police officer or somebody else. Also, 155, if I might read.
Yes.
The Inspector General shall accept complaints from LAPD officers regarding matters which the Inspector General has authority to investigate, and the Inspector General shall not disclose the identity of an individual without the consent of the employee from whom a complaint or information has been received, unless such disclosure is unavoidable in order to effectively investigate an allegation or is otherwise required by law or the Los Angeles office of the City Attorney, provided, however, that the Inspector General shall not disclose.
No, this is the policy that Mr. Chaliff referred to earlier.
Yeah.
And, and we can amend that policy. I guess what we're all saying in some way or other is, in egregious circumstances, officers are going to know that their names will be public, because otherwise it won't rise to a level that it matters. Otherwise, you have the 800 number, and officers will then be directed somewhere
All right,
to go to
we
that
are all
step.
saying that over and over and over.
Well, so-
Mr. Chaliff.
Just so everybody understands, when we passed that policy and we wrote that policy, we did not want to give anybody the impression there was an absolute guarantee of confidentiality. That's why we wrote it the way we did, and that's why Mr. Eglash tells people that. Just like if, somebody makes an ethics complaint, I'm sure that Mr. Alpern or somebody else will tell them the same thing ultimately. Now, if somebody calls in on the hotline, or if somebody goes in and sees the Inspector General and says, I want confidentiality, and that investigation that gets started produces another 100 witnesses, and they don't need that person.
Different story.
Then that's a different story. But, just so you understand that, we did not want to create a false impression either. And that's why we wrote what we did.
Okay, I'm going to, since the next two people are speaking for the third time, I would just like to say that I think these are all very important issues, but I don't see why we want to write more things into an agreement with the federal government instead of doing them ourselves than we have to. The point of this is to establish a partnership with the federal government, and we've all said over and over again, the point is not to turn the administration of the department over to them. And I think these are very important principles, and we ought to carry them out whether or not they're in a consent decree. So I'm a little troubled personally, not as your chairman, but personally troubled by the fact that we want to keep throwing all of the additional concerns that we have into this consent decree. I think we need to deal with those concerns, but that's what all these other procedures that we refer to in here are for. And I understand everybody's concern that we won't do it if it's not in the consent decree, but that's what we're supposed to be fixing ourselves. And the reason for even agreeing to consenting to a consent decree is because we acknowledge that we're going to do all this stuff, and that these are LAPD practices or city practices that we want to establish, not federal government ones. So I think that I'm not troubled by Section 90, which we're still on, being as succinct and categoric as it is. I do think paragraph 155 is also pretty succinct, and addresses this issue, and I think we have other forums available for all the other stuff. And now I have 3 speakers again. Ms. Goldberg.
Well, I'm looking for my little list, but there were really only 3 things. I went through over the weekend the Christopher Commission report, and there were really 3 major areas. I can't find my notes. Oh, well, they're here somewhere. Too many pieces of paper. But there were basically, I think, 3 areas in the Christopher Commission report that were really critical, that were kind of not done. One of which was the issue of retaliation. And that's why, for me, one of which was retaliation, one of which was the tracking. I can't remember the third, but I remember there were 3. I'm looking for my sheet. Let me tell you why I think it's important to have this in the consent decree. First of all, it's because it is one of the unfinished pieces of business of the Christopher Commission. Oh yes, the third was move toward community-based policing. But there were 3 major areas: implementing a tracking system for problem officers, moving toward community-based policing, and ensuring that whistleblowers are not retaliated against. Those were the 3 now, that was my interpretation, but as I read through that document again, those are the big 3 that have not really been done. And I think that that's critical why I want this one in the consent decree. Other things that I may be proposing, I certainly think your argument is telling, and I will take it seriously. But this is one of the big 3. So that's my first argument. Secondly, here's the difference. If you can come forward confidentially, you're more likely to be able to describe the level of detail that will really lead to an investigation being successful than you are if you're going to leave it on a hotline. You're just not going to leave all of the names and all of the incidents and all of the times you saw. You're not going to sit and read from your notes. You need to be interviewed by someone who knows how to ask you questions to get the information out. That's why the need for confidentiality. Now, I agree that you cannot guarantee anybody, if they're right, that they're going to remain confidential, and they need to be told that up front. But there's a big difference from having your name revealed at the end of the investigation when the department has decided to take action, and when it's just getting started and 95 people of the friends of the person being complained about can gang up on you. So there is a modicum of security in having the amount of time it takes to look into this, which is why I think it's so important.
Mr. Padilla, for the first time on this point.
Actually, just to applaud you, Madam Chair, and this comment you made earlier about, this is substantive, opening up the content of the consent decree broader than what's in there already. I think part of our job on behalf of the city's interests is to maintain as narrow a scope as possible when it comes to this consent decree. Now, I know a lot of people are referring to reports in the recommendations in the Chemerinsky report, and we may have to make an exception or two there. But as much as possible, let's stick to the focus of the content of the proposed agreement, and yes, let's deal with other recommendations, other policy matters in due time. But this proposed agreement before us has evolved so much to get to this point that to open it up would be to open up a Pandora's box.
Mr. Wax.
I agree with part of Mr. Padilla, but not the conclusion. I certainly agree with it with respect to the role of the federal government, and I also agree with it to the burdensome role on, we discussed before, on the paperwork and others. But in terms of the substance of reform from within, for which, as you're right, Ms. Galanter, we could have and should have been doing even without the federal government, I don't agree. And the fact of the matter is, Ruth, we're here now because we didn't do the other things. And, you know, how many times do I hear people saying, you know, well, how come you didn't implement the Christopher Commission? Now we've got one of the major ones that we didn't implement that's got to be implemented. And if we don't put it in here, what gives you any more assurance it's going to be done 3 years from now than it's been done over the last 9 years? This is a chance to do it. This is a chance to clean our own house. And it's different from the others, Alex, Mr. Padilla, in that this one isn't something that involves the extent of the federal government's role in our department, and it's not one that places, this is just one that we internally can and should clean our own house. And if it's finally become clear to people that this is one of the causative factors of the problem, then it just seems to me, that we've got to do it. And the fact that there's such resistance to us doing it now, quite frankly, should be a clue to you that there'll be a resistance tomorrow in not getting it to either. I guarantee you that a year from now, if we don't do it now, a year from now, the same resistance you're hearing, you're going to hear it from doing it then. But then you won't be under the threat or under of an agreement. So if you want to do it, if you believe it should be done, you do it now and you guarantee that it gets done. If you don't want to do it, then that's a different story, then you don't do it. And I can respect that. There's a difference of opinion. But if you agree it needs to be done, now is the time that it has to be done and should be done and can be done. I just think it's really our decision time as to how important we think this is.
Okay. Mrs. Walters.
Well, my comments, thank you, Madam President. My comments are along the line of Mr. Wax. It seems to me that we hear a lot about the big Mo with momentum. We haven't had the big E, the big energy to exercise political will on these issues with respect to the police department. We very timidly went about the Christopher Commission reforms. We are notably weak-kneed in the face of heavy lobbying by the police, what are they, the PPL, and we just don't exercise the kind of political will in these issues that we want and that we should. And I think that it will be easier for us to perhaps collectively see that this isn't a consent decree and it will be enforced long after we're gone. It's at the behest of the Justice Department. So there's some logic here as to why we should put this in, incorporate some suggestions from the Shereminsky report into this report. And I will support that occurring here.
All right. I actually have a blank screen here. Treasure this moment. I know, don't touch that button. I have my bat right handy here. We have... I know, I brought it for a purpose. Actually, it's very useful for reaching that button. We have, I believe, two motions. That is a motion and an amendment. Mr. Wax's motion is to amend paragraph 90 by adding recommendations 8, 8A, 8B, and 8C from the Chemerinsky report. Ms. Mizikowski's, right?
Qualifying language to the
Right.
extent legally permissible.
Now, I'm glad you mentioned that, because Ms. Mizikowski's amendment was to take out the phrase that says with an assurance of confidentiality. I believe we could solve both problems if we changed that phrase to say with the an assurance of the legally, you'll have to help me with this, the maximum maximum legally permissible confidentiality. Now, would that solve, Cindy, will that solve your problem with Joel's motion? And Joel, will that solve your?
Well, I think I'd like to ask the city attorney if they have a problem with that.
Well, that was my next question. Do you guys have a problem if we add all that stuff in, and if we make that qualification to it? I think it solves. Okay, everybody's comfortable with that?
My only request is that 8A, 8B, and 8C all are in different parts of the agreement, and that we be allowed to put it in the appropriate place.
Right. Okay, everybody's comfortable with that? Is there any, is there any objection to doing that? In that case, we don't have to call a roll. We will consider item 90 amended with all those qualifications. And we are now going to, it's 5:21. We are going to take a 9-minute break in which everybody gets to stand up, go to the bathroom, get dinner, which has been prepared. Dinner is in the back. and then you're coming back, because we're going to do this again, and I have my whistle so that I can function as a whistleblower. We are now on a 9-minute break. someone I blew it to.
Did you leave?
All right, are we ready to reconvene? Members of the council, we are up to item 91. Remember, there are 182 of these, and some of them are still back at the beginning.
We're halfway.
Well, we're not halfway, because we're only at the beginning of 91, and we didn't do the 10 or so at the beginning. Okay, 91, the teams agree in concept, but continue to discuss transition of how to handle things. We lost Deaton. That was pretty sneaky. Oh, there you are. Okay, this is item 91.
This is the transfer.
This is sort of the interim till we're up and running with the new stuff. How do we make sure that
Right.
we're not losing?
The difficulty in this is getting a staff shifted over to internal affairs. We've been working with DOJ on a transition plan. They don't have a problem with the end 2 years, but they would like to have some of the complaints, maybe with the specialized units, be transferred earlier. We, at the point in time that we were in the negotiations, had not got the information on what those numbers were.
So there's really nothing we can do
I think
until...
you just let us proceed with...
keep working on it. Yeah.
Right, I think it's in good shape.
All right, items 93, 94, 95, 96, 97, 98, 99. We agree. I'm sorry, which one?
92.
92? All right, Mr. Pacheco on item 92.
Okay, I continue to be a prosecutor, but under subsection B, I have some concerns about that area where it talks about every time a court grants a motion to suppress evidence, the officer shall be investigated, because it seems to indicate that we want the LAPD to request that all prosecuting agencies provide us with written notification when that occurs. And every time we get written notification that occurs, we're going to do an investigation, an internal affairs investigation. And I had personally an experience where the lower court, the preliminary hearing judge, did not grant the motion to suppress. And then when it went to Superior Court, the Superior Court judge did grant the motion to suppress. And my main concern here is that since probable cause is a subjective, it's not an objective standard, it's a subjective standard. Every single motion needs to be investigated as if a major offense occurred, or because sometimes it's just a mistake versus misconduct. And so I was wondering if we can alter that so that I think I was discussing this with the city attorney during the break. I think we can track it in teams, and if we see a pattern, if we see 3 in a year, or 3 in 6 months, or 4 in 6 months, then it brings gives us one of those notifications that there's a problem here. But if you do every single one, I'm not sure how productive that's going to be. And then on section D, I raised this before. I don't know if we want any prosecutor to have that type of authority. I know in the city attorney's office, we have a process that requires supervisor approval before notifications given to the police department that there's an appearance of misconduct by an officer that should be investigated. So if anyone can give me some guidance on why every single motion would trigger an internal affairs investigation.
Mr. Chaliff.
Well, first of all, obviously, your experience and mine has been much different, because I don't know if very many of them are granted. So I didn't think it would be a problem that occurred a lot, but both of those are in a situation where you want internal affairs to know about it, and then they can conduct the appropriate investigation. On B, when a judge, on those rare occasions when it happens, makes a finding that there was an illegal search or seizure, it's something you want the department to know about it, and then, like I said, they can look into it. If it turns out to be a judgment call, if it turns out it's been reversed, all those things can be tracked. The fact that an investigation is open doesn't mean that it becomes a full-scale 24-hour press. It becomes something that we want the department to know about. As far as D is concerned, You don't want the department to be in a position where a prosecutor sends over information that an officer is not telling the truth and not have the not have the department do something about it. That's why it's in there.
Right, and my only question on D is, why aren't we using the same standard we have in our city attorney's office in the consent decree?
Well,
And then on B, if it's an optional issue, that it'll be optional for the internal affairs to investigate, then why does it say shall investigate on the top language? I just think that generally, I don't disagree with the basic concept that it should be noted and maybe someone should look into it, but the internal affairs group, to me, is a pretty strong statement to make. Wouldn't this maybe necessarily be better put under the chain of command or commanding officers a jurisdiction as opposed to internal affairs?
I think it's as much a protection to the officer as it is to the department. I think that if you've been accused by an officer of the court, or there's some allegation, that we should have an investigation of that, and it should be cleared up for the benefit of all concerned. And the internal affairs is an independent from the. I think that it is the proper place for it, and I understand that it might not. I mean, it goes two ways.
Well, the only point I will push it again, but the only point I'm making is that when you're in court, it's not like the judge makes an allegation. The judge says, you know what, I know the officer saw X, Y, and Z. Officer thought he had probable cause.
We'll come back to you.
I just disagree that, it's not like they're making an allegation that misconduct
we're coming back to
occurred.
you. Ms. Goldberg.
Okay.
Actually, the point Mr. Deaton made was the major point I was going to make. I think that sometimes this acts as a protection for the officer every bit as much as for anyone else, because these allegations are serious when they get made, and to be able to get someone quickly to look at it and clear them if it was just a mistake is, I think, very important thing to have happen, rather than having it kind of hang out there. I think the other thing that I would say, though, is that I think that's all I want to say.
Mr. Hernandez.
Mr. Pacheco, did you go to Loyola Law School? Okay, because I was just there. And it was interesting. I was sitting on a panel and I was listening to public defenders, one in particular who defended Ovando, someone who played both roles. At one time was a deputy district attorney and also has been defending people, Johnny Cochran. I think we've heard his name around here every now and then. And a lot of the panelists, and there was an assumption there that a prosecutor, particularly in the district attorney's office, is more inclined to want to get a conviction or a guilty plea. They were saying it almost to the point that it would be, even if it obstructed justice, that there was times when they would cut deals simply because that was their role, and that the system needed to be opened up in a way where not only prosecutors but public defenders as well as judges filed complaints. Because the reality being that when you track these things, very rarely does a prosecutor allege police misconduct, that there tends to be a relationship there between the prosecutor and law enforcement, that basically it's not an inclination for them to allege that there was improprieties in the search or improprieties in the review. And that's what I was hearing from the law school and the panel and everybody else. And so I kind of came back finding it interesting that when I was going to the panel, I thought there was going to be a focus on LAPD, but there was a real focus on the judicial system and how the judicial system had been failing at all levels when it came to the defense of people, and how it is that that defense is balanced out. On this report, I noticed that it does not include the public defender's office as someone who could also file a complaint. And I'm asking, or not a complaint, but file a potential claim that there's been mismanagement or inappropriate conduct. Is that something that should be considered for inclusion?
The Public Defender's Office is, of course, can file the complaint. All this deals with is who investigates the complaint, and this makes specific that IAG must investigate it under these circumstances.
But it also talks about if a complaint is filed by a court, a judge or a public, a district prosecutor, and it mentions the court and the prosecutor on several occasions. And so I was just wondering if there would be anything wrong with us mentioning the defense side of it. Because I think there would be a greater inclination to
I
file.
think she answered that, Mike. The question is not who files a complaint, but who investigates it.
Well, I agree with
And
you.
it has to be investigated by somebody who's got the ability.
But this item does say if a complaint is filed by a prosecutor or a judge, it's to be investigated. It's to be investigated. It doesn't mention the public defender's office.
Fair enough. So does anybody want to answer his question about the public defender? Okay.
Yeah.
Think about it for a minute if you want while I call.
We did talk about that. The challenge was, I think, the issue that Nick raised, which is, I think it was the public defender at the top level who made the filing. That's one thing. I think what we were trying to avoid setting up, though, was a strategy where people defending people on the defense side would, just as a matter of course, use this as a mechanism to undermine the officer in connection with the prosecution. So you need to balance that out. But certainly if it was the public defender currently himself at the most senior level, it would of course be investigated quickly, promptly, and with appropriate investigation.
Ms. Chick.
Yes, well, I'm glad Mr. Pacheco raised this issue because with the advice of another former prosecutor, it was pointed out to me that there are times when evidence is suppressed and it's a decision of the judges that is very much unrelated to any potential intentional wrongdoing on the part of an officer. So that front language that says will investigate, it doesn't say will investigate, from A to Z. It just says, so couldn't that mean will look at?
No,
It's the full investigation?
I think if you go into this agreement assuming that when we say shall investigate, that the monitor would ask, how many of these did you get, and what would look at the nature of the investigation related to them, and if you didn't do an appropriately diligent investigation, you'd be in trouble with your monitor.
Because one of the first questions that should be asked is why did the judge suppress? And it could be very, very clear in answering that question that there's no reason to further investigate the officer. So I certainly understand why the suppression of evidence and the dismissal of a case can be a sign that there's a problem. I mean, we've just seen that in some of the Rampart documentation. But it also seems that a full-blown investigation might not always be necessary. Perhaps this is something that needs clarification with.
But if you get started on it and there isn't that much and it's easily.
Exactly,
it won't
then
be
it's over.
But it'll be over with internal affairs.
So you could ask one question and that could close the investigation?
No.
One or
It
two?
would- It'd be dependent upon internal affairs.
No.
If they felt they had enough information to close the investigation, they would.
Okay.
If they didn't, they wouldn't. But I think not to have it done by internal affairs, not to do anything about it.
No, I want it
Our
to be
discretion.
internal affairs, and it should be looked at, but I think there are situations where it can be done very quickly and doesn't involve a whole case brought against an officer.
Mr. Pacheco.
Let me give you a little insight on some of the things that you may experience, especially at the municipal court level, where one of the common situations where this arises when someone's given a ticket for driving without a license or driving on a suspended license. I can tell you right now, as a matter of fact, that there's a judge sitting in the Citrus Courthouse who will not find probable cause against any Latino defendant who has an item hanging from their rearview mirror, which is a violation of the vehicle code, because he openly believes that that is a sort of a cultural thing, that they like to hang things from the rearview mirror, so that's not a valid basis to stop a vehicle. And so that would be a motion to suppress granted. I'm just telling you that there are some really odd things that can occur when you look at a motion to suppress. I'm not talking about necessarily the felony where you're talking about, Furman climbing the wall and he's finding the glove. I'm not talking about that. I'm talking about another example that I will give you that I personally experienced. The call out was a man with a gun in the front yard. Okay. The officer rolls out to the scene, gets close to the home. The man in the front yard runs in the house. The officer gets closer. A second man runs out the back door. The partner chases the second man. The driver goes into the front door chasing the first man. As they go through the house, they notice that there's marijuana plants all over the house that are being grown inside with those lights. Okay. When I have the officer at the preliminary hearing on the felony charge of producing or growing marijuana for distribution, I asked the officer, did you see the gun that was reported in the radio transmission? He says, no. I didn't see the gun. But I saw him run into the house, and so I followed him. Well, because I stopped it. But there may be prosecutors who will go through the motion to try to put it up there and see if they'll get by a judge. Let me tell you something. If you haven't heard this before, there are police departments that shop judges when it comes to their search warrants because probable cause is so subjective that they know one judge would probably go with one thing and another judge will go with another thing. And that's why I have a difficulty with investigating every motion to suppress, because it's so subjective. I don't mind tracking them, and if you see a pattern of 2 or 3 in the month, or whatever the protocol would be appropriate, some bell or whistle goes off. But every single motion to suppress that's granted, because of how subjective probable cause is, I have problems with. That's my only thing. I'm not trying to say that they shouldn't be tracked or shouldn't be monitored, but I'm not so sure every single one should be investigated. And this could be really cumbersome if you talk about misdemeanor traffic violations and the 1538.5, the motions to suppress that deal with lack of probable cause for pulling over a car. I'm just concerned that we're going to pad, or an officer is going to have a padded file, and it's based on some irregularities based on law changing or judges just having a quirk. So, like I said, I don't mind monitoring it. I don't mind having a bell or whistle, and a protocol should be established. But I just disagree that every single one should rise to the level of investigation.
Okay. Anybody need to respond? Ms. Mizikowski.
I guess I needed some help here from our legal folks, because is a motion granted where a motion to suppress was granted, does that always relate to a constitutional violation or misconduct? Because basically what you agreed to in the language is that it would be in order to suppress because of a constitutional offense or misconduct. If it was a motion to suppress the evidence because the judge just felt like he didn't think there was enough reliability to allow it, and it's not a constitutional violation or misconduct, then it doesn't require the criminal investigation. And if that occurs, that is, you can have a motion to suppress that does not rely on constitutional evidence, a violation of constitutional rights or misconduct, then I don't think we're going to get into the situation that Mr. Pacheco indicated. But if, in fact, it is a motion to suppress based on constitutional violation or misconduct, then we want to know about it. Can the folks at the table help me on that legal point?
I think Councilmember Pacheco is, as a recent former prosecutor in trial courts, I've had experience some years ago on this. The law is continually evolving here, but basically these motions are to suppress are based on the Constitution, that there has been an unlawful search and seizure in violation of the Constitution. And then there's a whole body of law and a lot of cases and a lot of fact situations on what constitutes probable cause. As Councilmember Pacheco's pointed out, did you have a right to be in the place you were when you observed the marijuana plants, for example? So there's, and then some judges find it just on, I didn't believe the police officer. They'll just make a finding on credibility. I didn't buy what the officer's saying. They're not necessarily saying an officer committed perjury, but they're just not confident that what the officer said accurately depicted the event. So there's a number of findings that are made there, but basically what you're starting from was was whether or not there was a search or a seizure in violation of the Constitution.
Well, can we use the information then to send back to the negotiating team to look and make sure that, where there is serious evidence or a serious finding of on this, and again, whether serious is the right term or something, so that it's not just everything that might be somewhat frivolous, but in fact, something substantive.
And then the other thing is, I'll certainly review this in my office. Maybe we can get some idea of what the magnitude of this request would be. How many of these motions are granted?
Okay, anybody else? I think then we're done with 92, and you've heard the concerns of the council. The next one where we have a disagreement is item 100. Yes? Okay, we're back on 95. Go ahead.
It says that the city shall plan and initiate a plan for organizing and executing regular, targeted, and random integrity audit checks or sting operations. There is some concern, I don't know whether I share it or not, but I want to at least raise it. Who is going to help decide actually who would be the subject of the stings? Which officers will be, is it going to be random selection? Is there going to be oversight by the Inspector General just to make sure that the way the targets are selected, not doing the stings, but is there some oversight somewhere along the line, somewhere about, or some reporting back on how the selection was made?
There's, IAG is the unit that will have the responsibility initially for conducting these operations and also for identifying where they will be aimed, so to speak. Both the Inspector General and the Commission, the Inspector General will be auditing these. Both the Inspector General and the Commission will be getting full copies of every sting audit report and will be reviewing them.
But that's after the fact.
That's after the fact, but this will be an iterative process.
A what process?
Iterative. I mean.
Oh, iterative, okay.
This will be a process that there is provided for a feedback loop from the Commission back to the department, or the LAPD as we've defined it here, that will say where these things should be going and what they should be looking at.
Okay.
So those feedback mechanisms are in here. The initial one, the very first time, will be IAG, and somebody has to make that cut.
Yeah. No, the concern expressed to me was about retaliation. Was somehow or another that a person could be targeted for this, and I just wanted to know, I don't believe that would happen with IAG, but I just wanted to raise it because since retaliation has been a big issue,
Right.
I just wanted to raise it. Mr. Chair, if you shook your head.
No, what I was going to say was, that's something that would pop up immediately when you did an audit, if you found out that every officer who's getting targeted, somebody who made a complaint against another officer, you'd know immediately what was going on. That's what Ms. Martin was talking about in our reviewing these, because the commission and the IG gets a review of gets a copy of every audit. I mean, of every sting
And in the
operation.
audit report, the IAG will explain why they picked the people they picked, or to have this sting on that group of people. They'll have that explanation in there. That should probably do it. Thank you.
No, it says random
The
targeted.
proposal says random
And
integrity.
targeted, though.
Well, random is good. As long as you use a random table, it's really random.
Okay. Mr. Hernandez.
Madam Chair, members of the council, this is an area where I think it would be appropriate for us to add the kind of behavior that will be reflected in the sting operations, compliance, or Special Rule 40. I have found that dealing with the issues of immigration, particularly in certain communities, and how that relationship works, has been something we have had a difficult time tracking, compliance with Special Order 40. And then looking at the kinds of behavior that would be reviewed in these sting operations, I could envision that happening, where that would be an area I would like mentioned in the consent decree, that we would be doing these types of audit stings in that particular area. And so I would move that that be added to the language of the kind of behavior that'll be the target of these auditing stings. Right.
Okay, is there any problem with adding that language? Did anybody hear the language? You better say it again, Mike.
Well, just compliance with Special Rule 40 it would also be in review as part of the audit stings.
Can we put it on the table for a few minutes and let us
Okay,
have a chance to talk?
all right. Okay, that's now on the table while we think about that. And the next one where I see, I do not see that both parties agree, is 101.
Oh. Maybe I can say something. I think since this was,
You lost everybody else up here.
well, okay, let
Go
me
ahead.
just leap in. Since we debated this, I think that there has been movement, particularly on the mayor's part, as to the collection of data in connection with racial profiling. There is another way of doing this, which melding, we sort of need a Vulcan brain meld or something here to make this language work. There is another way of doing it, which is how they did it in New Jersey. In New Jersey, and paraphrasing, it would say something like, the Department of Justice did not allege that there is any department policy that explicitly provides for or condones discriminatory law enforcement, and acknowledge the department prohibits invidious discrimination on the basis of race, color, ethnicity, national origin, gender, sexual orientation, or disability in conducting law enforcement activities. The department shall continue such policy. DOJ acknowledges that the department has already undertaken a number of steps to begin to address the issue of racial profiling and other forms of disparate treatment of minorities, including through its hiring practices, including by adding a racial profiling complaint category and facilitating the filing of complaints for investigation by the department. But I think we need to address the issue of racial profiling. We need to put the policy in there that we prohibit these things, but we need to sort of use the words racial profiling to capture what it is we're trying to get at.
What's wrong with the DOJ language?
Just one, before you answer that, what we're talking about here is paragraphs 101 through 107, which all relate to 107, all
Right, I understand.
relate to non-discrimination
No, okay.
in one form or another. Well, 108 and 109 are the motor vehicle stops, which we talked about earlier.
As to paragraphs 101 through 104, I recommended that we accept the DOJ language, but add the language in underlined, just to confine it to what the issues are before you, that we're not going to use race, color, ethnicity, or national origin to any extent or degree in conducting motor vehicle stops or pedestrian stops. And because there had been a number of people who said, well, what about a benign reason, and what we might want to do something different dealing with people. What we're trying to confine this to is in conducting motor vehicle stops or pedestrian stops. And I think that that language is acceptable to DOJ.
I have a couple more people who want to be heard. Mr. Fewer.
I'd be happy to defer to the answer to the question Ms. Goldberg first.
Okay, do we have an answer to Ms.
Well,
Goldberg's question?
The first problem is that pedestrian stops, and Fred Merkin has done some research on this, as I understand it, is not all that clearly defined in the law. So we need to know what we're talking about here, but at a minimum, we need to have a number of things carved out from it, including canvassing a scene where the person stops voluntarily or consents to the stop, bike safety, any number of things which we need to make sure we get done correctly, which, we can do that, and we obviously will make sure that the definition of pedestrian stops works, but there's a difference between a pedestrian stop that leads to a detention and one that may or may not lead to the detention, is, I think, part of the challenge.
Okay, Ms. Goldberg had a question on paragraph 95. Is that the one you wanted to defer?
We did that already.
Yeah.
Okay.
So for example, if it's a pedestrian stop that's leading to a detention, you obviously have to have in the second full sentence of 101, you have to have legitimate articulable reasons consistent with the standards of either reasonable suspicion or probable cause to stop somebody. If it's bike safety and it's not leading to a detention, you can make the stop without having to have reasonable suspicion or probable cause.
Somebody else at the table? Okay, Mr. Fewer, you're on.
Yeah, last Tuesday, I moved and Cindy seconded that we implement the racial profiling reforms as recommended by DOJ. I'm prepared to amend that a little bit, but only a little bit. I think that with regard to paragraph 110, pedestrian stops, that the city attorney's minor amendment to that, I don't mean to trivialize it, but to say that it retains the core of the idea, but says let's record information where we would have filled out one of these field investigation cards anyway. I think that's probably a fine place to end up, as we discussed a similar proposal from Mr. Hahn in the search and seizure context, about which there was consensus. Regarding the possibility of exceptions to the pedestrian stop in particular, one of the concerns I have, Kelly, is, this conversation has been such a sanitized conversation of racial profiling. We're talking in real life about people who in their neighborhoods are really concerned that only because of their skin color, they're going to be stopped in all kinds of circumstances. And I think we need to be careful about carving out exceptions, even things like, and maybe I misunderstood you, but even things like, let me just, Kelly, because I'm going to be very short of my time.
The reason people are interrupting you is they want you to speak directly into the microphone, not to cut you off, but in fact to hear you.
All right, thank you. Even, I think Kelly has another thing to say, but just real quickly, even in situations where, say, we're talking about bicycle safety, but that allegation that there's a bicycle safety problem can often be used as a subterfuge for something much more egregious than that. I want to hear that, and one more thing I want to say before my time goes out.
This is a drafting issue, and this language as drafted doesn't work because race, the second full sentence of 101 isn't talking about race. It is saying that any pedestrian stop, whether of a white person, a purple person, or a turquoise person, must be on the basis of legitimate articulable reasons consistent with probable cause or reasonable suspicion. And my issue doesn't go to the fact that people should not be stopping people on the basis of race. My issue is there are things in the legal sort of definition of pedestrian stop that aren't detentions and don't have to be based on reasonable suspicion or probable cause, no matter the color of the person being stopped. It's a technical kind of an argument. It's not a substantive point, it's a technical point. And so when the city attorney says we need to move this language as is, we can get there on the language. We can work this out. We will get there and satisfy DOJ and be very, very clear that the kind of behavior you're talking about is simply not permitted. But this sentence as drafted is overly broad.
Yeah, I guess, my point is there are two issues here in broad terms. One is language that philosophically prohibits the behavior. But the other, and the more nettlesome problem, has to do with what we do about it, because we know that the mere prohibition is not in many circles deemed to be nearly enough. And so we're talking about really the collection of the data and what triggers that, and we're talking about what we do with it once we get it. Now, this document doesn't address what we do with it once we get it, and I think that's okay for the moment because that's really a management decision for us to make, and all of us will be held accountable for how well those decisions are made. But on the drafting of the document, and in particular where we're actually going to collect the data, Mr. Hahn, there's a little bit of a sort of a mild disagreement between what the mayor's office has said and what you've said here. What is your response to what Kelly has said regarding the drafting issues?
We did identify this as a drafting issue that we think the language can be worked out, and if there's an expansion of reasons consistent with the standards of either reasonable suspicion or probable cause is warranted, maybe some language further that, or is otherwise legally permissible under the circumstances might solve that situation.
All right, because just as I concluded, from my standpoint, the core issue is we need to not be drawing back from, but embracing the idea that extensive data collection is necessary for us now, and any minor drafting issues that are at the periphery of that are fine. Anything at the core of that would be unacceptable from my standpoint.
Mr. Fuhr, may I comment on that, please? While supporting both yourself and Mr. Hahn on the core issues, I would ask that you leave the negotiating room flexibility so we don't put ourselves in this corner, and that's prevent officers from doing their daily job. Certainly, I don't want officers to use an exception as a ruse. On the other hand, every day we canvass witnesses. We stop and talk to people as part of Neighborhood Watch. There are a number of consensual searches, or stops, excuse me, that don't rise to the level of probable cause or reasonable suspicion. It's just a part of what we do every day, and I wouldn't want an extreme reading of what we have in this document to prevent our daily business.
Mr. Wax.
Questions, Madam Chair. The reason I questioned whether we should stop from 101 to 105 is because if we're really going to get into racial profiling, we've got to go into the subsequent
Yes,
sections
no,
as well.
that's certainly true, 108, actually through
The other day,
111.
as a minor, well, it's not minor, but it's cuts to the chase. The other day, I raised the question that our negotiating team had recommended the language not invidiously discriminating as opposed to simply not discriminating, and I thought it was inappropriate to have that that qualifying language. But if you accept 101 to 105, then the invidious is not in there. So if you're going to insist on invidious, then we'll have the conversation as whether we should have it or not. If you're now recommending that it's not be in there and you use the language simply not discriminating, then we don't have to have that dialogue. So, because DOJ didn't include the words invidious. So that's one issue. I mean, are you now, I thought I heard Mr. Hahn recommend now that the Department of Justice language, and that doesn't include the word invidious in it.
If I may add something, Councilmember Wax, I don't think the word invidious or invidiously has any adverse impact upon what you're trying to achieve.
Okay, wait a minute.
It's a term of
But
art.
first, let me ask you, are you recommending it be in or out? If I disagree with you, but if you're going to recommend that it's out, then I don't have to have a discussion.
Actually,
do you care whether it's in?
I don't care.
Okay.
I should tell you, I think it's a little more precise if it's in, but...
And I fear that it's a qualifier, and this sort of a qualifier that could have more harm than good.
If I could say, Councilmember, I did some research...
But if it's not going to be in there, yeah,
I
go
did some
ahead.
research on this point. It's sort of legal shorthand for forbidden discrimination. Invidious discrimination is essentially forbidden discrimination. It's used by the courts. Federal courts have used it over 6,500 times. The United States Supreme Court 317 times. State courts over 3,000 times. And California Supreme Court 119 times.
Okay,
So,
I'll be happy to just have a listing of all those. No, that's fine. Thank you. The bigger issue on he's probably got it right there. That's what computers can do, I've learned. The bigger issue on racial profiling, and it's a discussion we had when Chief Parks was here, Chief Pomeroy. The one issue that's commonly talked about is should we acquire the data? Should we have the information? I have always believed that there's nothing to be afraid of having the facts. The facts are the facts, and you want to know them. The real issue, I think, was the issue that Chief Parks raised when he was here, is what do you do with those? How do you interpret them? What meaning do you ascribe to them? What actions do you take based upon that? And I had been under the impression and welcome and wanted him or you or the rest of the department to come back with those recommendations, with those guidelines, with that framework, because I think that really is important. I feel we should have the data. I'm not afraid of data. What's to be afraid of? The facts are the facts. But I do think that there is real room for disagreement or debate as to what that data would mean, how they're interpreted, how they're used. And I think somehow this seems to have avoided that discussion, that I was under the impression the department would be coming back with something. In fact, I'm sure that was the last time we discussed that issue in this council. We were told, and I welcome, the question is where is it and when will it come, something that really puts it all in context. Once you've obtained the information, how do you interpret it? What meaning do you give it? What policies do you have pursuant to that? And where is that? That was the last time I remember Chief Parks.
Let's
Here,
see if we
saying
can get a response to that, and then we have 5 more people so far. Go ahead.
my understanding that the chief's belief on that has been in the past and remains to this day, that there is no statistical model that'll help us generalize or interpret in general this information. He believes, and I personally believe, the best use of this information is when we have an allegation or a suspicion or a risk management issue with a single officer, to go to that data that's accumulated to that officer's name as a way of interpreting or understanding that officer's individualized behavior.
I'm not sure I'd quite digested that, but I want to think about it. I think it's a very, very important issue. What do you do with the facts once they're presented to you? X number of people, Y, got
And
stopped.
also who determines what they mean. who makes the
Exactly.
judgment.
So-
Okay, push a button again if you need to. Ms. Goldberg.
Well, like all compromises, I wasn't completely satisfied with the one we struck the last time, but since we struck it, I don't see any reason why we shouldn't do it on this set, which is that as to pedestrian stops, that we collect information where we have, where we would anyway, with arrest reports, field interview cards, or gang activity cards. I mean, I think that that's for 110. On 101 and 104, I think we should accept the city attorney's recommendation, which is essentially to take the DOJ's language, but add that LAPD, blah, 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 in conducting motor vehicle stops or pedestrian stops. It's on page 6 of the city attorney's, because that's what we've been doing. As to 108, this is as to traffic stops and pedestrian stops. Now, what I think Mr. Deaton, you said when we talked, I don't remember whatever that series was, the numbers before, but you said that, or somebody said that the issue of traffic stops was not an issue, really, between the team and the DOJ, right?
Yes.
That was not an issue. It was the pedestrian stops. Is that right?
I mean, I was ranking them.
Oh.
And I think that we need a way in traffic stops to make it simple and quick for the officer to do it, electronic. What I was saying is that was much simpler in a vehicle than it was on foot because of...
But this little list, really, I did do it by hand, but you can reduce almost all these questions to yes or no or circle the answer. So I really don't think it's a difficult problem. It'd be different in the search and seizures. There are long sections you'd have to do with paragraphs and describing, but there really aren't any in this one. It just asks you.
Well, to the extent we could do that and do
Yeah.
more or less like San Jose for a few more and they have 5 or 6 items.
Well, I saw one that CHP did too. They had more items, but it was still circle or number and
Right.
put a number. It was
I
really.
think that's essential to being able to do it.
Yeah, I don't think it should be a problem, but I think it just gives you basic information. I think that's all we're looking for. So I would urge that we take the city attorney's suggestion on 101 and 104, that on 108 we go along with DOJ, but we insist that it be something that can be done by circling or saying yes or no as to the data that, gets collected, and that as to 110, that we take the city attorney's recommendation.
Okay, Mr. Padilla.
Thank you, Madam President. I know we're talking to a number of the paragraphs here, but the majority of the paragraphs, if I read this correctly, says, this is a drafting issue. DOJ and the team both agree in concept and are very close regarding language. That's 101 through 107. So I think it's appropriate to give the negotiating team some flexibility to iron out that language if we are that close, and specifically reiterate something that's come up earlier in the day, and that is that both Justice and the negotiating team have looked at other local governments for successful models, including San Diego's been mentioned, San Jose's been mentioned, and the standards set by Justice in other consent decrees that they've entered. So I wanted to remind us all of that and hope that, and if necessary in the form of a motion, have the action on this particular topic or set of paragraphs be that the negotiating team has the latitude and the flexibility to finalize what seems to be almost closed issue with the Department of Justice.
Ms. Walters.
Heard a second there.
I heard a second. Go ahead.
I detect that the department is resisting the specificity of the language in 101 and other paragraphs here that stipulate that the LAPD personnel shall not discriminate on the basis of race, color, ethnicity, national origin, gender, sexual orientation, or disability. And if my reactions are correct, as I heard Chief Pomeroy saying, we don't want to have to do anything that's going to impede our daily work. It seems to me, Chief Pomeroy, that what you're doing on a daily basis is the issue here. It is absolutely the issue. And it's been the issue for a long time. The racial profiling issue, for example. Rodney King. Nobody would have ever known about it if there hadn't been a video. And yet, that kind of thing has been talked about in the African American community ever since I've been in Los Angeles, 45 years, that it's a frequent occurrence. And if we don't collect this data in categories, we will never know, we will never have the data, the hard data, to indicate whether that's a suspicion that's handed down from generation to generation, or whether it's an actual pattern and practice that the department is engaged in. And I think if what you're doing on a daily basis, quote unquote, is not objectionable, then we'll find that out as well. But I think that that goes to the heart of the matter for this whole report, that the data must be collected and categorized in that form. There are people in other communities, women, gay people, disabled people, who all have harrowing stories about what happens to them in just what should be an innocuous situation. So I just think that it's very important that this data be collected and that it cannot be emphasized too much in what form it's going to be collected. And the issue of whatever you're doing day to day, that it impeding the progress of that and the amount of paperwork and all that is immaterial to the core issue here. And I would really urge the department to take a step back and look at how they can cooperate with this and how they can use this process to get some of the changes that the managers of the department feel that they want.
Thank you. Okay, we seem to be close to a consensus here, but we have two more people to be heard. Mr. Pacheco?
I just wanted to rise and say that regardless of how we end up working these details out, I think even though I don't personally believe that data collection is necessarily the smartest or the best direction to go, and I think for those people who support it, they should really view this as a major step forward when we deal with the traffic stops. And I don't want, at the end of the day, that people feel that because the pedestrian stop issue is so difficult to get your arms around, that a major step forward hasn't been taken when it comes to the traffic stops. So even though I don't necessarily land on that side, but I think in terms of for those who support this as a tool for ending racial profiling, I don't want at the end of the day that this be swept away because of our concerns on pedestrian stops. But and I do think we have sort of worked this out in a more reasonable fashion with the city attorney's position. So I just wanted to say that.
Thank you. Mr. Fewer?
I think, I just was going to sum up where
Well,
we are.
take your mic.
We can do that.
You can stay seated, but take the mic
I was
down.
going to say, I think it'd be good for somebody to sort of sum up where we are. No backsliding, but it may be from the core commitment, maybe Ron could
Right.
summarize.
I think 101 and 102 is a discussion and drafting issues with the lawyers, and I'm sure that they will eventually decide
Can
the
you
right language.
Get your
And I
mic
think-
and your mouth close
okay.
together. Thank you.
On, mainly 101 and 102 has been drafting between the lawyers and between the Department of Justice and the City Attorney's Office. Actually, the rest of us, it's been trying to get the right language to make sure that it's carved out the right way, that allows us to do what we need to do and still protects and doesn't backslide, as Mr. Fuhrer has been talking about. That has not been a team versus team discussion. It's been more mainly between the two lawyers.
Well, my recommendation, again, there was this objection by some about the use of the word law enforcement activity, that maybe if, that this would interfere, for instance, with our ability under other consent decrees to be able to use race in making hiring decisions and things like that, where we're supposed to do that under our previous consent decrees. So to end any confusion that we were not talking about any benign law enforcement activity, that's why I said, well, what we're really talking about here is when you're, stopping, either pedestrians or motorists, and so we should use that language instead of law enforcement activity, because I think that's what we're trying to cover. But I think that this issue is not one that we're not going to be able to resolve, and I think that the Department of Justice language, I think just with that one modification, from what I've heard from the council, is what the council would like us to do.
Yeah, that, I wanted someone to say that. Good.
And on the pedestrian and traffic stops, we will do as quick, we want to do the collection as easily as possible, if we're collecting from other sources, to use those, and to use electronics and those kind of provisions in order to collect the information.
Fine.
I think the only actual motion we have on the floor is to give the team the flexibility to go back and try to resolve these issues, and I don't hear any disagreement with that. The other two issues that were raised were... No, this was actually...
All the way through about 110.
This was all the way through the section, through 111. There was some...
Yeah.
But the other concerns that have been articulated, and somebody will tell me if I've missed them, is whether we need to be, whether we need invidiously, and Fred Merkin agreed that we don't, so we can take that out. There was the concern that Jackie raised about making sure that if we're going to, that when we ask to collect data, that we try to find, actually the concern was that we try to find a way to collect the data that will help us track these things in a way that is not unduly onerous. And that requires going back to the Justice Department, which brought us back full circle to the motion to give you the flexibility to go negotiate it now.
Yeah, no, the only other motion is the motion from actually last Tuesday, which directs that we follow the DOJ approach, but I think that we've successfully modified things to come to a consensus.
So. Done it. So that, I believe, there being a blank screen in front of me, means that we have got past section 111, and now we really are more than halfway through.
On 95, there was a motion by Mr.
Oh, right, on 95.
On Special Order 40, and we'll add that.
Okay, so Jackie, you got that? Okay, 95, then we're going to add that. Mr. Pacheco, now what?
112? I thought we were at 112
No,
now?
we're going, yeah, we are about to go to 112.
Madam President?
Yes.
Before you go to 112, could I ask a question on 97?
Certainly, go ahead.
97, the latter half of it describes officers who have a history of any sustained investigation or discipline received for the use of excessive force, a false arrest or charge, or an improper search or seizure, sexual harassment, discrimination, or dishonesty shall be disqualified from IAG positions unless the IAG commanding officer justifies in writing the hiring of such officer despite such a history. Why in the world would an officer with that kind of history still be on the force? Let alone talking about somebody hiring them in an IAG position. I think there seems to be no justification that I could think of that, and you're talking about has such a history. That means that it's not just an accusation. Why is such a person allowed to be still on the force? Don't everybody speak
Chief,
at once
I
at
think
that
you're
table.
probably the one,
Let me answer
or
that.
Jerry, you're the
I'll
one.
answer it.
Okay.
Part of it depends on what they did, so it's the severity of what it is, because excessive force includes everything from grabbing somebody by the arm inappropriately to
Mr.
beating them over
Chaloff,
the
it
head.
says, improper search or seizure,
Right.
sexual harassment,
Right.
discrimination or dishonesty, excessive force,
Right.
and that they've received, they had an investigation or discipline received for the use of any of those things.
I agree, and I think what I was saying was, part of it was, first of all, there are going to be some people in the department who've done these things, which either the department in the past or a Board of Rights or somebody decided weren't as severe as might be apparent from the words, because as I said, the use of excessive force can include grabbing somebody by the arm inappropriately and grabbing them by the elbow, because that's a use of force. So what we felt was, if these people are there, and if there's an explanation, because we shouldn't punish people forever for something they may have done 20 years ago and has an otherwise spotless and outstanding record, that the way to handle that was to make the person in charge explain a reason why they were going to bring somebody like that into their unit.
To whom do they explain it? To whom do they justify
It
it?
goes into the file, and it becomes reviewed by the people above him and by the Inspector General, and as part of
Okay.
the audit process.
My question is, why would they be allowed to still be on the force,
And my,
let alone be
it's
considered
just if
for
proper search or
promotion to such a sensitive spot?
my answer is, it depends on the severity of what it was and what the
You need to
dis-
speak up.
My
please.
answer
hold the
is,
mic
it
closer.
depends on the severity of what they did and how the discipline process handled it, because let's assume even that, to get to your first question, why are they still in the force? Let's assume that some chief in the past had decided the person should be fired, but a Board of Rights said they should only get 5 days off. A Board of Rights which may have contained a civilian, a peer officer, and a command staff officer. So because of the way the discipline process works, there are people on the force that have had sustained complaints for lots of things. Whether that's appropriate or not, that's the system we have now. It's like the criminal justice system, not everybody gets the death penalty. Depends on the severity of what they've done.
Well, and that's part of what we're trying to correct
That's right.
by what we're
Sure
doing
hope.
here.
Right.
Okay, I believe we're now ready to go to section 4.
Tell the chief when you just fall on your hand grenades once in a while.
I might just mention that there are 12 sections, and this is section 4.
No, we're getting there now.
Thank you.
Number 112.
112.
This is one of your things.
Madam President, are we ready? Should I
It's
start?
actually 112 and 113. Yes, Mr. Pacheco.
Okay. Colleagues, I want to direct your attention to subsection E, small Roman numeral 7, when it talks about off-site interviews. My question is, when I used to be a prosecutor, one of the ways that I would indicate to a witness that I respected their time and their participating in the process is I would go to their home and interview them at their home and bring a police officer to do the interviews. And so I have quite a few questions about this prohibition about doing off-site interviews. And I guess the starting point for me would be also, does this include a crime scene? So if you respond to a crime scene and you're part of a gang unit and you're not on site, which would be your station, where are you supposed to tell the witness you need to come back to the station to finish the interview, because the witness may not want to be that cooperative. They may want to do the interview at the crime scene, but they may not want to travel down to the station. And I just have a concern that this one hasn't been thought out in terms of the day-to-day operations of a police officer trying to investigate a crime and solidify the witness's observations, because I know for a fact that it shows a lot more respect to the individual if you don't tell them you have to come downtown with me to finish this paperwork. And so I have some concerns about that. Exactly what is this? Is there a way of making it tighter to meet the goal as opposed to keeping it sort of vague the way it is right now? I do believe we would want our police officers to be able to interview witnesses at the crime scenes and even maybe the arrestees. So I don't know if I'm missing something, educate me, but it just seems vague here and seems that may cause more problems in doing crime investigations than solve.
Our view is that current policy requires that off-site can only be used, my recollection is during business hours with the approval of the commanding officer, and that to get it in writing would not be, shouldn't be
Okay, well,
necessary.
so if you have a robbery at 2 in the morning and a gang is involved because they robbed the person coming out of the nightclub, and the police officers go to 3rd and La Brea, and is this say that the off-site interviews now have to be taken on-site? That the interview should not occur on the street right there? They should just...
Mr. Councilman, you make a good point, and perhaps I wasn't clear when I expressed myself to my colleagues when we were discussing all this. In my mind anyway, and in most police officers' mind, there's a difference between a follow-up interview, which is, you point out, sometimes even done with the district attorney, and the preliminary investigation, which involves the crime scene and the initial receiving of information. And
Which does this refer to?
Exactly. So what are we talking about, follow-up interviews?
Yeah, the special order that this is based upon was referring to those follow-up interviews. that
Okay,
should
then
be
it
done by
needs
a
to be
detective.
clear.
Okay, then that obviously definitely provides clarity. And I think that is something that a prosecutor could comply with, but I still have the concern, and maybe we can work this out, or this is just something that, if you're working in the DA's office, you're very often given the case in the afternoon on the way to go pick the jury and told, here's your case, go try this case. You go down to the courtroom, and then you want to interview the witnesses yourself personally to be prepared for the next day. So will there be expedient mechanisms for that prosecutor to get the written approval to have that off-site interview? Because I don't want, obviously, to impede the prosecutor's ability to prosecute the case.
But this refers specifically to the police department, not to the prosecutors.
Because we bring police officers to our interviews as prosecutors to be an independent witness in
Okay,
case
so
the
then the
witness...
question is, I don't mean to cut you off here, I'm just
Okay.
trying to get us toward a resolution. If the prosecutor feels the need to go interview a witness and takes a police officer, is that the prosecutor's interview or the police officer's interview?
I think he's raised two very good points, and I think if we go back to DOJ and raise them, I'm sure they'll cooperate and put in good language.
Okay, that's all I ask. is
Okay,
that we,
fair enough.
Look at that.
And I agree, those are very important points. Did you want to add something? Ms. Goldberg?
There seem to be a large number of issues, and I'm not sure that this is the hour to take them up, because I think this is a very important item, and I would really propose procedurally that because there's so much detail in this section, and we're not going to finish tonight. I mean, I wish we were.
We could.
Well, okay, I was just...
We're not going to finish by 7, that's clear, but we could stick around and keep going.
Well, I unfortunately have to get somebody at the airport, so that for me would not probably be possible, but that wouldn't break a quorum, so that might be okay.
Actually, you would not. We seem to have 11
That's what I'm
people.
saying, I would not.
Yeah, you would
so-
not.
Okay. Because I have a lot of concerns about this. These items, I think, were not recommended from nowhere. I mean, they were recommended, the whole question of which channels you use sounds like a silly little detail, except that some of the information that I have is that using different channels was how some types of illegal behavior was carried out, because they weren't using traditional monitored channels. You know what I'm saying? It's not like these are frivolous little details, which is why I really wanted to have a longer discussion about why we object to the pieces that we object to. Because these are not, you know, this didn't come out of nowhere. This came out of this actual set of data and incidents. So that's my reluctance to get into this, because it is, in my opinion, a somewhat lengthy discussion. If you tell me you want me to do though, I'll press my button again and I'll try to organize my list of questions.
You know, I think it would be helpful if the department responded to the issue of the radio frequencies right now.
Certainly agree with Councilmember Goldberg about the history of how this came to be, and understand and wrestle with the idea of how we prevented the inappropriate use of radio frequencies. However, the trouble with what the DOJ proposal is that there is a primary frequency for each division upon which they normally operate. usually between the base station and the field units. However, we provide all officers in each bureau with backup or tactical frequencies so that they can use them during the course of business in responding to emergency situations. And they use them every night. For example, they're responding to a robbery in progress. They'll switch to that and coordinate their activities so they don't tie up the primary frequency. Or a sergeant will say, everybody switch over so we can serve a search warrant or whatever. It's just very, very difficult to tell officers they can't, as the need arises on a nightly basis, switch over and use those other frequencies without having first obtained written permission from a captain.
No, I appreciate that, but then you still haven't addressed my concern, which is, how do we prevent this all from happening again by the use of that? Are we going to tape those frequencies? Are we, you know what I'm saying?
Yeah.
What are we going to do to make sure that those folks who go beyond the pale, and we all agree they exist, don't get to use all of our mechanisms to do it with? That's what I'm trying to address, and that's why I said it's a longer discussion, because I agree with you. You certainly can't wait to get permission while you're on the way to a scene of a crime to coordinate the crime. That's ridiculous. But what are we going to do? If we can't do this, what do we do instead? And that's sort of the same question I have for that as well as for off-site interviews. That, you know, theoretically, not a bad idea. Because there are lots of times when that's a better place to be than on site. But right now, I'm reading on page 67, it says, currently off-site facilities can only be used during business hours with the approval of the support division commanding officer and with a supervisor present. Well, if a supervisor is present, why can't the supervisor give the written approval?
Councilwoman, those two issues, your question about if we can't do these, what are the other things we can do? That's covered by A, B, C, D, all the rest of E, F, G is open, H. I mean, we've taken any number of steps to, or the department has taken any number of steps to deal with the special enforcement units and change it. And these two are the two that I think in E that the negotiating team felt were the most intrusive on a day-to-day basis in terms of operations. And when you know, you put those two in the one pan and all these other things on the other, you were in terms of what you were giving up, we felt that was an appropriate place to strike the balance. So that's why we came out with them the way they are. We've required them to be in uniform. We've required them to follow the procedures regarding detention, etc. We've required them to use marked police vehicles, to check out their equipment, to attend the roll calls, they're only going to get 39 deployment periods. They have to use the Teams 2 review before they can come in, the eligibility criteria. You know, B, their community sensitivity, commitment to integrity now is taken into account. We've added audits, we've added all those other things, and when you weigh off all of that stuff that we are doing in this agreement vis-a-vis these units, and we then set on the other side of the equation radio frequencies, which has the issue of going to the crime scene, and interviewing witnesses, which you still have to get supervisory approval, but you just well, actually, it's an interviewing witnesses, we're saying that it should be in writing. So it's, no, I'm sorry. The supervisory approval in writing on the interviewing of witnesses is the other one where we still have to get the approval. It just doesn't have to be in writing. So I think there's a lot here that wasn't here before. And the DOJ agreed with us. So
I agree with that. I didn't mean, if I sounded like I didn't think there was anything here, I apologize. That was not my intent. But Mr. Deaton, did you want to?
It's not a supervisor's approval, it's the manager's, which means the captain of the division. And that, I think, is the difference. I think it was just the supervisor, which would be up to a lieutenant, watch commander or something, that might be a...
Yeah, but the idea is if the supervisor who's on the scene has to put it in writing in terms of the consent to use a location, then you have accountability. So you say, who was it that authorized you taking him somewhere else to interview him or her?
You're saying that a supervisor, not the manager.
I'm looking at paragraph 112E subsection 8, and I'm looking in the comments section on page 67. And in the
Right.
comments section, about two-thirds of the way down, it says, "Currently, off-site facilities can only be utilized during business hours." So we're not talking about at night anyway.
Right.
And then it says, "With the approval of the support division commanding officer and with a supervisor present. Therefore, appropriate oversight is provided and written approval would only serve to create an unnecessary level of oversight." Now, I'm saying, why can't the supervisor be required to give, because they're on site anyway, written approval so that you have some accountability? You know who gave the okay.
Well, the manager who's there had to either have given the okay or be responsible for the fact that they went off-site. Written approval isn't, I mean, the writing is only valuable as an auditing trail to us.
Yes,
But that's what she's asking.
That's what I'm looking for.
But the manager's accountable whenever they go off-site.
Assuming everybody agrees who was there. If they're
Well, that's
off-site and you're trying to do something nefarious, people are not going to say who was there.
No.
If you're doing it, if you're not doing anything nefarious, there's no problem.
But Jackie, what are you saying then?
I
That
don't
you
think
want
that's right.
somebody to, you want someone to write down who
I want
was there?
something in writing from somebody who's the supervisor.
No,
when they're off-site interviewing someone during business hours.
Okay, but again, to use your example, if they're doing something nefarious, they're not going to write down everybody who was there.
Excuse me, but...
Go ahead.
But it's
good
the-
point.
It's the manager who has to give the approval. And there's only one manager during that watch. So that person is
Okay.
accountable, period. Whether they write it down or don't write it down, that person's accountable. The writing doesn't add anything to it because the manager is accountable.
Because that is the
That's
only
the
time,
distinct-
it
there's only
is
one.
the only time that it can happen.
All right.
And
Okay.
I think our problem with the other two are that radio operations, you can get, possibly if you thought something was going wrong or doing the random sting audits or something like that, but the fact is that if you're both in that and planned tactical operations, I think the chief needs to explain that a tactical operation can be, we're headed down to a liquor store because there's a robbery and everybody's headed down there, that's a tactical operation, as opposed to something that might happen in 3 or 4 hours, in which perhaps this would be, but drawing that line between those kinds of things happening and something that is, you have enough time to do it, just is very difficult in the field. And that's why those things we balked at.
One of the advantages of keeping going all the way through is that I'm too tired to fight.
Well, unfortunately, you're not alone. We have 2 more people who want to be heard on this section, and I'm certainly going to suggest that we go through that. The question I need some help with here from the council is whether we are going to keep going or whether we're going to quit when we finish this section. And if we quit when we finish this section, we are going to have to find another time to go back and do yet more of this. And the likeliest time is going to be tomorrow on the end of the council meeting, which means that we are looking at a very long council meeting tomorrow on-site during business hours. So what I need to know is, because we have 11 people here now. Mr. Fewer is supposed to be speaking at a meeting in, what time, 7:30? No, 7 o'clock. Ms. Weingart is leaving at 7, although we have lots of city attorneys here.
We're blessed.
Sorry?
Nothing.
And some of the rest of us have already checked out. We have been at this now, I have been sitting in this chair for almost 8.5 hours. So what do you want to do? You want to quit when we finish this item and go on tomorrow, or do you want to keep going? Okay. The consensus was we're going to keep going. That's, yes, right. And then, now, it is true, if Mike leaves to go to his meeting, that, Jackie, when you leave to go to the airport, we're done. What time are you leaving to go to the airport? The first thing to do is call the airport and find out. All right. Okay, I am now going to call on Mr. Padilla, since we are going through this item in any case. Go ahead. Yeah, hold on, Mrs. Walters.
Are you still on
We are on.
112? Are you
Yes,
going-
we're on.
You're still on 112?
We are on, I believe so.
Yes.
Yes, okay.
Yes, okay,
All right,
Mr.
great.
Padilla.
Thank you, Madam President. Just wanted to clarify, as I read the negotiating team's comments on item 112, it says the Department of Justice proposes to continue existing LAPD procedures. And so that's 99% of addressing this item. Difference here is they're offering certain enhancements that the negotiating team or the city's perspective, we do have concerns or issues with. These enhancements, more than any other of the DOJ's proposals in the document, I think begin to impact LAPD operations. And we've been saying throughout the course of the day that although we're willing to accept and agree to some oversight by Department of Justice or the monitor, what is unacceptable or inappropriate is their impact or involvement in day-to-day operations. And I think here we're more than walking into that gray line. So formally, I would move that we adopt the negotiating team's language, which I think the city attorney also agrees with. And in terms of any enhancements, leave it back in the negotiating team's proposal to work out with the Department of Justice.
I agree.
Okay, anybody need to say anything in response to that? No. Mr. Hernandez.
Some of these items seem to be very specific in regards to the oversight of the gang details. And the city attorney's recommendation was that we give them some direction and then try and delete certain sections because it is moving into the actual management of the department. That, from my perspective, how many off-site detainee areas do we have?
We're only referring to those detective divisions that are apart from the area station.
How many do we have?
What comes to mind is Hollenbeck and Rampart. I can't think of another one off the top of my
Right,
head.
and I mean, I kind of knew that answer, but, but I wasn't sure if everybody else knew it.
You could have saved me some embarrassment by just telling me, Councilman.
Well, and again, I worked hard to create the detective unit at Rampart, and then it came back to basically, in some degree, haunt me. So right now, the procedure is basically as newly adopted by a new policy, that it cannot be used except during business hours only when there's written consent from the manager in charge. Is that correct?
No, our current policy is business hours only with the permission, not written permission.
With the permission. And so then the manager would be aware and so forth.
Correct.
And so what happened before, for whatever reason, the manager was not aware or claimed not to be aware, and that might have been part of the problem.
Correct.
In terms of the radio frequency issue, that also kind of came back to us. If someone was to be using an unauthorized frequency at this time, a police officer, what's the penalty for that?
Well, it depends the circumstance. That could be very serious, it could be relatively minor.
Yeah, well, based on some of the details with some of the facts that have come out in regards to the Rampart scandal, those would be considered very serious.
Yeah, very serious, and unfortunately, just a smaller part of a very large package.
Right. Now, in pointing that out, members of the council, is because I think what the city attorney was asking is for some direction for the negotiating team. I think that we have a new policy in place that really we don't know how it works. And to be able to give that some appropriate time frame, I think is important, that be taken into consideration. And I would like to give instructions to the city attorney or to the negotiating team, I keep on saying city attorney, to try and negotiate the kind of wording that would allow for the review of this policy and how it's working. And that could include some of the other issues that we're dealing with in terms of audit stings and so forth, but to see how this policy actually is working in regards to oversight of the gang details. It shouldn't be the crutch or the basis of this whole agreement, but it's something that I think the Board of Inquiry addressed, as specific as it might be in that particular area, and that we should allow to see if it's a process that basically does provide the proper oversight in regards to the kind of activity we don't want to see happening.
Yeah, it went in place March 6, 2000, so it's not been in place for too awfully long.
Right, it just started.
Mrs. Walters.
On 112, my general opinion is that we ought to accept the DOJ language on all these where there's a question or no decision has been made, and move forward with that. I mean, these things just don't seem to be that big, that large of a bridge to cross. So that would be my concern. And you're not ready to go to 113 yet. When you get to 113, I have a question
Okay.
on that one.
All right. Are we,
Well, hold on.
well, we may be ready to go to 113. Are we done with 112?
There's a motion on the table for 112
And the motion was?
to adopt the negotiating team language and allow the team to work with the DOJ.
Oh, we like that. Does anybody have any objections to that?
Yeah, I'd like
Okay.
to move that we adopt the DOJ language.
All right.
Is there a second to that motion?
Okay, we have a straightforward split here.
112.
On 112,
I move DOJ language.
we have, I forgot now whose motion it was
There's two
initially.
motions, Padilla, Miskowski.
Okay, Padilla and Miskowski moved to go with the city attorney's, there are negotiating team's recommendation and send them back for further negotiation.
Negotiating team or the city attorney?
Negotiating team.
The negotiating team. And then there's a substitute motion by Ms. Walters, seconded by Ms. Goldberg, to go with the DOJ language. So the first motion will be whether to substitute, Ms. Walter, the DOJ language motion for the other one. So open the roll on whether to substitute. I'm sorry? I will do this again. The first motion that was made was Mr. Padilla and Ms. Miskowski, which was to go with the negotiating team's position and have them go back and keep talking. The substitute motion was Ms. Walters' motion, which you seconded, to go with the DOJ language. So the first vote will be on whether to substitute.
Substitute.
So this is, a yes vote is to substitute the DOJ language, and a no vote is to not substitute the DOJ language. So open the roll, close the roll, tabulate the vote.
4 ayes, 7 noes.
Okay, so that was not approved. So the motion to go with the city attorney recommendation or the negotiating team's recommendation and send them back for more discussion is now before us. Open the roll, close the roll, tabulate the vote.
9 ayes, 2 noes.
All right, that's approved. Yes, ma'am. Okay. All right. Ms. Chick was a no vote. That does not change on the motion to substitute. Yes, on the motion to substitute, that does not change the outcome. She did not want to substitute. All right. We are now up to
113,
113,
which is agreed.
which is, excuse me, what? Ron? Which is what?
114, Ron.
Well, 113, 114.
Okay.
114.
Now,
is
wait,
the
guys,
begin-
don't get out of hand here. We have a long way to go yet. This is 113 and 114. Mr. Deaton.
114 is the beginning of the discussions on confidential informants.
Okay.
114, 115, 116, and we get to 117, I think is there?
All right. I believe that Mrs. Walters had a concern about 113. Was that correct? All right,
Yes.
113.
Thank you. Again, this is the same kind of thing that was in the other paragraph. People with all this checkered past being allowed to work in the special enforcement units with justification by whomever hires them. How many of these misconduct activities are going to be allowed? And this specifies that they have been convicted of those things, disciplined for those things, and yet they're considered, and the person has to justify why they're considering them. How many of these, as you read through the litany, it says, supervisors shall be required to document in writing their consideration of any sustained misconduct investigation, adverse judicial finding, or discipline for use of excessive force, of false arrest, or charge, an improper search and seizure, sexual harassment, discrimination, or dishonesty in determining whether an officer shall be selected for the unit. Those aren't allegations. That says that there were findings that they had been involved in those things, had done those things. So how many of those things can they have before they're disqualified?
There is no number.
There is no limit.
I didn't say there's no limit, I said there is no number, you asked that.
There is no number. Well, there ought to be a limit. And one of the other things that I've learned in reading through some of the things that we settle and asking the people who present it, how many offenses prior to this or negative actions has this officer been involved in? And some of them, you just say they're real beauties. They've got one after another every year or so. They're doing something they shouldn't have had any business doing, and yet they're still on the force.
Well, again, that gets back to the discussion about the discipline system. But in this one, we felt that having to document why you put somebody in that unit with any kind of past history of misconduct put the pressure on the supervisor or the manager to have a real good reason, or else they were going to be responsible and they were going to suffer for it. That would accomplish what we wanted, rather than setting up an arbitrary rule, which may have been unfair in some way, depending on what the person did.
Well, it says they should document it. It doesn't say that they're going to suffer for it.
Well, that's part of, if you go read on in the personnel evaluation, supervisors are judged for their activities in the use of teams and the activities such as this also.
All right, thank you, Madam Chair.
All right, Mr. Pacheco. Oh, sorry, yes?
I'd like to just weigh in on a couple of items
Well,
briefly, and I mean
that
briefly.
okay with you?
because
She's the only other one up
Plane
there.
is
All
actually
right.
early.
Oh,
Plane is actually early.
boy, that in itself is worth noting. It wasn't
Yeah.
United Airlines, was
Yes,
it?
it is. It is United Airlines. And it'll be on the ground in 18 minutes. so-
You think, yeah, but then they have to get to the gate.
I know,
So
that's
don't
why
hold
I-
your breath.
but I do have
All right,
to-
go ahead, you go first.
I don't know whether or not you're going to take up all of the issues having to do with the consent decree and so forth, but I don't think that's the major issue. I am very concerned that we do something major about the mental illness section, and I do not agree that we should just eliminate 118, 119, 120, and 121 and substitute it with 122. So I hope that you'll have a discussion on what we need to do. I am concerned on 117 that we do preserve written notes and reports and notebooks, in my view, that you take to work are not personal property, and there are no jobs that I know of where your work products at your work are personal property. I don't think police are any different than anyone else, so I don't agree with that. And mostly, I really wanted to say that I think that wherever possible, in terms of the integrity audits, that we require a timely and independent outside looks at these audits periodically, not at all times, but periodically, so that people who argue consistently that somehow or another it's always the fox watching the hen house can be dissuaded from that thinking. And I don't know what the period ought to be, but there should be some periodic external
Okay.
review of the audits, even though I agree that most of the audits should be done internally, and I thank you for that personal privilege and for letting me cut the line. Goodbye.
Okay.
I'll see you all tomorrow.
Be sure to tell us what time the plane actually
I will.
reaches the gate.
I will.
We've all sat out there for half an hour at least. All right, Mr.
I will.
Pacheco, it is now your turn.
Oh, okay, let me preface this that I start off with complete ignorance on this issue, so these two questions are really based on when it comes down to subsection A, and it says that personnel in uniform assignments shall not maintain or use informants, I just have a real basic question in terms of what is the definition of an informant? Does this include civilian informants who work through Neighborhood Watch, or does this include, let's just say, a gang unit that develops a rapport with the citizen? Is there some sort of requirement that money be exchanged or favor for a person in dealing with an informant? And then the second question I have is on paragraph 16, is the centralized database of informants. Why would we not include those informants working with other agencies? Aren't the informants working with multi-agency task forces the worst problems? For example, the INS and the issue of the immigrants' rights that are being abused through those multi-agency task force. So if the database is good enough to have the informants that are utilized by LAPD, why wouldn't we include the ones that work or do double duty or double dip with other agencies? I don't understand, because those are the ones that are most problematic for my community. If you're telling me that an informant who works with the INS and the FBI is not part of this database because they also work with LAPD and those two other agencies, then you've left my community out of the picture in terms of being protected by informants who are problems. I mean, there's a reason we're tracking these informants. I can't believe we're tracking them because it makes us feel good. It's because we believe they may be a problem. So I have a question as to why would we not include the ones that are most threatening to my community in terms of those that work with the INS and the FBI in this database? So that's one of my questions also.
Okay, have we got an answer to that question?
Mr.
Chief.
Chaliff and I have agreed to split the answers. I'll
Okay.
go first, Councilman.
I do want to point out before you start that the rest of us all get paid for this, but Mr. Chaliff is here on his own time and has been here since 10 o'clock this morning. I think we all want to thank you. Go ahead.
As to the question about the definition of an informant, first of all, consideration is not an issue, although sometimes, as you know, an informant may receive money or an informant may receive a letter of consideration to district attorney when they're facing charges. But that's not the prerequisite for considering them an informant. The prerequisite for considering them informant is the ongoing or enduring nature of them providing information. We certainly have allowances for one-time receipt of information or using what we call sources of information. It would be that individual who, for whatever their motivation, continue or provides information over a continuing length of time.
So that would include the neighborhood watch captain or leader who continually gives us information as to what's going on in the neighborhood. They would be, I mean, with the way you define it, it sounds like it would include that citizen.
No, under our definition, the person who provides that general information, such as you've described, would not be an informant. It's the person who gives the specifics. And yes, if someone is giving us specifics about the who, what, when, where, and why on a particular intersection and does it again the following week and then another intersection the next week, yes, we would require an informant package on that individual.
Even if they belong to the neighborhood watch?
Yes.
Okay. And obviously the second question is about
The
those
answer-
informants.
Oh, wait, Mr. Chaliff wanted to
Yes.
split the answer to
The
that.
answer to the second question is the agreements that have been signed by the department and approved by the commission with some of these, with these other agencies do not allow for this kind of maintenance of records, and if they did, and we did that in violation of the agreement, we would no longer be part of these interagency task force.
Okay, now, are those agencies the two I'm most concerned about with my constituency, the FBI and the INS?
They have-
Or are you talking about the sheriffs? and
No, we're
the-
talking about all of them, and the FBI and the INS and others have federal regulations that they're responsible for.
I'm not aware of any joint task force with the INS. We're talking mostly about FBI.
Yeah.
Okay, but, so, in the reports where Latino immigrants were being abused at Rampart with the Rampart officer, then turning them over to the INS agents, that situation, there's no limitation because there's no current agreement with them, so we could include the INS. Well, you're telling me there's no multitask agency
Well, but that's
with
not,
INS.
those aren't informants, that's different.
Well, wait, there may not be any current informants, but all I'm asking is, since there's no current agreement that prohibits it, why wouldn't you include it so that I can report back to my constituency that we're protecting them from any misdeeds that may arise from the INS? I mean, I'm trying to be proactive here. I understand what you're saying, that
I think you've been actually very clear. You're quite articulate on this subject, and the question boils down to, can we include INS in this?
If we don't have any informants, I don't see how we include them.
Okay,
Wait
so
a minute, there are other provisions you can
that's the
provide relating to Special Order 40 and other things that could relate to INS, which we can adopt either as city policy or the commission can adopt. But in this, what we're talking about now relates to the use of informants and keeping records of who the informants are.
Yeah, but part of what we want to make sure here is that if we have an informant who says, so-and-so down the street is here illegally, that doesn't instantly result in, that's not the kind of informants we're looking for.
Ms. Calantra, I actually have a motion, if it makes it clear.
Okay.
The language right now says, the manual shall establish a permanent, centralized, confidential file listing of all LAPD informants, except those currently listed by the Anti-Terrorist Division, okay, and those used in conjunction with another agency. And I would move that, after it says, and those used in conjunction with another agency, except for the INS.
Okay, now is there a problem with that?
No.
City attorney? Anybody?
Since we don't use them, no.
Well, you don't use them today.
Okay, well, but,
that
no,
you can't-
but wait, but the key part, Nick, you jumped too soon. The key part was, he said, but therefore, no, there's not a problem with adding the INS. So I think you can hear Mr. Pacheco's motion as, say, except for the INS. Does anybody have a problem with that? Seeing none? There you go. Well, you'll ask DOJ. If they have a problem, they'll let us know, and then we have an issue.
Right.
Okay, Ms. Walters.
Well, that's right, that's one way of finding out who's doing what.
All right, don't fall apart yet, guys. We have a long way to go. Ms. Walters?
Yes, we just spent, paid out, I think, more than $2 million in a very famous case that involved an informant that apparently did not have the credibility that he purported to have. How do you select informants? And do you do anything by way of trying to verify their credibility or their credibility on the issue for which they purport to inform?
No one else responding, I will, Ms. Walters. I'm not quite sure how to respond to the word the characterization of select, because often they come to us as opposed.
Well, once they come to you, what do you do?
Then we have
verify their information or verify that they have some credibility, establish that they have some credibility.
I understand. We have a rather lengthy process where we do a background investigation by the officer who comes in contact with the informant, overseen by their supervisor, and the supervisor is then required to meet with the informant and go through an evaluation process that eventually makes it up to a manager, which would be a captain or above, who then authorizes the establishment of an informant package and the use of that informant. And then every contact, in effect, every contact we have with that informant goes into that package, and we're constantly evaluating that package to see if there should be a continued use of that informant.
Well, this one was over, or approximately 30 years ago, and the department denied and denied and denied, as well as the FBI, and it finally cost us a couple $1 million.
Well, but again, what we're trying to establish here is a monitoring program in which, between Teams 2 and the changes in administrative procedure, plus having the independent monitor, that we're going to know in way less than 30 years if there's a problem and be able to correct it.
Well, the monitoring process, as I understand it, is going to monitor the chain of decision-making within the department. The so-called informants will not be included in that monitoring process. The result of their information may be monitored as we look at the decisions that were made.
Well, no, that's true, but what will be monitored is the way the department uses informants and whether they do, as Chief Pomeroy has suggested, whether they investigate the credibility and whether they are using credible or uncredible informants and how they're using that information.
Will this also get to the issue that has been raised in Rampart, where people are coerced into providing the department information?
Okay, I can't answer that. Can any of you answer that?
Well, to the extent that that is prohibited by policy then and by policy now, it will. And it was misconduct then, it will remain misconduct. We now have a more stringent review of informants with this order.
All right, so that's probably the first issue, is that we do have a more stringent review, and
More
under this we will.
stringent, the informant was not the issue here. The action of the police in coercing a person to be an informant, to give certain specific information.
Understood. That was improper then, and it's improper now, and even more so now, by policy, they would be prohibited from having an informant, those officers that were engaged in that behavior back then. So I think it would even be more apparent to us if they did it. Although certainly they can hide misconduct.
Okay, let me call Mr. Hernandez.
Madam Chair, I just want to point out that apparently Special Order 4 was issued January 4th of the year 2000. So that was this year. And that's this package that's pretty much before us, and both parties have agreed to that particular package. It didn't exist 30 years ago. And it didn't exist as presented when the Rampart scandal was ongoing. And for some reason, Justice Department has agreed to the language of the oversight. In terms of these packages and updating of the packages of in regards to the use of an informant, would that be subject to the audit stinks?
Yeah. Yes. Yes.
Okay, so that we could try and make sure that that process is being reviewed properly and...
Not only the stings, it could be also subject to the OHB's audit of the gang unit.
Correct.
Which would, the use of adherence to policy and that in fact the file was kept up to date, et cetera.
And my last question is, if Special Order 40 was to be, 4 was to be proposed to be changed, would this consent decree allow that to happen?
With the...
Without their approval?
Not without DOJ's approval.
So that means that if it's part of the consent decree as adopted, it has to stay on the books unless all parties agree to change it.
Right, on the specific issues
Yes.
that are in the consent decree.
Thank you.
That's right. Okay. Anything further on 114,
15 and 16.
115, and 116? Not yet. 115 and 116, it says here both parties agree. Do we have any need to discuss those? In which case, we get to the next really big issue in 118.
Did we do 117?
We'll take it.
All right, okay. I'm sorry, we're back on 117. Ms. Walters. Well, I'm sorry, you're right. 117, I only picked up as far as 116. What happened on 117?
There's two parts to 117, and I think they should be thought about separately. One is the written notes and reports that are the property of LAPD, and the other issue is the requirement that officers who are uninvolved in the case be at the lineup. And I guess, from my point of view, that, as I understand lineups, they're mostly conducted by the sheriff, and I can think of an example if you thought of a rape victim who is the detective investigating that rape, who they've established a degree of trust, and they're working on the investigation together, and then she goes to the lineup and is confronted with a different police officer. It's not good for the victim. So I think that one in particular should come out, and we should not go with what DOJ suggested.
Just to reiterate, I think that for the most part, lineups are conducted by, as I understand it, by the Sheriff's Department, and but we do believe that our officers should be involved in that lineup. And the question of the notebooks, I think, would be best discussed by the city attorney, and the problems we have. The negotiating team doesn't have a problem with it, but it's been a long-standing problem.
Okay.
I would move the DOJ language on this.
Well,
You
the
should
only
hear
thing
from-
that's still really an issue is with respect to the notebooks, is that right?
Right, and I think you should hear from the city attorney
I
first.
think we should. So can we hear from somebody from the city attorney's office? Pull the mic up really close to you, so it...
Good evening, Mark Bergen, Los Angeles City Attorney's Office. The issue on the notebooks is there is personal information contained in those notebooks, and officers do consider notations within those books that contain the personal information their personal property. Other notations in the books that are LAPD records or records of our LAPD events, there's no problem there. So I think it's a drafting issue more than anything else. I think we can go with the DOJ language with a modification to exclude. Yeah, the concept's okay. We just need to work on some drafting to make sure we excise out that personal information.
Okay, but the question is, you've said that the officers consider those notebooks their personal property. Are they their personal property, or is that an issue that we have to resolve with the officers, or?
Yes, the information, some of the information contained in there is treated as their personal property, yes.
Okay, so, and we agree that some of the issue, some of the material that's in those notebooks is their personal property.
Correct.
But we don't agree that all of it is their personal property.
That is correct.
Okay.
This is a big issue for the PPL, and that they have apparently filed many grievances on in the past, and we're afraid that if we go with this language, that you're going to get a lot of grievances. The end result is going to be the PPL is going to recommend to their officers they buy their own notebooks, and nothing's going to change. So if we leave this in here, there's going to be an expectation that something's going to change, but nothing's really going to change. And so it seems to me that this one, at the end of the day, is not going to be all that important to DOJ, and we ought to be able to negotiate it out of the agreement.
Okay, now, Mr. Fuhr did not want to be
Madam
heard on
Chair.
this one. Hold on, I'm coming to you. Mr. Padilla is next. Are you on 117?
Yes.
Okay, go ahead.
Well, question is, before Councilmember Goldberg left, she mentioned in most other jobs, if you keep a notebook or some sort of paperwork that involves personal notes and notes related to your work, that it's considered property, public or in terms of your employer. So my question is more of a legal one. Is there any legal reasoning or justification that would support the negotiating team's suggestion on this, that private notebooks are private notebooks?
Wait, hey, Fred and Ron, you got to either pay attention to this or talk farther away. Say it again, Alex.
Question on this item 117 relative to the officers' notebooks. What legal argument or justification is there to help us argue that a private notebook, even though it has notes pertaining to your work, is a private notebook?
Well,
We're not arguing that.
There's a good argument that, I take it you're asking that the private notebook is actually the department's property? Is that the question? Is there some argument you can made?
Well, that's the concern the negotiating team expressed on this item when it comes to DOJ language.
No, the concern is twofold. The concern is the notebook itself, and then Kelly has raised the point that if the officers go and buy their own notebook, instead of our having bought them the notebook, nothing will change, but that they would have a more plausible argument as their private notebook. So the question is, what can we do here to get at the intent of the DOJ language? And Alex's question was, how do you say to DOJ, no, it's their private property, you can't have your language?
Well, I think the first question we ask back is, are the notations made on city time? That is important. Even with your private notebook, if it's done on city time, that is city business, and that becomes city property, at least in terms of the access by the police department to what has been written by that officer. So I don't think the purchase of the private notebook is dispositive.
Well, I wasn't asking about who purchased the notebook. I guess my question is, I see what the negotiating team wants to accomplish here, which is to limit, if not restrict, the use of the officer's private notes as it's written in 117. But to feel comfortable with directing the negotiating team to go and argue that position with DOJ, I want to make sure that we have some sort of legal justification behind that or legal reasoning.
Well, I think that, first of all, the question of property we're talking about now is one issue, and who owns what. But there's also the question of whether that information, even if it's written by the officer on his or her own time, on his or her own notebook, has nonetheless done some sort of recordation of the events of an arrest. That's evidence. And that bears upon the...
The question is the other way around. We all agree that the notations that have something to do with police work are evidence and are the city's property. The question is, do we have any basis to go back to the Justice Department, which says including these notebooks, and say, no, you can't include these notebooks?
Thank you. And I see Mr. Deaton is...
Well, and I had, up to this point, had the feeling that we had been stymied from doing exactly that.
Yeah.
If in fact, we believe that those notebooks or that information that was put down in those notebooks is city property, if it's done on city time, I'm willing to go with DOJ language.
The problem we face is when we talked about this amongst the negotiating team, the city attorney's office told us we had received grievances on the ability to get access to the notebooks. Mark, you were the one who told us this, and that we had lost this issue, and that's why we took the position we took.
Well, there's a way of dealing with that, which is to avoid the commingling. I mean, if you have an officer who has a private notebook who's commingling personal with the public, the answer is to that is you prohibit the commingling. You have the official and you have the unofficial, private.
Okay, you can prohibit it, but suppose somebody does it, can you still get your mitts on the notebook or not? And what DOJ is arguing and what people are asking you about is, well, actually, Alex was asking it the other way. Alex is saying, if we have to go back to DOJ and say, sorry, fellas, because of all these grievances, we can't put this in, that we can't agree, we can't consent to having this in a consent decree, how do we justify that? And what you're saying is we can't justify
I
it.
think the answer is is redaction. If you have personal information,
Yeah.
then you redact out the personal, but the public...
The rest, okay. Jerry?
Okay.
They do that now in the courts.
Okay.
Let's just say that we would agree to the DOJ language to the extent allowed by law. If we can do, it's city
Okay.
property, and it's not not messing up some investigation or
All right, so there's
some
two
problems.
issues then, to
Yeah.
the extent allowed by law, and if there's anything in our collective bargaining agreement that is an issue, then, well, there's nobody to listen to this. When somebody's ready to hear this.
Yes.
The other one is, if there's anything in our collective bargaining agreement, because they've been filing grievances, we can't change the collective bargaining agreement without,
I've been thinking like her.
Yes.
Language has just been pointed out to me that reads as follows. This is the DOJ language,
yes.
which shall include a requirement that all written notes and reports that are
That are the
the property of the LAPD and that were created as part of the investigation of the offenses charged be preserved.
Okay, but the key then is the word "that." It doesn't say all written notes and reports are the property. It says all written notes and reports that are the property shall be preserved.
And that
So
word,
that
yeah.
should cover all the concerns that have come up.
Well,
Thank you. No? Don't
I
make it harder.
understand, and maybe the city attorney, maybe I misunderstood the conversations the negotiating team had, but I understood that that the city had grievance procedures or some other form of procedures vis-à-vis members of the league that got into exactly the argument about whether or not they were the property of the LAPD, and we lost those. So to say to the extent they are the property, we all understand this is a null set. Is that correct?
No, it's not correct. It wasn't grievances. What would happen was when we try to get access to notebooks, the officers would object and assert it was their personal property. We'd then have to subpoena those notebooks, and there'd be redactions of that personal information.
So
That's what would happen.
So we could still do that.
Are we going to subpoena property? I mean, are we saying then that in leaving this language in here, we're going to be subpoenaing this?
No, all the language here, I really do think the word "that" is the key to this. We would be agreeing that all written notes and reports that happen to be the property of the LAPD and were created as part of the investigation must be preserved. And a requirement that lineups be conducted.
And in the past, when we had this discussion with the PPL, we had, in order to get access, we had to subpoena them. So now we're going to have a contractual agreement with the DOJ, which is going to say that we'll have procedures to preserve this evidence. And then are we going to create an affirmative burden and obligation ourselves to go subpoena it and get it? I think we need to sort of parse it
Okay.
a little better.
All right, well, but
How about this?
Mr.
The
Padilla,
risk
you
of playing
finished, then I have
semantics.
3 more people who want to be heard. Go ahead, so
If-
far.
ask the city negotiating team to try, not to require them, but to try to include with the Department of Justice approval words such as in accordance with city policies or consistent with existing MOUs with employee organizations or something along those lines, where we can balance the interest of the federal mandate in this consent decree and the policies that we need to exercise with the employee organizations.
If I may add, Councilmember, to the extent allowed by law, might be
That's
desirable here.
That's
If
fine,
we
but I
have
think
some
you get
problems.
our intent here.
Okay, we got it, to the extent allowed by law. Ms. Walters?
It seems to me that a bargaining agreement does not trump an existing law, a law of the state or a law of the federal government. The matter of notebooks, calendars, for example, are discoverable. And if they're discoverable, then this language here should not be a problem. Now, I don't know why you lost on that issue in the collective bargaining things, but that should not have an effect on this. I know that there's a case, I believe, on point that involved a major news outlet and some calendars of some elected officials. And the major news outlet, if I'm not mistaken, won the case or was settled or whatever, but the calendars were not considered personal property, and the issue of who purchased them never came up. So I think that that's thin ice and that we need to take the Department of Justice language here. I really object to, because a grievance, some grievances were filed and the city lost on the grievances, that should interfere with an agreement on DOJ, particularly when it's not the case.
Mr. Hernandez?
What if the officer doesn't have the notebook?
Probably not doing his job well.
Is he required to keep his notebooks
No,
as part of his job?
will be now.
The chief should answer that.
It will be.
Has to take notes on investigations.
It was a question, is the officer required to keep the notebooks now? The answer
Keep
is
them at
no.
home, I mean, after he uses them?
He may.
He may. So, like at my house, if I take some paperwork home, it ends up in the trash. My wife doesn't like me leaving things around.
You got that same problem, right?
I mean, it's kind of like automatic. I'm just asking the question because does the officer believe it's his personal property?
In my experience, yes, as does the officers' union.
And they could keep notes in other forms also, right?
Correct.
So shouldn't we have some form of defining what they can do and can't do with evidence? I mean, with these kinds of notes, maybe it has to be left at the station?
When it comes to evidence, we certainly have many rules and state laws regarding retention of evidence. And in fact, the requirements for evidence to be retained for a murder investigation will be slightly less than what we're about to impose for administrative investigations.
But it doesn't necessarily apply to these notebooks.
Correct.
And again, members, I'm just cautioning because I think we're opening up a whole different set of bailiwicks with this requirement, and I like the wording, whatever is required by law. I mean, I'm required to have losing thoroughbred tickets whenever I bet at Anita, only if I win, and that's a rare occasion, so most of the time those tickets get thrown away. I wouldn't understand why an officer would keep all the notebooks unless he was anticipating having to use them for court on an ongoing basis.
Maybe he writes poetry, you never know.
Yeah, no, and then that I would consider personal.
All right, we have two more people who want to be heard on this. Let me remind you, we're on notebooks now. The next item is the big one. And we've been here for a little over 9 hours, and we're beginning to show it. So I think that it would behoove us to try to move on if we could. Ms. Mizikowski, we're still on notebooks. Ms.
Right.
Mizikowski.
Members of the council, many of you may not remember, but this was a really big issue in the late 1970s. We used to have a division in the police department called the Public Disorder and Intelligence Division, PDID. There was an officer named Jay Paul and a number of others. They had personal notebooks. They actually had personal computers. They took home notes. They were notes about investigations of people. Jay Paul was fairly inventive back in the late 70s. He contacted all the militia-type groups and started conveying information back and forth with them. It was his private personal computer, but he had city notes on it. He intermingled other notes about other people. This was the group that was the so-called, spying group within LAPD. We lost a major case, lost millions of dollars over the issue of what was being done at home with those private notes. It was significantly problematic. So I believe that I like the intent of the Department of Justice here, as informed by current law, as informed by how we need to go with the League on MOU issues or meet and confer issues if necessary. But if officers are going to keep those notebooks, they are part of something that informs ongoing criminal investigation, and just in terms of our own ability to check into that, we can't let those freely go without some concern I think as we have reinforced here, that are the property of LAPD and that were created as part of the investigation. We need access to it, we need to be looking at it, and take care of the laws to redact out anything that shouldn't be in there. But what we were learning in the past is that this led to a major scandal within LAPD as to the kind of information that was being collected privately, shared by other officers, and in violation of a whole lot of civil liberties. So I think we've learned in the past, I think we're forgetting a little bit. We've got to go back to that point, take that with this language, again, within the context of law today, but go heavily towards the direction that DOJ is suggesting.
Mr. Padilla.
Thank you, Madam President. I think we actually had resolved that particular issue, but the emphasis was certainly in order. I wanted to, for the second time now, speak on the other issue, which is that of the lineups. It says in the notes that towards the end of negotiations, the city brought to the attention of DOJ that the Sheriff's Department conducts the lineups, and it doesn't say what the Department of Justice's response was to that. Were they open to that? Was that just something done at the last minute? Is that something already near closure?
They were listening. We didn't get a chance to wrap it up.
But do you feel they were open enough to
open.
it that we can entrust the negotiating team to bring that to closure?
Certainly.
And I see all the heads going like this, so that'll be my motion.
Okay, I don't think there's a dissent to that. So we're now going to jump to the big one.
Mental illness.
I'm sorry, there's a
Without objection.
There was a motion by Ms. Walters to move the DOJ language.
But I thought we resolved that by adding the phrase to the extent.
To the extent allowed by law.
Or allowed by law.
And,
Another approach could be required by law.
Right.
I'm sorry, say again.
To the extent required by law.
To the extent required by law, okay. Then I don't think we need a separate vote on that. I think we've agreed with the modification. Now, this is section 118 out of 182. Go right ahead.
118,
And just so we're clear, this is 118 through 122. Go ahead.
a couple things. One is the difficulty with this is the DOJ was suggesting that we make an audit of 5150 calls. First off, we don't believe that we can locate all the 5150 calls because of the way they were collected. There were no standardized approach to the compilation or the recording of those, so we don't think that would necessarily be a beneficial study. We have agreed that we would look at how we handle this problem and report back to the Board of Police Commissioners with any suggestions that we find. I think the team believes that DOJ had some ideas about how they thought that study should come out. We don't necessarily think that some of the approaches will work in Los Angeles, but we were willing to just say, do the study, and however it comes out is fine. If that requires us changing, we will do that change. If not, we want to stay where we are and let that study be where it is. I think they were not overly concerned about that. They seem to want an audit of what we're doing now, and I think that we were open to that, but we were not too enthusiastic about having it done in a year, because at the time you start looking at all the things that we have to get done in the next year, quite frankly, the cumulative effect is going to be very difficult to get done what we have already indicated we're going to do. So I think we're close to this, resolving this. I don't think it's as monumental as one might
As it
first
looks
take
like here?
As it looks like.
Okay. Mr. Fewer?
Thank you, Madam President. As one who's actually advocated the DOJ approach in a lot of cases, I think that the city's negotiating team proposal is more on track this time. First, I think that it's important for us to have real control over how we deal with this issue. And I think that the city's negotiating team approach gets us more closely to that point than does the DOJ approach. I also think, as I've said before in other contexts, that the role of the monitor contemplated by the DOJ here is really not consistent with what our vision here is, which is to report our progress rather than to be involved in directing what we do. Having said those things, and I'm basically prepared to support the negotiating team's proposal, I am given pause in that by the extent to which I know Ms. Mizakowski raised a motion on these issues a long time ago, right, Cindy? And I think it's been difficult in the context of everything else going on to get PD to really move forward with some specific ideas, and of course I'll let you speak to that, but my perception has been not a lot of progress in that area, notwithstanding the council's effort, your effort to elevate this as an importance in the city. And I want to be sure that if we adopt the city's negotiating team approach, that we really are assuring ourselves that we're going to have concrete proposals on the table before decision makers, and that this won't be allowed to simply lapse in light of other things that are also pressing the department. Does the team have any thoughts about that issue?
Well, I think that to not perform on a council suggestion vis-a-vis being in court and being in breach of a contract breach of a consent decree may have different impact on us.
Yeah, but the difference is, the language of the proposal from the negotiating team is really pretty mushy. It says that PD, based on analyses, shall recommend to the commission any appropriate policies or training that de-escalate this. And I guess, right before he exits, Chief Pomeroy, for 1/2 second before I let you wander off here. How can we toughen up this a little bit to assure that there really are proposals, an array of proposals coming from the police department for the police commission to evaluate? Because I thought it was great when Cindy introduced her motion on the training and so forth, and it has been disappointing to see a relatively small, if very nominal reaction from the department in response.
Get a bigger hammer, sir.
Well, that is essentially
And I
Ron's
don't mean that
point.
facetiously. I'm going along with what Mr. Deaton said.
Yeah, but may I say, I got that very candid answer is a problem. It does underscore the importance of the consent decree, but the whole point we're trying to convey to the Department of Justice is if you allow us to have fundamental control and you report on our progress, that we will have the horsepower behind reform to make it happen. The fact that we need the DOJ hammer, which was a very telling comment that you made here, I find disappointing. But I think that's underlying this whole discussion, that maybe that hammer is beneficial and not just a negative thing for us.
And I certainly don't want to weasel out of answering. I know the police commission's been more involved in this than I have, and maybe there's some information Mr. Chaliff would like to impart of what they've done.
And Dean Hansel's involved in a task force.
Yes, that's the task force. And also, without negotiating against ourselves, one of the things we could take back as a counter proposal is the fact that the commission will review the audits that are done and will make recommendations or findings relating to the treatment and then report it back to the city council.
I would move we amend the proposal to reflect that suggestion.
Okay.
I'm sorry.
Amend
The team's, the city's
the
proposal.
city's
to
proposal.
reflect
Got it.
further commission.
And then
Okay.
it should include the city council and the mayor.
I'm sorry, the city council?
Whatever recommendations the commission comes back with goes to the city council and the mayor.
Yes.
Yeah.
Okay, Mr. Wax.
Well, this has been, Mike, you've been one of the leaders of this, so I'm a little surprised to hear you take the position that you do. I remember the eloquent debates that we've had in this council not all that long ago to try to correct the failure to properly train officers as to how to deal with people with mental illness. And I think it stemmed from one particular incident that was a highly publicized incident, but it called this whole area into effect. And we promised to do something, and it's almost a year since that promise was made, and now we're worrying about, can we fulfill it in another year? What has happened since the time we passed the motion in council directing, I believe, the commission to do just this? And how do you do it without an audit? Now, I recognize, Ron, you say we may not be able to locate them all, we can't audit them all, but to the extent that we can, we should. How do you know where you have failed if you haven't really made the kind of analysis that an audit would give us? And then you can't make the analysis without the evaluation of other successful models. And then you need some kind of mechanism to see if what you do change and what you kindly come up with really is working, is effective. I mean, you could have all the good intentions in the world, but this is a difficult area. But the point of this is, I remember Ms. Chick, Mr. Fuhrer, Ms. Mostkowski, myself, and others, we had a lot of debate on this council chamber as to the need for us to evaluate what we're doing in this area, what others are doing, where we could be more effective, how we have to improve our policies and our training to deal with the recurrent problem of officers coming in contact with mentally ill persons. And it's almost like we're talking here as if this was a brand new issue and we're going to start it right here. And somehow I'm stunned that nothing has occurred between when we talked about it and where we're now sitting. Maybe, Mr. Chaliff, you could give us a report on just what the commission has done since the council passed its motion.
Commissioner Hansel is leading a task force which has about, and I'm sorry I didn't bring, well, maybe I did bring it with me, 4 or 5 subgroups dealing with all aspects of dealing with the, I don't have it here, the mentally ill and homeless from the point of how the department deals with them all the way up through how the court system deals with it so that there isn't the kind of problems that are being created now. And that task force has been ongoing for about 8 months. And I think Commander Papa is the department liaison, and there's people from every aspect of the mentally disabled community. And that I mean the healthcare providers, the groups that are providing support, representatives, all the different governmental agencies to try to deal with this, including training, practices, and policies.
And will audits be conducted as well? Are we going to have, is this a matter of no audits versus all,
Well, 2 things. One, they had talked about a specific audit on this, and also, which my main problem with that is timing, considering what else we're doing in rather large changes.
Okay, DOJ says auditing 5150 calls over 3 years. You say it's hard to locate them all and it's maybe too cumbersome.
I think that would be, I'm saying that part of it I don't think we can do.
But maybe you can take a sampling of them, a meaningful sampling of them. I mean, some kind of audit of what you have done is always a critical step in examining the effectiveness of your policies. I don't see why we can't at least look at a substantial and representative sampling of them as a part of this process of evaluation.
Councilman, that is my recommendation, as you see in the letter that I wrote to the council on this. I think that if we're only going to revise our policies based on comparison with what other people are doing without looking at our own experience, I just think we're making that decision in a vacuum.
Absolutely.
I would be willing to at least look at what the raw data looks like, see if we can get a representative sample. If that makes sense and we can proceed with that, I think we can work something out with the police department, and I'd be willing, I think that would...
I think you have to do that, or you're not going to have you're not going to get to the heart of the problem of what we've done wrong. I don't think you can ever get at what you're doing wrong unless you're willing to totally, honestly look at yourself and see what you've done.
But isn't what we're really trying to do, figure out what it is we've got available so that we can examine our own practices and see if we've done that?
Yeah,
and
and
really, I don't think they're disagreeing with you in the intent or the general premise that we want to examine our own practices. I think the disagreement is whether we can actually do what it is in the form the Justice
let
Department
me
asked
just
about.
conclude then. I don't mean to say you have to do them all like it says here, if that all is not practical or feasible, but there's a huge difference between all and not doing it at all. And I would like you to include in our reforms at least something, a representative amount that is meaningful, that is practical to do, and I just don't see why that can't be
Well,
done.
it's also, you can do it forward into the future better than you can do it into the...
That's probably true
very
as well.
and so,
But I'm...
Well, we're looking at Rampart as to what happened, not...
no, I know, I agree with that. I'm just saying that one of the things we
Same with
could
this.
set up is a way to keep track in the future as well, so that we don't lapse.
Absolutely on that.
It's a good point.
Okay.
We'll
Mr.
try to-
Hernandez.
Try to do both.
I know.
I think that in regards to item 118 through 121, we're looking at more than Rampart here. And part of what's bothersome to me is, I think we've identified an area that we had just recently previously identified as an area of deficiency. When we say we can't conduct an audit of 5150 calls over the last 3 years, it's because we weren't tracking them. We basically have been lacking a mechanism to deal with the fair evaluation of a policy in this area. And so now we're basically stating we're developing a policy, and we'd like to have the ability to do that. We're willing to consider what other departments are doing throughout the country. At the same time, Mr. Hahn is recommending that we also look at what we're doing as part of that evaluation. But we're conceding to the fact that we don't have a policy.
That's not, policy for what?
For dealing with mentally ill calls. We do have one.
We do have a policy.
And
We have
it's
a
in
number of
place.
policies, yes.
We just
have
don't track
policies
it.
in place,
We have policies, practices, and training. I think what Department of Justice wanted us to do was not only look at those, but audit some of the actual experiences.
So why can't we do that?
The problem with the 5150 calls, and I was just talking to Chief Pomeroy about it, and maybe there's a way to do it, is that there's no recordation of them now as that kind of a call. You have to go back and hand search each incident to see how they started. Some of them end up in arrests, some of them end up in no activity, some of them rest up in uses of force, and you'd have to start searching through those, and that could take a very long period
Well, I
of time.
remember we had the incident with an elderly Korean gentleman who didn't speak English.
That ended up in a use of force, I think. That we could track by going through and hand searching the use of force to see how it started. And we can do that.
Okay, and okay.
And then what
But we
happens?
just can't do it in the form of a call.
No, we can't do it by just saying we'll audit all 5150 calls, because we don't have a category that we could easily find those.
So we will be auditing what we currently have been doing.
We can, yes.
We can, but it has to be framed in a slightly
Right.
different way in
Right.
order for, see, the problem is that,
See, as I read the report, that's why I'm confused, because as I was reading the report kind of says we can't audit it because we weren't tracking it and we don't have a mechanism to do that.
but what it says is, if I'm understanding this correctly, we can't audit it in the form of, under the language that DOJ proposed, because we don't have a file somewhere that says 5150 calls. That doesn't mean we can't find information, it just means that we have to express in the consent agreement something, we have to express it differently so that both DOJ and we know what it is we're looking for and what it is we're reporting. So it's more language than it is
Well, then let me
intent.
get back to...
And it's going to be extremely
in my
difficult.
time. One of the things that's bothersome to me is the reason this is beyond the scope of the Rampart scandal is primarily because of some recent issues. And we have not really had adequate answers as to how those issues evolved. When I used the example of the elderly Korean gentleman that ended up in excessive force. Clearly, then, we didn't have a response. The recent shooting of a homeless woman, those are questions that are being asked. And that's why I think the Justice Department wanted us to review it. And to me, those are serious.
Well, I think what Ms. Galanter is saying and what we're saying is, we can get to some of that. We just can't say we just can't agree that we're going to audit all 5150 calls, because we can never do that. We could find some other language to say that.
Yeah, and I want to say
This is a question of the label versus the content. And we can't agree to the label because we can't do it under the label. But we could do it, and we're not objecting to doing it if we can have a different label for it that allows us to get at the same information.
That's basically the issue.
Yeah, but the other part I was hearing, and I was hearing it in the dialogue, for example, the example of get a bigger hammer, is how do you move it up?
Well,
I think it's been moved up.
it's been moved up and the commission's already dealing with it. But this adds impetus to the fact that we as a commissioner, or whoever the successor commissions are, we don't want to be held in contempt either. So if we agree to do this, we're going to do it.
Okay, now, there are no deadlines or timeframes attached to this.
We haven't done that yet, because we've
Okay,
been trying to find out something.
Madam Chair, if I could make a motion, I would ask that the negotiating team, in regards to this issue, adopt a timeframe for compliance, so that something can be brought back, that Justice can agree to, we can agree to, and be very much aware of.
On 122, we did say, within 6 months of the effective date, the PD shall conduct an in-depth evaluation of successful programs across the United States dealing with police contacts with persons who may be mentally ill. And within 1 year of the effective date, LAPD, based on its analysis required by the preceding paragraph, shall recommend to the Police Commission any appropriate policies, practices, or training that de-escalate the potential for violent encounters with mentally ill persons. LAPD shall audit implementation of any revised policies, practices, and training required by the preceding paragraph.
Okay.
And we can change that to the commission within
And then we would have-
that year.
So, okay, so Mike, does that cover what you had in mind? Okay, so we don't need a separate motion. Ms. Mizikowski?
I think the city attorney, basically, in their recommendation on this item, gets to that point, which says, don't deal with the specific language where we can't do what the DOJ wants us by way of their definition, but we're going to do it not just by looking outside, but also looking inside. The city attorney basically says that we audit our own practices. Now, it may not be that we audit 5150 calls, but we audit our own practices. And I dare say that what Commissioner Hansel has been working on for the last 8 months, in fact, incorporates that. So this is one we may have a whole jump start on, and have within 6 months of the effective date of this, that audit complete, and it may very well be, both internally and externally, and within 1 year, it come back not only to the commission, but I would add to the city. So that includes everything as we've otherwise defined the city, including the mayor and the city council, in terms of what these practices are. And the only other comment I would make is, I don't know that Mr. Deaton wants us to take to heart when we talked about what is the difference between a motion that we introduced a year ago to get this done and where we are today, and he said consent decree. We may be using consent decree on a whole lot of our motions in the future.
Yeah, but I have to initial them all. Okay, Ms. Chick.
Yes, well, I'm pleased that we've gotten, I think, an agreement about where this needs to go, but I still wanted to add a few comments on this subject. Colleagues, I think some of you, along with me, might remember that in our briefing with Chief Parks regarding the death of Margaret Mitchell, we learned that it had been a priority of the Wilshire Division for Bike Patrol officers to be, and maybe it was for other officers, but I remember specifically it was for Bike Patrol officers, to repossess stolen market baskets. Now, if there is something that needs to be reassessed and not wait for a consent decree, much less for an audit of our own practices, there's a glaring example. There's a glaring example of why we are all agreeing that we need the bigger stick, that we need the outside help. And I hope, I'm pleased that Commissioner Hansel is doing the work, but I'd feel better if it were coming from the department itself very proactively, having moved already to change some of their policies and practices. There was also a discussion I raised here and in my office with LAPD staff and mental health professionals, that many of the, in training on the FATS, the simulator that helps to train officers to make those very dangerous and difficult split-second decisions, that many of the scenarios with mentally ill persons show the mentally ill person as a very dangerous person with a hidden knife, with a gun, using force. And while officers do need to be careful and protect themselves, and sometimes mentally ill persons are dangerous and can become violent if not dealt with properly, that I question that these videos are putting officers in the place of automatically thinking that's what they should always expect with mentally ill. I put together a meeting in my office with professionals and experts from the county, the PET team, University of Southern California, UCLA, who are all offering pro bono their time to LAPD to help look at training, to make suggestions and recommendations. That was over a year ago. I don't even want to ask whether that was pursued and what has happened since, because at this point I'm going to rely on our agreement and the consent decree. Auditing ourselves, thank you, Mr. Hahn, and also, and we don't have to reinvent the wheel. There are experts out there around the country who are doing phenomenal things with law enforcement. Thank you.
Thank you. Ms. Walters.
I have a great deal of agreement with Ms. Chick, Ms. Misakowski, and Mr. Fuhr on this issue, and it's appalling that we do not have a plan, and that we're saying that we cannot audit this, that we cannot recapture the data that's here. I think that we must, and I think that we must come up with a plan in less time than we're talking about doing. The concept or the knowledge that there are mentally ill people out there with whom the department has to deal or is called upon to deal is not a new concept, and it's not a new experience. Margaret Mitchell was not a new experience. You've been up against that before. The naked man that you shot some years ago. There's been any number of unfortunate incidences, and it's time that LAPD have a policy of dealing with mentally ill people in a manner that is not the same as you would with a violent criminal, somebody that's got a gun on you. And that's the way that thing with Margaret Mitchell, this small old lady with a shopping cart and a screwdriver, and the guy shoots her down in cold blood. It's just unforgivable. It's just unforgivable. And this will not be, as far as I'm concerned, a complete consent decree unless it forthrightly steps up to the plate on this issue and indicates a willingness to change the pattern and practice of behavior in which we've been engaged in the past, and to do it in a time frame that is much shorter than is what is set forth here.
Okay, thank you. The screen is blank. What we have got to on this item, I think, is an agreement that we want, which I think is where you were headed anyway, that we want to demonstrate to DOJ that we are fully intending to address this issue, that with respect to the 5150 calls or auditing our past practices, past and present, that we will come up with a way to do that, but it'll have a slightly different label on it. And I think that closes the discussion on this issue.
Language that Mr. Chaliff had talked about in terms of getting concrete steps from commission to council to make.
Yes, and there was somebody, also suggested that you're going to come up with a time frame, a timetable that, or is that the same thing? Okay.
Okay.
All right. Now, it has been suggested to me that we jump around a little bit here in order to make as much progress as possible tonight and go to the issues relating to the monitor. Is that correct? All right. So where do you want to take us now? Which paragraph numbers?
That would be paragraph 165.
165. All right. So we have stopped it. We've gone through 122 and we're now jumping to 165. Section,
Hey, all the rest of that stuff's easy.
that can't be, that's it. All right, section 11.
Right. If you could turn to page 103.
Oh, all right, page 103. Okay.
Somehow in mine it's 102.
In the white notebook with the chart comparing them, it's page 103.
I think that the comments that the team has had is relative to the first one, which is that the purpose of the monitor would be included in the agreement. Some of this is in, but this is just clarification.
Some of it is in where?
In the DOJ proposal.
Okay.
But to clarify from our perspective, the purpose of the consultant is to monitor the compliance of the city with the agreement. 2, that DOJ, not the monitor, would have the ability to declare, go to the court to declare a breach if the cure provisions are not satisfied. That there is,
Yeah, you got to get the mic up.
okay, that the selection of the consultant, we have prior, we just would like to have a process that we work out with them, perhaps a different one that's in there, we're not sure exactly right now. Quite frankly, we did not discuss this, we needed to come back, I think there is
You
more.
did not discuss this with DOJ?
We gave them this list, but we didn't.
We have not had discussions. Okay.
And an aggregate money cap of some sort on the use of the consultant. We believe that they should have reasonable access to our documents. They shouldn't have access to privileged information, attorney-client. And last item, reasonable default, I think, which is included in Mr. Freer's motion.
Right.
With those provisions in there and giving us the ability to go negotiate, we think that'll do it.
All right, so what you basically want from us is an acknowledgement or direction to take these provisions and go sit down and have the talks with them.
Right.
Okay, Mr. Fewer.
And we should do. There were 2 elements of the motion I introduced last week that are relevant here. One is underscoring that the role of the monitor is one of reporting, not one of possessing any directive authority over the department. I think there's a consensus on that.
That is listed in here.
And the second piece is that which Mr. Dean just referred to, which is the opportunity to cure any defects in our procedures that the monitor identifies before any enforcement action is undertaken. We should leave it to the negotiating team to identify the period in which cure can take effect. And regarding the cap issue, I'm open to the amount of money associated with what that cap should be. But I think that we have now achieved a real consensus when it comes to reporting, not authority, cure, money, we're in business.
Okay.
Let us hope. Mr. Padilla.
Actually, I think Councilmember Fear summarized it pretty well, so I'll move the negotiating team's recommendation.
Okay, Mr. Wax.
I assume that's going to include then the mayor's recommendations regarding the role of the monitor. Yeah.
That's already in the motion and in this.
Well, as stated forth in the letter that he and Council President Ferraro and Councilman Padilla, I think that they enumerated more and would give the kind of assurances that have tended to divide the public unnecessarily as to exactly what may or may not take place, and I think that it should incorporate that. And the only other question, Madam Chair, is I know that we've skipped to this because we've been here 10 hours and I have a feeling we may be breaking soon. I want to make sure, I'm still prepared to stay, I want to make sure that the other items that we've skipped over will come back, because one of them is the role of community-based policing, which is something that I think desperately needs to be addressed in more detail than was addressed here. So I'll wait for those comments to when we get there, but I don't want to overlook community-based policing.
We're not going to overlook any of the sections we haven't discussed unless we decide to later on, but we'll have to make an affirmative decision if we're going to do that. Did you want to comment?
Well,
Three more people up here.
Yeah.
I will not resist it, I just may choose to ignore it. But the, what I would like to do is return to paragraph 1, because I think that...
Right now,
Right
before
now.
these 4 other people get to say what they
on the
wanted to say?
independent monitor?
No, we have 4 more on the independent monitor. Mr. Pacheco.
Yeah, Ruth, it's going to get a little testy in a moment. I can see that now.
No, I'm still holding the bat. Go ahead, Mr. Pacheco.
You're going to have to chase me down the hall in a minute, Ms. Galante.
I would just simply support the earlier comments about including the compromise language that was in the letter, but also wanted to make sure that the monitor, when reporting to the city or the parties, we also have that third entity called the public, and we somehow articulate how the public, through either a website, libraries, city clerk, something.
Also, when the independent monitor reports, it'll be reporting to the mayor and the council, which will become, with the Council of Brown Act issue, and will be
And therefore
available to
will
the
be public. Okay. Ms. Walters.
We're developing a consensus around this language, but is there any indication that DOJ will accept this language?
Yes.
Yes.
There is some indication of that.
I think so.
Well, we heard about 6 yeses, and then I think so.
Well, I'd like to let it be known now, should they not accept this language, I would request that you not spend more sleepless nights trying to get them to accept this language and come back to the council right away, because I, for one, am ready to accept the language language other than this that might be more acceptable to DOJ. And I would not like to see a lot of time wasted in trying to convince them that they should accept this language as opposed to our accepting language that they would formulate.
Well,
You
perhaps
don't
we
have to
could,
see sunrise, sunset in LA downtown at night?
perhaps,
Well, I do that anyway.
perhaps we could cross that
daily
bridge when we
basis.
come to it.
I think we'll be successful.
All right, Mr. Hernandez.
I'm kind of whacked here trying to figure out where I'm at.
You're not used to having people speak that short a time? Yeah.
I mean, I was confused when Mr. Wax brought up the issue of community policing. Is that part of this report, this consent decree?
Yes.
Okay. And then there was some other outstanding, I just want to get a clear understanding procedurally, because
Procedurally,
the big issue right now is the independent monitor's role. And I'm supportive of...
That's the section we're dealing with.
And I'm very supportive of that.
Okay.
Then what's going to happen from here?
First, we're going to finish this one. I have one more person after you.
Right.
Then we're going to go to, now I have 2. Mr. Chaliff,
No, I
hold
just
on.
have a request on where you go after this.
Okay, go ahead.
Is that if you're going to finish tonight, that you try to finish Inspector General and Police Commission, because I don't know if I can be here tomorrow.
All right.
Okay.
So let's try finishing this first. Then, now, but the question Mr. Wax asked, which I assume is what you're leading up to here, is what happens to all the stuff we didn't get to tonight? It comes back tomorrow.
Okay, that answers my question. Now I'm not so whacked.
Well, see, we've accomplished something tonight. All right, Mr. Padilla.
2 quick points. First of all, I want to say that I would not be open to accepting language any less than what I believe the negotiating team is going to be pushing for when we go back to DOJ. But second, paragraph 170, I know this is DOJ's language and not ours, and moving ours, but I would just want to call to our attention, it reads, "The monitor does not and is not intended to replace or take over the role and duties of the police commissioners and/or the inspector general." And I notice it does not include the chief of police in that sentence. So I want to bring that all to our attention, but once again reiterate what I would support, and the only language I would support is that what the negotiating team is putting forward.
Okay, let's point out that the chief of police reports to the police commissioners anyway, So if they're not usurping the authority of the police commissioners, that I think accomplishes. That's right, but they do not, the monitor does not take over the role or duties of the police commissioners, whose duty it is to oversee the chief in any case. Ms. Walters?
This drumbeat about what the monitor shall not do vis-à-vis the police department, whether they're a takeover. We don't espouse those concerns when we're trying to get money out of them. We keep saying, bring more money, give us more money, more. And we don't concern ourselves, we haven't concerned ourselves with the possibility of such a thing happening. We really have not seriously believed that it could happen. And this is a result of a lot of chickens coming home to roost. And I don't think we have too many options in the matter. So, on to tomorrow.
Well, now wait, let's just see. All right, I think we're now done with that section. Okay, you're going to go talk to DOJ.
Right.
You're going to let us know if we're at any kind of an impasse with them, and then we'll fight it out here. But we've had council members indicate that they would, and others that they would not support language different from the negotiating team position as articulated here. So right now, your instructions are take your position, go talk to DOJ, and let us know what happens.
Right.
Okay, now, you wanted to go one place, did you want to go to a different place? And I see Mr. Pacheco wants to go out the door.
But before he
The first council member who leaves breaks the quorum, so,
But before he leaves,
yes.
I would just like, because this was a contention with the Department of Justice, I would like to do 1 through 8, et cetera, and direct the negotiating team to work out the language, not necessarily the specific language in these paragraphs, that generally speaking that the agreement would follow this pattern.
All right, and so can we summarize that even more bluntly and say this is the issue of whether we are having a consent decree or something else?
That's correct.
Okay, so basically, 1 through 8, if we say yes, go ahead, we are agreeing to having a consent decree subject to all of these things that we've talked about, plus the sections we haven't gotten to yet.
Exactly.
Okay, now I got 4 people again. Mr. Padilla.
Yeah, Madam Chair, point of order. Mr. Shaliff has stated that he won't be able to be here tomorrow. And the only item where both parties did not agree under the police commission was item 151. And I just thought out of courtesy to him, because he's been here all day, I don't think it's a biggie. I think it's a question of making sure there's a report through the commission. But I just know he's not going to be here for 151.
All right, so did you want to...
I'd like us to consider 151 while he's here.
Well, is there something you want to say about it? Because I've got 4 people who want to be heard on the consent decree item.
Well, I just would like to hear Mr.
Pacheco, who needs to catch a plane.
Yeah, we could hear his position on that. Maybe Mr. Pacheco could hear it, and we could deal with it right away.
All right, let's actually, if that's all right, if that's agreeable with everybody else, Mr. Chaliff, why don't you give us your recommendation with respect to
The
151 and 152?
I don't know about 152. The 151, the only issue is whether this list prepared by the Inspector General for documents that he needs has to be given to the commission first.
And you want it given to the commission first,
At
or you
least I
don't
think
care?
the commission ought to know what's going on, and I don't know if there's any approval language in here, but we certainly should be aware of it, because if there's a dispute as to whether or not information should be supplied, we should be there to enforce
Right, and you are an integral part of it?
Right.
Okay.
And I think the city attorney has a slightly different position, but...
Yeah.
All right, well...
So do I.
Folks, do you think we can all remember Mr. Chaliff's position so that we can go back to doing items 1 through 8, and also we can let you go home?
Okay, no, I'm here.
Or you can sit here through the rest of it, however long it lasts, but let's then go back to items 1 through 8, and we'll, to the extent if we lose the quorum, we'll take this up tomorrow. If we don't lose the quorum, we'll take it up next. Okay, we're back on 1 through 8.
Let's consider that we've lost a quorum.
Well, we haven't lost a quorum yet. 1 through 8, come on, do it. What do you need us to do?
If there's no objection, that we would be instructed to negotiate in generally along the lines of the language that's in the document.
All right, now I have 4 people who've asked to speak, and I think I already called on somebody. So let me start by asking if there's an objection to those items. Mr. Padilla has an objection. All right, wait, in that case, I'm going to call you in the order that are on here, so just sit tight. There's 5 now. Ms. Chick. That's, oh, good, there's 1 down. Mr. Hernandez.
I'm down.
Mr. Wax.
And it will include the language in the mayor's, the recommendations in the mayor's letter?
And the president of the council.
Same letter, however.
Same letter.
Answer is yes. Okay. That's it? Mr. Fewer.
Always been the same place. Fine.
Mr. Padilla.
Thank you. Yes, I think it's important that if we're going to vote on the matter of whether or not to include this in the form of a consent decree, that we address the terms of the consent decree, and specifically the one that interests me more is the termination of the agreement. And so I would move to direct the negotiating team to negotiate for the term that ends the agreement to be a set period of 5 years, and the burden be put upon the Department of Justice to demonstrate that the city has not fully complied with the agreement.
That would be hard to do.
Fine.
Comments?
I have no problem with that.
All right. Anybody else have a problem with that? Okay.
Yes.
Yes, you're next. Ms. Walters.
I have a problem with that. I prefer DOJ's language.
With respect to the termination issue specifically.
With respect to the termination, with respect to what's in 1 to 8.
Okay. Mr. Ridley Thomas.
Madam President, I respectfully move continuance on the balance of the issues.
Well, can we settle this one?
Well, I think we've done a considerable amount of work. No one could deny that. And to the extent that we have, Madam President, I think we can pick up the balance when we reconvene.
Ms. Mizikowski.
Only on that last issue, I think we're in agreement other than the term, and if you look at 179, it deals about the term, and it basically says we can make a motion to dismiss it, DOJ shall have 90 days from receipt to file an objection, and I think what we're looking for is to instruct our team to come up with an arbitration acceptable to both parties as to how the termination. In other words, Mr. Padilla has said it must be incumbent on DOJ to prove it. Ms. Walters says no, the city must prove it. Let's let our team go back and negotiate how they accept that.
The DOJ has already indicated in informal conversations, the mayor had breakfast with Bill Lunley, that as described in the mayor's letter, they would be willing to accept that. So I think...
Willing to accept
that's
which?
underway. The notion that after 5 years, the agreement would terminate unless DOJ made a motion that said they thought that the city was not in substantial compliance.
Okay.
The city would then have the burden of proof to establish substantial compliance, but the DOJ would have to take an affirmative act
In order to require us to
Yeah.
do that. Okay, Mr. Padilla.
Well, I think
To reiterate, I've also shared that with Bill and Lee, myself, over the telephone, and they seem more than willing to accept. But again, I think the terms of the agreement are necessary to clarify before I can vote for putting this in the form of a consent decree. And I think with this letter, it's safe to assume that Council President Ferraro and the mayor stand by that as well.
Ms. Chick.
I'm comfortable letting the team go and negotiate and come back. But I do want to point out one thing. In several places, we are asking, and I think in this letter as well, we are asking for understanding and cooperation from DOJ in a flexible timeline, a realistic timeline. And I'm just wondering if we're kind of contradicting ourselves, that we want time to get teams 2 up, et cetera, and I'm not sure that that fits with a 5-year timeline. So what are we thinking in terms of the timeline we need to do many of these things that they're asking, including things like teams 2? What kind of timeline are we looking for?
Well, to have 2 years of successful operation, and it's going to take us 2 years to do teams 2, that's 4 years.
4 years from
The
sometime
effective date
in
of
the
adoption.
future, not
The
today.
effective date. So I think that we're realistically looking at a 4 to 5 year period of time before we would be able to demonstrate some of these things to be working. There's other issues, but just looking at teams 2 alone, to have 2 successful years, and that's assuming that everything else is working
Okay.
well.
Mr. Ridley Thomas.
Madam President, the appeal for flexibility The appeal for reasonableness can be read in a variety of ways. And I simply wish to register my sentiment in that regard. There is a clear indication that some have had substantial unreadiness about the Department of Justice's involvement in police reform in the city of Los Angeles, having been quite resistant to the issue of a consent decree in the first instance. I certainly would not be comfortable with language that continues to erode the strength of what this consent decree would ultimately accomplish. The letter that was submitted on this past Friday, I would hope can be taken in the best possible light, but insistence on these words that may be more euphemistic than anything cause me unreadiness. Once again, I move continuance on the balance of the issues before us.
On the balance of the issues, that's fine, but we have an issue that is before, that we're in the middle of.
Well,
And
may I
you also
suggest-
moving continuance on that?
The middle, the balance, the end, the rest, until we can then reconvene and take care of the items before us.
I'm sorry, Mr. Ridley Thomas, I apologize to you if I've been doing this now for a long time, 10 hours. I'm not clear whether you're moving that we continue the issue of whether this should be in the form of a consent decree as well as the other remaining issues. So just yes or no?
Yes.
Yes, okay. All right. Oh, goody, we can do it all again tomorrow. Mr. Pacheco?
See what I get for listening to you, Ron? My only point is very simple. If the term consent decree equates to a judge having independent authority to impose terms without the parties' participation or giving any sort of power to a judge to do that type of federal intervention, then I think the words consent decree undermine the direction that we're going in. I think that everyone agrees that we have basically a meeting of the minds of how we want to structure the independent monitor and what role the Department of Justice will play as an enforcer. And I believe that's the appropriate role in terms of if the Department of Justice finds us not moving rapidly in implementing, then they would take us to the court. But I think that this obsession of sticking to the words consent decree for some purpose that has no legal significance really undermines the meaning of the minds that we have developed today and over the last weekend with Council President Ferraro Padilla and the mayor. And the fact that the Department of Justice is willing to go along with that seems like a compromise that everyone should embrace instead of taking a step backwards and fixating on two words, consent decree. So I would simply move that we adopt Mr. Deaton's recommendation that we move 1 through 8 as he's requested.
Okay, but now the first motion that we have before us, and I still have 3 more people who want to be heard. The first motion that would be before us would be Mr. Ridley Thomas's motion to continue it. So sit tight. Ms. Walters, then Ms. Mizikowski, then Ms. Chick. Mrs. Walters.
Madam Chair, I keep hearing these, it's my understanding that by an act of the council, a unanimous vote, I believe, the people before us are the city's negotiating team. Am I correct? Yes, we did.
No, the president.
Council president just appointed.
All right, the council president appointed, that's within his authority. So you're still our negotiating team, is that correct?
Correct.
Then I have difficulty understanding all of these sides. Well, I talked with this and I talked with that and this is acceptable and that's acceptable. I think that's dysfunctional to us getting through this and getting to do it. And I think we need to recall that as council members, we have no authority as an individual. Our authority rests in the majority vote of the council. And I think we'll get through it better if we continue to recall that.
Ms. Mizikowski.
I think we did ask earlier, one member of our team, either individually or generally, do we have any indication that the DOJ would accept this? So we were informed by some of the information individually gotten. I stand by the recommendation that we move the issue as it was presented by Mr. Deaton and augmented by the letter of consent, which clarifies that issue, and which we did get information that DOJ would be willing to agree to, and I think that's what we should vote on.
Ms. Chick.
Well, I hope we're not all too tired to count, but I think that we should lay this over.
I'm afraid we're going to have to. I can count.
Right. Whatever the final outcome is, and it's been a long day, and you've done a remarkable job, by the way.
This, by the way, is not, thank you. This is not the record meeting I've chaired. I once did one that was either 12 or 14 hours, but I have no desire to
I'm
repeat
glad
that.
I wasn't there.
So,
But
yeah, you should be.
I think the late hour, the length of the debate, the real importance of this
All
last
right,
item.
so you're agreeing with Mr. Ridley Thomas that we should
Well,
continue it? Okay.
I'm counting as well.
Mr.
Yeah.
Hernandez. So are you, right?
Yeah, Madam Chair, I was also counting, but I also think it's important that we recognize that the last issues we have to resolve should require as many of the council members present as possible.
Well, let me just tell you that at tomorrow's meeting, we are expecting everybody except Mr. Pacheco, Ms. Walters, and we have, you will be here? Okay. Mr. Savornich is leaving at noon, and Ms. Chick is leaving at 11:45. And, okay, so we'll have almost everybody here. We lost a quorum. All right, we're out of session. I just want to thank all of you. Those who stayed till the bitter end, Ms.
Yeah,
Chick,
thank you all
Mr.
very
Fewer, Mr. Hernandez, Ms. Mizikowski, Mr. Padilla, Mr. Ridley Thomas, Mr. Wax, and Mrs. Walters. Thank you all. Thank you to our city attorney, our negotiating team, and once again, especially to Mr. Chalev, who really doesn't have to do this. We are adjourned.